with a new organization and I need to know about it. So, are y'all just here to watch, or y'all here with another media organization? Who?
Courthouse News Service.
All right. Okay. I don't think I have Rule 22s from y'all if y'all want to send one to me, but I've been letting everybody, if you're just here to observe and take notes, then you don't have to ask any permission. If you're trying to record something, you need to let me know. Okay.
Not recording yet, but we may be.
Okay. All right, just let us know, and if you need to tap into their feed, let y'all figure out how to do that. Good morning. As y'all are coming in, we're in a very precarious situation this morning. It's 50-something degrees, and the thermostat control in the building wants to turn the heat on, which is not enough. Option for this courtroom. So I already had to turn down the little sensor in the office because Tracy had it cranked all the way up. So anyway, well, I may have to turn my fan on earlier. All right, Mr. Fogus, go ahead and call your next witness.
Thank you, Your Honor. If it pleases the court, counsel in state calls Ted Wiley.
Discussions this morning, I think we are leaning toward not coming back Thursday afternoon, so we'll break at noon for the day. What I think there's some things the lawyers need to work on before that make sense as we go. So that's the current plan. I'll finalize that and let y'all know.
Mr. Wiley, you raise your right hand, please. Do you solemnly swear affirm the evidence you're about to present in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Go ahead and lower your hand. Good morning.
Morning.
You do not want to be here today, do you?
No, sir.
That's fair. We've subpoenaed you to come in from Alabama, is that right?
Yes, sir.
If you would, state your full name for the record and spell it for us.
Ted Wiley, TED, L, WYLIE.
Go ahead and scoot up and pull the microphone down towards you.
Yes, sir.
Mr. Wiley, I'm not trying to embarrass you or do anything, but you know why you're here today.
Yes, sir.
And you understand it's a murder case, and that's why we've asked you to be here.
Yes, sir.
Do you see Melanie Walker Farris in the courtroom today?
Yes, sir.
Would you point out, please? She's sitting over here in the black.
Yes,
That's black. How old are you today, sir?
60.
And when did you first meet the defendant?
It's probably been maybe 85,
And
86, something like that.
When did you meet Gary's sister, Sherry Farris?
Around that same time.
And how long were you and Sherry Farris in a relationship?
Probably 20 years.
During that time, did you meet the defendant?
Yes, sir.
Did y'all ride horses?
Move the. No, I'm not talking.
Okay.
Let's move the easel so the juror can see. Just back it up.
Yeah.
You'll need to pull it out.
All right, Mr. Wiley, you got a soft voice. If you speak in that microphone so we can hear you. So you met the defendant through Sherry Farris, is that how?
Yes, sir.
Did y'all ride horses together or things like that?
We have.
And where did y'all first meet? Was it in Georgia or was it somewhere else?
No, we would see each other at Christmas and birthdays and Thanksgiving and things at Sherry's mother's.
Now, again, I'm not trying to embarrass you, but at some point, did you have a romantic relationship with the defendant?
Yes, sir.
And when did that start?
I can't tell you the exact dates, but it was probably in 2008 or 10, somewhere in that range.
And when y'all would meet and come together, where would y'all meet?
But she's usually coming through town, either going to her friend Sheila's Hutchinson's home, or she would be going to visit her mom at the hospital.
And how long did this romantic affair go on?
Probably 3 or 4 years.
And during that time, do you know whether or not Gary knew about the relationship?
I don't think anyone actually knew about it ever until this happened.
And it was after this that it came out?
I think it did. Then they had were suspicious and things, but I don't think that they actually knew. They had no knowledge of it.
And to be clear, it was an intimate relationship more than just friends, is that right?
Yes, sir.
How many times do you think, how often would you see each other when y'all were together, you and the defendant?
We would see each other at that particular time. Before that time, we'd only see each other Christmas and Thanksgiving, but at that time, we might see each other twice a month.
Would y'all meet in motels, hotels, or somewhere else?
We did a time or two.
Would she come to your house and stay at all?
She did.
Was there a time when you remember that she separated from Gary and spent more time with you?
She did. She never stayed more than like a week or something like that. But we were snowed in one time, and her friend Sheila stayed with me. And so, anyway,
Was that Sheila or Sherry?
Sheila Hutchinson was her friend.
Were you ever confronted by anybody about the affair?
No, sir.
Gary never said anything to you?
He did not know. He had suspicion maybe at the end.
Now, you've heard us talk about the $50,000 loan or whatever you want to call it. Are you familiar with that idea?
I wasn't involved in that. I don't know about that.
What I want to ask you, though, is during the time, did the defendant write you checks for things?
She did help me with payroll once or twice.
And how much money during that time did she give you?
It was a few $1,000s to make payroll.
Would it be closer to $10,000 or closer to a few $1,000s?
It could have been 6,000 or 8,000, somewhere like that, to make payroll.
Okay. And that was in 2000, I believe 2009? Would that be right?
I'm thinking so.
Is it true, though, that she did write you several checks that were worth several $1,000s?
Yes, sir.
And you said it was for payroll. Tell us about that.
I have a building company. I had a building company at that time.
Did you ever use that money for anything with Kay Walker, her mother?
I'm sure I probably did.
And did you ever say it was for that, but it was for something else?
I don't think that I don't think that I did.
So, is it closer to 10,000 or closer to 15,000? What do you remember?
I'm sure it's closer to 10 than 15. I don't know that.
And she would write you personal checks for this?
She has. She has.
How many checks do you think she's given you in any shape or form? How many checks has she
Probably
written?
not more than 2 or 3.
Do you know if she ever had more money than that?
She told me that she did. I think it was maybe when she was handling her mother's affairs or something like that, if I remember correctly.
Did she tell you whether or not she took that out of the account that she and Gary had over the house or something?
I don't remember all that now. I don't remember that.
How much money do you remember her having independently from Gary when they separated?
I don't know about her finances and things.
How long was she separated that you know of where she was not with Gary during this time?
I think it might have been maybe a month. I don't know that for a fact.
You don't know exactly how long it was?
No, sir. Like I said, she would come into town and then she would go on to her friend Sheila's house or something along those lines, or go somewhere else.
And was she coming up, was it under the guise that she was there to visit her mother, help her mother, but she was seeing you?
Oh, she was helping her mother. Her and Sheila helped her mother get healed up. She had heart surgery and got her back, on the mend.
But she would come up and see you too?
Yes, sir.
And are you saying that the affair itself lasted for 3 years or more than 3 years?
I would say somewhere around the 3 to 4 year mark.
Closer to the 4, maybe?
Maybe so. I didn't keep up with that.
Did she ever tell you that Gary was, because of this, started to control the finances or do anything from the finances?
I think he did that all along.
Did she talk about how she did not have money except for what Gary would give her?
We didn't talk about money much.
She talked about leaving Gary at any time?
She did say he served her with divorce papers, or was serving her with divorce papers.
And you knew that was because of y'all's relationship?
I don't know that it was because of our relationship.
Did you ask?
I did not.
You kind of just let it be?
Mm-hmm.
Do you know whether or not that was followed through or anything?
I don't know.
Now, when did it end?
Probably I think it was 4 years before this happened.
This was in July of 2018, so y'all's relationship was over in about 4 years before?
Yes, sir.
So, 2018.
Well, I just didn't hear from her. I don't know that it was over. I just didn't hear from her anymore.
It just kind of dissipated?
Yes, sir.
So about 4 years before 2018, so sometime around 2014 is when your relationship with the defendant stopped?
I hadn't seen her or talked to her before that.
So since 2014, give or take, have you had any communication with the defendant?
I talked with her. She came into town one time after Gary passed.
And that's it?
Yes, sir.
So you understand one of the reasons I have you here is that your name was brought up in the investigation as a former, if you would, boyfriend of the defendant.
Yes.
And so I want to make sure I'm shrinking the world. I want to make sure the jury hears this from you,
yes,
and
sir.
they see you. In July, this is Riley 1. This is calendar July 2018. Tuesday, Wednesday, Thursday, the 3rd, 4th, and 5th. Can you positively look at this jury and tell them that in July of 2018, you didn't step a foot into the state of Georgia?
Yes, sir.
Did you have anything whatsoever to do with and I'm not saying you are, I just want to hear from you.
Mm-hmm.
You didn't have anything to do with what happened to Gary, or know anything about what happened to Gary?
No, sir.
You weren't even in the state?
No, sir. I was not.
Did you have any communication with the defendant or anybody in her family about what happened?
No, sir.
It's not till we contacted you, someone from the district attorney's office years ago, I think, reached out to you?
Well, I think I talked with Sherry about that. And that was about it.
So if this occurred, it did occur in July 2018. Gary was killed in July 2018.
Mm-hmm.
When was the last time you were physically, in any shape or form, in the state of Georgia?
It'd have to be 4 years before that.
Nothing else, John.
Streeter?
Mr. Wiley,
Yes, sir.
my name is John Luke Weaver, and I, along with Michael Ray, represent Melody.
Judge, I apologize. The juror just indicated to me that she couldn't hear me speaking microphone.
Speak up, speak up.
Yes, sir.
Again, my name is John Luke Weaver, and I represent Melody. Got a few questions for you on timeline. So you guys were together, you think, between 2007 and maybe 2010?
Something like that.
Something like that, because you said 14, but it'd be more like 2007 to 2010. Right?
Probably so.
Okay, all right. And the state mentioned something about some money that Melody loaned you $6,000 to $8,000, and you paid it back to her, right?
Yes, sir.
Okay. And I'm just going to ask you. I mean, y'all didn't really talk about Gary at all, did you?
No, sir.
And Gary never had any crosswords with you at all
Never.
about any of this.
Never.
And y'all didn't talk about it at all.
Never.
Any of her kids have any crosswords with you ever? Scott or Chris?
No, sir.
So really, you hadn't seen Melody since 2010. It's been about, 14 years?
Yes, sir. I'm guessing that's correct.
Somewhere in there?
Yes, sir.
And it just fizzled out?
We just went different ways, I guess.
Nothing, y'all didn't talk about Gary or anything to do with Gary?
No, sir.
Okay. If I may have a few moments, Judge. That's all there.
Redirect.
No, Your Honor.
All right, you can step down. Thank you, sir.
Judge may be released.
Go ahead. That's fine.
Okay.
Call your next witness.
Judge, we call Christine Lavoie. Stand up there, cross free, and you can see. You solemnly swear from the evidence you about to present in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Go ahead, have a seat, make yourself comfortable. Go ahead and tell us your full name, where do you work, and what do you do?
My name is Christine Lavoie, Christine Lavoie. I work for the Georgia Bureau of Investigation, Division of Forensic Science, and I'm a forensic DNA analyst.
Judge, you have the remote control for the TVs? You can turn those on, please, Your Honor. Yes, Your Honor. Ms. Lavoie, what is your expertise at the GBI?
So I perform DNA analysis on evidence.
And if you would, we've heard yesterday from Ms. Norris, but if you would, just when it comes to DNA analysis, how long have you been doing it?
About 9.5 years.
And what's your educational background?
I have a Bachelor of Science in Microbiology from Mississippi University for Women, and I also have a Master of Science with a concentration in Biochemistry from Mississippi State University.
Do you have to have a master's degree to work at the GBI to be a scientist as you are?
No.
But you have to have some type of bachelor's degree to work at the crime lab?
Correct, a bachelor's in life science.
And when you came on to the GBI, did you go through the hiring process to take an exam to get on and make sure you're qualified to do the job?
Yes.
Do you have to take continuing education through the year to make sure you keep up with the current trends in science in your expertise?
Yes.
Are you a member of any professional organizations or anything like that?
Yes, I'm a member of the Southwestern Association of Forensic Scientists and the Society of Molecular Biology and Evolution.
Among the people at the crime lab, where are you when it comes to how long you've been there and experience? Do you have more experience than other people, less experience? Where do you fall in that?
I'm considered a senior analyst.
And is that supervision or what makes you a senior analyst?
I hold the title of a crime lab scientist 3 senior.
Do you teach and train other people how to do their jobs?
Yes.
And do you do any outside teaching or education as part of your job?
Not outside, no.
Are you part of any kind of scientific groups or anything that works on the cutting edge or new technology or new science that comes out?
No.
Have you ever testified as an expert before in the courts in the state of Georgia?
Yes,
How many times have you been labeled an expert in DNA?
about 90 times.
And just this time, I tend to witness an expert in the science related to DNA.
Okay. All right. Witness deemed to be an expert, as I told you before, you can give an opinion testimony based upon her experience, all right?
All right, so we've gotten through the foundation. You did actually just a couple things, and we're going to have you look at some of the reports. I think you're covering some of others, if I remember correctly. Let's. Have you had an opportunity to go back and look at some of the reports in the case?
I've looked at my reports.
And I think you did. So we have two reports, GBI DOFS 7 and GBI DOFS 13. Are those your two, the ones which is a DNA typing? And, excuse me, GBI DOS 14, and then the DNA typing, the true allele. Those your reports?
Yes.
Just this time I tender GBI DOFS 7 and 14 into evidence.
All right, any objections? All right, they're admitted.
You have a copy of your reports with you?
I do.
All right, let's go through those quickly. We've stipulated the reports. That's why we don't have to go through all the regular procedures we do at trial. If you don't mind, let's just walk through these. Let's begin with 7. What type of services was requested in this?
It was a DNA typing.
And what was the date of the report?
March 6, 2019.
We'll be looking at GBI. We discussed yesterday as GBI item 6 and GBI item 31. I think we'll begin with those. So if you could, tell us the results and inclusion. Begin here with the sentence that says the DNA obtained from the cutting. Read that, if you would, for us.
The DNA obtained from the cutting contained the DNA profiles of at least 2 individuals.
All right, 6 was the T-shirt that we have in the case, and 31, that would just be a cutting from that T-shirt. Is that right?
Correct.
And when you begin DNA testing, how do you know how many individuals or profiles you find? How does that work? Just kind of briefly tell us how you can determine that.
So when you look at a DNA profile, you see what looks like peaks along a line. And if there's only one person present, you'll see no more than 2 peaks at each location that you test. When there's 2 individuals, you'll see no more than 4 peaks at each location.
Here we have 2 profiles, is that right?
At least 2, yes.
All right, now, when you looked at the shirt, the garnet shirt or the red shirt that the jury has seen, it came back to a matching somebody. Who did it match?
The major profile matched Melody Farris.
And what was that frequency, the statistical numbers?
It was 1 in 4 octillion.
And do you know how many zeros that is?
It would be a 4 with 27 zeros.
Now, at this point, when you were looking at it, down at the bottom of your report, it says it may be possible to draw conclusions on all contributors from the cutting recovered from item 6. So 6 is the T-shirt, item 31 is the cutting, utilizing True Allele casework software. What is True Allele?
So True Allele is a software program that we use to help us interpret mixtures.
And how is it, what is the basic, if I said in the beginning 10 years ago and we're doing DNA testing, what type of testing did we do 10 years ago? If I said the regular DNA testing, what is that, STR or?
STR, yes.
So that's just what everybody's been doing for years and years, so that would be the regular type of testing?
We still do STR. It was still done in this case.
Right. So your first test is kind of the regular DNA testing. What I need you to get across to the jury is, how is True Allele different? How is it more advanced or a different stage? How does it distinguish between just a DNA test?
So, like I said, True Allele is used for mixtures. In this case, the minor profile, I wasn't able to perform any comparisons because it was just so limited. True allele has a capability of, I'm going to use an analogy. If you think about an iceberg, you can see, a human can see the portion of the ice above the surface of the ocean. But we can't see what's below the ocean, below the surface of the ocean. True allele can look below the surface as well as above the surface. So it can see the whole mixture, if you will.
Is it a mathematical probability that uses a formula and software to compute things?
Yes.
Is it, I don't know if the term is more accurate or more detailed. How is true allele actually, how is it more capable of getting things that you cannot just find under regular DNA testing?
That's how the software is designed.
And what does it do when it comes to known and unknown? How is it objectively doing an analysis of the DNA?
So True allele will interpret the mixture first, and then it will perform comparisons to a reference sample.
Let's look at your report 14 here, GBI and DOFS 14. What is the requested service here?
It's True allele.
And what's the report date?
November 15th, 2023.
Now, for your second test that you did, you are still testing item 6, the T-shirt, and 31, the cutting from the T-shirt. Is that right?
Yes, specifically it's the electronic data that's previously been generated.
And what we asked, our office asked you to, once you notified us in your first report that maybe True allele could actually help us identify that other contributor, we asked you to test it further using True allele. Is that right?
Correct.
And we're trying to see who the other contributor is. When you tested under True allele, tell us what the results were as seen in your report here.
So the cutting, once again, contained a mixture of at least 2 individuals, and there was a match identified between the data from the cutting and Melody Farris, and a match between the data obtained and Melody Farris is approximately 500 septillion times more probable than a coincidental match to an unrelated person in the population. But due to limited data, True allele could not make a determination as to who the minor contributor was.
So for the True allele testing, it came back even stronger that it was the defendant's DNA?
So this is a likelihood ratio, whereas the other statistic was a frequency, but 500 septillion is less than 4 octillion.
So it produced a less number, but it still showed that it was those many zeros would be. Now proceed, John.
Go ahead.
Again, apologize, it's rules of evidence come up. All right, so the second test still confirmed, based on how many zeros you have, septillion, that the major contributor was Melody Farris. Is that right?
Correct.
And then you could not determine, even with True allele, who the second or minor contributor of DNA is on the shirt. Is that right?
That's correct.
Can you say that there was DNA of someone else?
Yes.
So is it accurate, scientifically speaking, that there are 2 DNAs that we found on the shirt, and one is not the defendant's,
Correct.
but you just can't determine who it is?
Correct.
Can you determine if it's a male or female?
No, it was so limited I couldn't even determine the sex.
only that it was not hers.
Correct.
Nothing further, Judge.
All right, were you right? Or across, sorry.
Good morning, Ms. LeWitt. My name is Michael Ray. I represent Ms. Farris. Just a few quick things for you. So just so I understand, you had a shirt, and that was item number 6, correct?
Correct.
Right. And then somebody at your office at the GBI, they cut a hole into that shirt and took a piece out, right? And that is item number 31.
Correct.
Right. And then there was originally a test done on that, and it found 2 DNA samples, correct?
Correct.
And then they sent it to you to see if you could separate them out to see who both the samples are.
Correct.
You found one to be Miss Farris.
Yes.
Okay. Are you aware that that is Miss Farris's T-shirt? And you may not know.
I don't recall.
Okay. If it was her T-shirt, would you be surprised to find somebody's DNA on their own clothing?
No.
Okay. Now, with the True Allele program, it's a computer program, correct?
Yes.
And it runs on, I believe it's called probabilistic genotyping.
Correct.
All right. And somehow, and we don't got to get into how, because I don't care, but somehow that separates out and you can determine 2 mixed together types of DNA.
Yes.
Somewhat. Okay. Now, the other DNA that you found, according to your report at the bottom, was due to limited data, no conclusive determination can be made. So does that mean that it's such a small amount of DNA you can't separate it out?
It's such a small amount, True Allele couldn't perform any comparisons.
Okay, so it couldn't do anything with it.
Correct.
Okay, and in fact, it can't determine what type of DNA it is, whether it's skin, sweat, blood, semen, anything like that.
So True Allele can't, but I do have an opinion, if I can express that.
No, I'm just asking about True Allele.
Okay.
True Allele
True
can't do
Allele
that.
cannot.
Okay. Okay. And that's all I have, Judge.
I have a question. All right. If a child gets their DNA from their parents, yes?
Yes.
All right, and so you have the chromosomes from one parent, chromosomes from the other parent. What if there's a mixture from the 2 parents and the child, and there are 3 combined DNAs? How can it parse that out and tell the difference between the child and the parents?
So there would still be differences in the DNA,
All right, how is that?
because the child only inherits 50% from each parent.
So the 2 other grandparents don't get passed down, or it gets combined and then doesn't get passed down.
There could be some similarities.
All right. Okay. I know enough just to be dangerous. That was really more for my information than anything else. All right.
Well, just one thing, just to follow up.
Go ahead.
With DNA typing, you can, well, to make it 2 ways, you can distinguish between parents and children.
Yes.
And the only way that you couldn't distinguish it if you had identical siblings.
Correct.
Okay. None.
All right. That's what I've been told. I don't. That's why I'm up here and not over there. All right. You can be excused.
Thank you.
All right. Go ahead, next witness.
Emily Bagwell.
I'll stand up and stretch. You're in the speed dating phase.
Hey, just go stand up there if you would, and I'll swear you in, then you can have a seat. Raise your right hand. Do you solemnly swear and affirm the evidence you're about to present in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead and have a seat. Say your full name for the record.
Emily Bagwell, Bagwell.
Ms. Bagwell, where do you work and what do you do?
I work at the Georgia Bureau of Investigation in the Division of Forensic Sciences, and I am the technical leader of the Firearm and Toolmark section.
So you deal with guns day in, day out, is that right?
Yes, sir.
Tell the jury, if you would, your educational background that qualifies you to do what you do.
I have an Associates of Science degree from Young Harris College, a Bachelor's of Biology degree from Kennesaw State University, and a Master's degree of Forensic Sciences from Stevenson University, which is in Baltimore, Maryland.
So how did you get interested in doing being a firearm scientist?
While I was a graduate student in Baltimore, I reached out to the local crime lab, the Maryland State Police Forensics Laboratory, and they had an opening for an intern in their Firearm and Toolmark section.
Did you grow up shooting firearms and things like that, or was it just kind of something else you got interested in?
No, sir, just a career path.
Are you someone that is a collector of guns or anything like that?
Maybe now I am.
Do you enjoy the science aspect of what you do?
Yes, sir, very much.
At the GBI, when guns come in, how many guns do you think y'all are testing a year?
Well, we pick up evidence from our evidence receiving section every day. If there's 1 gun or 15 guns, it would be difficult to quantify, but we do typically pick up evidence every day. There's always something for us that's firearms related to pick up. It's hard to quantify how many cases we're releasing every year, but we see quite a few.
And how long have you been doing this with the GBI?
Since December of 2015.
And how many firearm scientists does the GBI have?
We currently have 22 reporting analysts across the state.
Where are all they stationed at? Where are their offices?
We have 7 regional laboratories. 3 of those, well, in addition to headquarters, 3 of those perform firearms and toolmark services. So that's going to be our headquarters lab in Decatur, our western lab in Midland, which is close to Columbus, and our coastal lab in Pooler, which is close to Savannah.
And which office do you work out of?
I work at headquarters.
Does the GBI headquarters have a warehouse or something where they hold the firearms? How many firearms do y'all have in y'all's property now?
Well, there's a combination because we have evidence where firearms are evidence, and we also have an in-house reference collection. Both of those other laboratories in Columbus and Savannah also have their own reference collection. I don't know how many firearms we have in our reference collection, but where we store our reference collection of firearms is also one of our storage locations for evidence inside of our section, but additionally we have evidence storage in our evidence receiving section, as well as a long-term storage facility in our vault, basically downstairs in what we call the crypt at headquarters.
Is it a bunch?
It's a bunch.
How much do you think y'all got?
Just in the reference collection, we should have probably over 650 in the state. But that doesn't include any of the evidence that are all packaged in boxes that we'll eventually analyze.
If the jury could go to your office and see what you do, what's your office like?
Just my personal office?
Like where you test firearms and things like that?
So our laboratory, it's not like your conventional forensic testing laboratory, but it's still a forensic testing laboratory. The firearms section is on the 2nd floor at the headquarters building, and we have about, I would say, 3 wings where we have some offices where you don't share with someone. I do not share an office as the technical leader. Both of our managers have their own offices. Some of the senior examiners have their own offices, but a lot of people bunk up, and there are 2 people in an office just because we have a lot of people. We have 2 areas where we conduct our test firing. So we have a shooting range where we'll shoot shotguns for just kind of shooting shotguns. We do not collect projectiles from shotguns, so we kind of just shoot those into the air in the range and collect fired cartridge cases. Also in our range is a test firing capture system called the Cotton Box. That's for shooting high-powered firearms such as rifles. So they're shot in the range. Across the hall from the range is our tank room. It houses all of our reference ammunition, which is all across the walls. And then on the back wall of the tank room is a 600-gallon water tank. It's a large rectangular metal box with 600 gallons of water, and that's how we capture our handgun test-fired bullets.
Have you testified in the courts of the state of Georgia as an expert before?
I have
How many times have you been labeled an expert in firearm science?
87.
Just this time I tendered the witness as an expert related to firearm science.
All right. Again, she's been tendered as an expert witness.
All right, we've got that out of the way, so let's talk about the case. In this case, we've asked you to actually, you're going to be looking at, I believe, 2 reports. And I believe you did one of them, then Vanna Kelly did the other one. Is that right?
Yes, sir.
And by stipulation, we've agreed to these reports and the contents, and we've agreed that you can handle the questions relating to both of those. When you test guns, as in the testing that's done in this case, can you just kind of tell the jury what type of tests were done on a firearms and also the ammunition that is related to your report?
So more specifically, on the first report that was authored by Vanna Kelly, there weren't any firearms that were provided, but she received fired bullets. So when you submit evidence to the crime lab for firearms analysis, what that would include is a microscopic comparison of fired ammunition components. The purpose of it, the whole purpose of firearms identification, is to determine if fired ammunition components came from the same firearm, different firearms, if a firearm is submitted, if it came from that firearm, or if it didn't. So in this case, those ammunition components were compared to each other to make that determination. Were they fired from the same firearm? Did they possess characteristics that could allow us to inform our customer if there was a list of possible firearms they could be looking for in terms of an investigation? And then later we received additional evidence, a lot of additional evidence that I examined, a lot of fired bullets. At that point, we had reached an agreement with the customer. We wouldn't do any microscopic comparison because there were so many and they had sustained a lot of damage. We wanted to turn some results around quickly, so what we did was we looked at those characteristics that were shared between these fired bullets to determine if there was a list of possible firearms that could have fired them, and to answer a question if any of them were a specific caliber. There was also a firearm that was submitted at the time that I did do a visual examination of, but it didn't have any characteristics in agreement with anything prior submitted for Ms. Vanna Kelly's report or the evidence that I was going to examine during my analysis. We weren't doing any comparison on my part, so we did what we had agreed with the customer.
And what was the caliber that we were interested in this case?
38.
So 38 special, 38 caliber is what we were looking for, is that right?
38 special is a specific 38 caliber. There's also a 38 caliber called 357 Magnum, and then there are some other specific calibers within that caliber family as well, such as 38 Smith & Wesson and 9mm. But typically, when something looks like it's just 38, it's probably going to be 38 special or 38 or 357 Magnum. Apologies.
Now, when we're talking about revolvers, let's go from smaller to larger. 22 revolver, 32 revolver, 38 special revolver, 357, 44. Is that kind of how it goes?
Yes, sir. That's pretty accurate. The 38 special and the 357 Magnum are closely related. Anytime a firearm says it is 357 Magnum, it can also shoot 38 special. So the difference is going to be the length of the chamber. A 357 Magnum chamber is going to be a little bit longer, so it can accommodate a 38 special cartridge, which is a little shorter than a 357 Magnum. But in terms of like their barrel diameters, they're the same.
So the bigger caliber gun can shoot the smaller caliber bullet, but not vice versa.
In this case, because they have the same diameter, but like you mentioned with the 44, it's going to be much larger. It's not supposed to shoot something like a 38 class that's a lot smaller. But the 357 Magnum is a specific caliber of a 38, so it's just a little bit larger than a 38, but the diameter is the same. So the 38 special will fit in a 357 Magnum chamber, but the opposite is not true because the 357 is too long, too large for the 38.
And then when I say semi-automatic handguns, we talk about 380, 9mm, 40, 45. I guess there's a 10mm some people shoot, but those are usually the type of gun that you put a magazine in and rack. Is that right?
That's correct.
So first of all, I don't know how you do it, but if someone would ask you a pistol or firearms, to me, is it a long weapon, a long gun, or a handgun? Do you kind of do that? Do you
Yeah, those
break
are the
them
two.
up?
Yes, sir. Those are the two basic categories of firearms, are those that are short and intended to be fired with one hand, and those that are longer and are intended to be fired from the shoulder.
And when you get into the handguns or the pistols, do you break those down into two major, so the genus and species? Genus is the handguns and species, the different types. Do you break those down into revolvers versus semi-automatic?
Yeah, revolvers versus pistols.
And so when you say pistol, you're talking about semi-automatic usually?
Usually they're supposed to be semi-automatic, but with the world that we're in, they can be converted to fire fully auto.
All right, now, this time, Judge, I'm tendering to evidence GBI DOFS Report 12 and 13.
Okay.
Let's talk about one that's not your report, GBI DOFS 12, and this is going to be Vanna Kelly report. What was the service requested in this?
This was a firearms analysis service.
And what was the date of the report?
This report was issued on October 31st of 2019.
And we see Melody Scott and Gary Farris's names here, and then so it's from them involved in this Cherokee County case. Is that right?
Yes, sir.
Evidence. GBI item. Don't worry about all those other numbers. 2 and 5. Tell the jury what item 2 is and item 5.
Item 2 is a .38 caliber bullet that Vanna remarked as being removed from the basement floor. The package would have indicated that. And then item 5 is a .38 bullet jacket.
And when it comes to item 5, obviously here we're talking about the jacket that came from the medical examiner's office. Is that right?
Yes, sir.
All right, so the bullet from the floor, then the jacket, and the jury's heard about the bullet in the ribs and things like that. Do you know much about this case?
As the peer reviewer, all I know is how Ms. Kelly would have documented it, and she only documented the item 5 as being removed from the medical examiner's box.
All right. Can you give us the opinion for this report? Just read that to us.
Yes, sir. So under the results and conclusions, it states that microscopic examination and comparison of the bullet and bullet jacket, our items 2 and 5, reveal that they were fired from the same firearm based on agreement of class and individual characteristics. And they are consistent with being fired from FIE, Arminius, and Titan .38 special revolvers, and RG .38 special Derringers. The list provided of those manufacturers is only an investigative lead, and it is not intended to be an all-inclusive list.
All right, in plain English, what does that mean?
So these two ammunition components were projectile components. One was an intact bullet, the other one was a bullet jacket, which just means that the inside core of the bullet was not with the jacket. Those two items were fired from the same firearm, so one firearm. That firearm that they could have been fired from based on the characteristics the bullets possessed could be that list that she provided in her report, but it's not an all-inclusive list, meaning those characteristics between those two projectile items could have also been fired from different firearms not included in this list. We narrow our list based on what we most commonly see at the laboratory.
All right, so fired from the same firearm.
Yes, sir.
And then trying to figure out, based on science, it could be the same firearm, but it could be one of those brands.
Yes, one of those manufacturers may have manufactured the firearm that fired both of these items.
We don't see a 357 on that list. Is there a reason why?
I'm not sure. It could be that they did not populate in the database that she put her measurable bullet data in, but I don't know.
Okay. Could also be that it's just not one of the guns that it came back to.
Yes.
But we know from the science that the opinion is that it was fired. It's a .38 special, same gun. It could be one of those brands. Is that right?
Yes, sir.
Anything about the type of bullet, the brand of bullet, or anything like that?
Ms. Kelly documented that they were consistent with being manufactured by Hornady, which is an ammunition manufacturer.
And Hornady, now again, I really want to ask you if you hunt and things like that, but I'll try to forego that. Do you ever go to Walmart and just go over like I do and just look at all the bullets?
Yes, I do, because I want to stay on top of what new ammunition might be out on the market so I can share it with my team.
Do you ever go to other gun stores and just see all the expensive bullets they have?
Yes.
Now, are you familiar with brands of bullets that come out of Russia?
I am.
Well, what if I say give some common names of bullets, cheap bullets that come out of Russia or something like that? What comes to mind?
The first primary company is JSC Barnoul, which is manufactured in Russia and comes into the U.S. under the umbrella company Monarch.
Okay. How about some other brands that are not? You familiar with Remington?
Yes, sir.
How about there's some blue boxes out there? I'm trying to remember the name of the blue boxes. What are all the type of firearm or ammunition that you're familiar with that's not Hornady? Hornady's expensive ammunition, is it not?
It can be expensive, and half of their ammunition is geared towards law enforcement officers as well.
Okay. And so those are actually, let's put that on the far end, expensive, nice rounds that don't have a lot of powder and things like that. Good bullets. Coming back this way, what are some other brands that you're familiar with?
Specifically in blue boxes, we have PPU, Spear, CCI. As some other bullet manufacturers, we also have Federal, American Eagle, and Winchester, which are more affordable lines of ammunition.
American Eagle, that's a Federal brand?
Yes, sir.
What kind of box is that?
It should be white and red.
Do you mind standing up? Can you see that box right there in front of you on the table? If you can, I'll go pick it up. Let me go pick it up. Let me do that. It's kind of hard to. I don't have my glasses. So Scott, 201, familiar with that?
Yes, I am. It's okay.
I apologize. And Scott, 202, familiar with American Eagle?
Yes, I am.
That is not Hornady, is it?
No, it is not.
Totally different company?
Yes.
Totally different types of, separate, not connected at all, competition, in fact. Is that right?
As far as I know, yes, they're not related at all.
And Hornady, would you consider it a higher, I won't say quality, I'm not trying to diminish theirs, but a more expensive bullet that's commonly used for not just target shooting?
I would consider Hornady as a premium line of ammunition.
And Hornady has, in those bullets sometimes they have that, looks like, I call it wax, I'm sure it's not wax, but they put something in the hollow point so when on impact it won't cave, it'll still expand. What's that called?
That is a red polymer flex tip expanding red tip. And sometimes the color changes as well. They do have a pink tip for breast cancer awareness as well.
And that is put in the, if it's a jacket, if it's a hollow point, it's put in there to make it do what?
So the way that it's advertised by Hornady is, and specifically for a hollow point bullet, is different than a bullet that doesn't have, if a bullet just has a nice round nose and it's encased, that's going to be a full metal jacket. Unless the base of the bullet's also encased, then it's a total metal jacket. So the difference with the hollow point is at the center, the nose isn't complete. It has a cavity in the middle to help facilitate expansion. Hornady will put a polymer tip inside of this hollow point to help control that facilitated expansion as they advertise.
So if it's a Hornady brand, you can actually open the box up and see if it has that pink tip or red tip. Is that right?
That's correct.
Do you remember when they started doing that? How long ago?
I do not.
All right, let's get to your report. This is 13. What was requested here?
So the Cherokee County Sheriff's Office and someone from the District Attorney's Office requested a firearms analysis, and they provided all of the firearm ammunition that you're going to see in this exhibit. And we had agreed with the customer there was a good bit of ammunition, and they had wanted results a little bit quickly. And then the state of the ammunition was there were different degrees of damage. I believe they were recovered possibly from a tree. And so they had just, when bullets hit something, they can acquire damage. It makes comparison of them difficult. We agreed with the customer that instead of doing a comparison of these items, we would group like items together. We would document their manufactured characteristics. Those are the characteristics that help us determine a list of possible firearms that may have fired bullets. And then we would provide that list. And so basically what the report that was received said what caliber they were, if it could be determined, and then a possible list of firearms that may have fired them, but no comparisons were performed.
Now, ma'am, do you ever have to deal with ADAs that ask you to test lots of stuff?
Yes.
How about law enforcement that says, I need you to test all this stuff?
Yes.
Why does the GBI tell us no all the time?
It depends on the circumstances.
Y'all not going to test everything we want, right?
It depends on what questions you're trying to answer. In this specific case, I believe the conversation was, we just really want to know if these items are .38 caliber, and in doing that, with the level of damage these items had sustained that we could see from the packaging, it was once we had, taken a look at them, we're like, well, we can tell you what caliber they are, but they are really damaged. This could take a long time, and time was a factor. We needed results a little bit quicker.
Compromised.
We reached an agreement with the customer that we would provide them with a determined type weapon statement rather than a comparative analysis.
It's a very good answer under oath. I like that. Did you get hit with a lot of stuff? How much was it? Let me do this.
So,
this is your report, and there's all this stuff. Did you actually get more than this, but you only tested this?
This was, well, it's possible, but all I have listed under this service are what you see in your list that I would have actually looked at.
So these are the things that no matter how much you got, this is what you end up looking at. Is that right?
Yes, sir.
All right. So tell us what this is.
So this is an evidence list. It looks like there's a lot more, and there definitely is. I received 3 packages, and one of those is my item 33 and 34, and then 35. The first package was 6 357 Magnum cartridges. So a cartridge is a unit of unfired ammunition. So it hasn't been fired. I'm not going to do anything with it except inventory it. And then just skipping down to item 35, that's going to be a Smith & Wesson 357 Magnum revolver that I received, basically to see if the manufactured characteristics inside that revolver were consistent with the ammunition that Ms. Kelly looked at the year prior. And then that item 34 package contained several items inside of it that received their own little itemization, so that's why you see the 34A and the 34B. Those are going to be .223 caliber bullets, some 9mm bullets, some bullets and a bullet fragment for which I couldn't determine the caliber, and then some lead fragments as well.
Ma'am, you don't know who Rusty is, do you?
No, sir.
Okay. I didn't think you did. So you don't know where that item 35 came from?
The revolver, I do not know where that came from.
Do you know where the other items came from? Besides coming from the sheriff's office?
I have an item source indicated as what was written on their packages, but no, I do not know exactly where they came from.
But you did mention a tree or something like that.
It's possible.
You have a cartridge. Let me see if I can get the monikers correct. Cartridge casing is when you take a bullet out of a box, if you would, has not been fired. Is that what you're talking about?
The cartridge is what you're taking out of the ammunition box.
The cartridge is what you take out, so it's got everything: the primer, the gunpowder, the projectile, everything on it.
That's correct.
So if it's been fired and the casing's laying on the ground, what would you call that?
That's a cartridge case.
Okay. So, and then what I call a bullet, you call the tip that goes out, that leaves the casing itself and is projected down. That is the projectile?
I also call it a bullet,
All
yes.
right. So 34A through H, those are 223 bullets?
Yes, sir.
Did you, when it first came in, did you look and go, oh, this is a 223 bullet? You have to actually look under a microscope.
Both.
So you could recognize it?
I can recognize a 223 bullet, but yes, we do take measurements. We weigh it, and then we also look at its just other characteristics. It's just its design characteristics from manufacturer as well.
How different is a 223 and a 5.56?
So they're the same bullet. They're slightly different cartridges. The cartridge itself for a 5.56 by 45 millimeter has an extra grain of powder in it that makes it slightly more, I want to say stronger, faster. Basically, there's an interchangeability issue here. So if you have a firearm that would be chambered for a 5.56, you should only shoot 5.56 because of that extra grain of black powder, increasing that velocity a little bit. And making the chamber a little unsuitable for something that has a lower charge. And a 223 firearm, well, I apologize, I misspoke. The 5.56 can shoot that and the 223, but the 223 doesn't have that extra grain of black powder. Its chamber is not outfitted for all of that power, so it should only shoot 223 caliber. But the bullets are the same.
But that would be what we call an AR rifle.
Yes, they can be 223 and or 5.56 or both.
But for those that don't know guns, 223 bullet is not a handgun round per se.
No, so a 223 cartridge is intended to be fired from a rifle-type firearm.
All right. 9mm bullet. So it looks like 34I through 34M. That is a handgun bullet?
It is intended to be fired from like a pistol-style firearm, yes.
All right. In case people don't know firearms like you do, cowboy gun, revolver, semi-automatic gun is kind of like a Glock or what police carry or something like that. So 9mm, revolver gun, cowboy gun, or semi-automatic?
Traditionally, most commonly it's going to be fired from a pistol, semi-automatic firearm.
And that's the most common is a semi-automatic 9mm.
Yes, sir.
All right. 34N and O just says bullet. Tell us what's going on there.
So for 34N and O, they were, well, for two reasons. They were consistent with a 22 class projectile for which 223 is a family member of, but they were heavily damaged. And I couldn't determine their exact caliber just on their own, so I take each item regardless of what else has been submitted and ask that item, what are you telling me about yourself independent of all other items? So I didn't determine that it was exactly a 223, but it is consistent with the family for which 223 belongs.
Not a handgun.
Not in this case, no.
All right. And then 34P, bullet fragment. What's that?
That is so it's a copper jacketed bullet fragment, which means there was some lead there as well as the outer jacketing material, but it was only a very, very small piece, and it was unsuitable. I know we're going to get there, but it was also unsuitable, so not much I could tell you about it other than it was just a piece of a bullet.
And Q and R and S.
Those were just lead fragments. I have noted for all of them that they are possibly the core of a bullet.
Just go ahead and read your results and conclusion, then I'm going to ask you to put it in plain English.
Okay, so for the first one, the bullet fragment and lead fragments, items 34F, 34N through 34S, were not suitable for comparison purposes, meaning they possess nothing that I could use for microscopic comparison, had I even been doing that. The next conclusion states that microscopic examination of the bullets, items 34A through 34H, reveals that they are consistent with being fired from AR-15 style 223/556 by 45 millimeter firearms. Again, that's not an all-inclusive list. It's only meant to be an investigative lead. The third conclusion states that microscopic examination of the bullets, items 34I and 34K through 34M, reveals that they are consistent with being fired from Astra, Beretta, SIG Arms, Smith & Wesson, and Walther 9mm pistols. Again, not intended to be an all-inclusive list, just an investigative lead. And then finally, the fourth conclusion states that microscopic examination of the bullet, item 34J, reveals it is consistent with being fired from Glock, H&K, IMI, Bursa, and Car Arms 9mm pistols. Again, that's not an all-inclusive list. And then I do have one more conclusion at the end on the next page.
All right.
And that one states the microscopic examination of the bullets, items 34N and 34O, did not reveal characteristics that could be used to develop a list of possible firearms from which they were fired.
In plain English, can you tell us how that relates to any 38 special bullets or anything like that?
There was no evidence that was suitable, at least, to determine caliber that was consistent with 38 special caliber.
Just that's all the questions I have.
Good morning, Ms. Bagwell. My
Good
name is
morning.
Michael Ray.
Nice to meet you.
Nice to meet you. I just have a few questions for you. Let's see where to start. Do you have up there, and you may not, and tell me if you don't, the bullet comparison that Ms. Kelly did?
I do.
And I just want to ask you a couple questions about that. With the bullet that was found in the rib, it doesn't have any grain, or it only has, I believe, I'm sorry, I actually don't have a printout of it either because mine's a photograph. Under where it says caliber and weights, it doesn't have any weight, correct?
It did have recorded weight. Down lower on that page, she has an actual weight that she took of 28.8 grains. The top part of her documentation, where it says caliber and weight, would be where an examiner records the weight that it's consistent with being for a specific caliber if that determination is being made. There are a couple of weights available in 38 class, so unless it was close to one of those that was manufactured, it would not be provided. It would be like she documented, and it would be a dash.
Okay, so the actual weight of the bullet found in the rib, which is item number 5, is 28.8.
The actual weight is 28.8 grains, yes, sir.
And item number 2, the bullet found in the basement, was 110.
It was 110 grains, yes, sir.
Okay, so Miss Kelly, when she's doing her analysis, she's not able to tell that that is actually a 38. She's having to compare it to the other bullet found in the basement.
That's correct. She had determined it was 38 based on the manufacturer characteristics that were present, which she did document as being consistent with Hornady. In this particular case, she was asked to compare another caliber or another bullet item that was also consistent with Hornady. It was more intact, so it had a weight that was more consistent with the 38 class. So the reason why she would have intercompared them is because they didn't have any disagreement of the available characteristics that were there. So it was saying, basically, I'm consistent with the 38, I just don't have a weight to help support that, but it needed to be compared to the other 38 caliber projectile.
Okay, so basically she's just making the best guess that she can as to what it is, and the manufacturer based on everything that she knows.
So the manufacturer, she would have resources available. We have our reference ammunition collection as well as the standard ammunition file at the lab. So if something does look like, and we are trained in ammunition as well, so if something looks like it's Hornady, she can double check that with all of our resources. So that would be documented, the weight would be recorded, and if it looks like it's a 38 class, then she could document that it appears to be a 38 class, but it wouldn't preclude her from comparing to another 38 class that she had more available to determine its caliber.
Okay, and with the going to the Hornady bullets, I'm going to show you a photograph. You've probably not seen it, but it's already been admitted into evidence, okay? And you just tell me if this is, that's large. This is how, when y'all see, when you look at a, well, let me ask you this first. When you look at a bullet, when you're doing your job, you're like, that's a Hornady bullet.
Yes.
Yes, okay. Because this ain't my first Hornady rodeo murder trial. And what you look at is you're like, oh, it has that red polymer tip on it, right?
That's one of the features. They also have about 2/3 of the way up that flat surface called the bearing surface. They have what's called a knurled cannular. Other ammunition manufacturers also have it, but the knurled cannular, in addition to hopefully the red polymer tip, but also the structure of those petals in the hollow point, is something that we recognize as being Hornady manufactured.
Okay. And that kernel that you were talking about, is that right here?
Yes, sir.
Okay. And the petals. Let me approach. I don't know if you've seen it or not. This states GBI ME28. You can, you can look in there. Is that where you see it flared out? Is that the petals you're talking about?
Yes, sir.
Okay. Now, you can just switch over to the elbow. No, it's fine. I can see it. No, I gotta get gloves on. The whole big thing. Oh, I'm sorry. I didn't do my part, Judge. I'm sorry. It's coming, I think. Yeah, it's on. While that's loading up, I'll ask you another question. There we go. All right, so like you can
You just set it down and then
set it down and zoom in. Wrong way. So basically, those little things that are poking out, that's the petals that you had just talked about?
Yes, and they have been peeled up So the previous photo that you showed is a hollow point, kind of what it looks like when it's hit a target. So the petals that are arranged around the nose have little cuts in them, we just call them slits, and so that's what helps those open up kind of like a flower or a mushroom. So those had been kind of peeled back and were obscuring the bearing surface. So Miss Kelly would have peeled them up so she would have more bearing surface available for comparison.
Okay.
So what you're seeing are they're peeled back up.
Okay, so Miss Kelly would have done that.
Yes.
Okay, so she would have peeled it back up. And actually, is it with Hornaday, and Judge, you can switch back to the TV, please. With Hornaday is because when you look at it closely, you can see that those petals are kind of jagged.
They kind of have like, where they're cut, they have a small interior cut as well before the slit. So, and it's not just Hornady. Other manufacturers have the same kind of petal design, but we've just come to recognize Hornady as having a basic, like a triangle with a flat top and then smaller pieces on the sides.
Okay. How long have you been doing firearm stuff?
Since 2015.
Okay. Do you ever have any bullets that you send off to have textile examination done from a bullet?
No, sir. As far as I know, some of our bullets are swabbed for blood analysis, but not for textile chemistry.
Because there is a report that the GBI had done that's already been admitted into evidence, and I believe that is the GBI number 3, that they did an analysis of the bullet from the basement, stating that there weren't any textiles or any characteristics like that on the bullet.
Then I have learned something new today about some of our services. Yes, that would be a section that's not firearms. So if other sections can look at something for a materials type of service, I don't know who would have done this report, but I guess that's something that they are capable of doing.
This person.
Yes. So I was going to state too that our materials analysts are some of our trace evidence analysts that work on the teeny tiny particles of evidence called trace materials, and Tatiana was one of our trace examiners. So.
And it would make sense if somebody was shot and it went through clothing and potentially even exited through clothing, that you could pick up textiles on it. Okay?
Yes, and now that you mention it, I believe I just misunderstood the question initially, because we did have something recently where Trace asked us to come over and look and see if they could do a general materials on it, so I just seemed to have forgotten that.
Okay, well, I'm glad I brought it back to you.
Thank you.
Well, unfortunately, now you got something else that you have to do at work. Okay. Now, you had mentioned that these Hornaday bullets that, with Mr. Fogus, that these are premium brand bullets.
I would consider it a premium line of ammunition.
And a lot of times you can tell like what's premium and what's not premium by the casing of whether or not it's like the brass or it's nickel and things like that.
It's more commonly for us going to be the design of the bullet itself and independent of the cartridge case and what material it's made of.
And in states number GBI number 13, all of those different bullets that you had looked at, were you aware that those came from like a target area at a piece of property?
No, I wasn't really aware of exactly where they came from.
Were you more curious as to why you were getting a whole bag of bullets?
It was a question that I had asked, yes.
And anything that Mr. Fogus had asked you about, this 357 here, you don't know anything about it, and there was no testing done on it to your knowledge?
All I did was a visual examination of it. I didn't do any comparison on my report, and then I did inform the customer that it did have a different rifling structure, so a different manufacturing characteristics than the bullets that Miss Kelly had previously examined.
Yeah, and I'll come back to that. But so that's a Smith & Wesson 357.
It is.
Right? Okay. And well, hold on a minute before we do that. So of all the bullets and everything and the fragments that you looked up here, you didn't see any Hornaday bullets at the target range? At least that you noted in your report.
In my report, we don't note ammunition manufacturer, so that information would be in my bench notes, and I believe just purely based on the level of damage everything sustained, I was not able to determine probable manufacturers for any of the items that I received.
Okay, that's fine. And in your training and experience with Hornaday being a premium brand, that's not a target shooting brand, right?
Not traditionally, no.
Okay. And in fact, I believe you have stated that brand is geared toward law enforcement.
Some lines, but some lines are specific for civilians as well.
Okay. So, in this report, you would notice there was a Smith & Wesson that somebody had sent you, we don't know whose it is yet.
Right.
All right, and then in your other report, or not your report, Ms. Kelly's report, that she had believed that it was a FIE, Arminus, Titan, those types of guns.
That's correct.
And that's because of the twist, I believe, those type of guns have an 8-right twist.
The guns in the list that Ms. Kelly provided, those specifically came up in the database because they have 8 lays and grooves that turn to the right. And she also measured them as well because they have specified widths at manufacturer. So if we know those widths, we can see those measurements come back in the list of manufacturers that are provided. And then the Smith & Wesson that was submitted, that revolver had 5 lands and grooves.
Okay. And with, because Mr. Fogus had asked you about that 357 Magnum is not listed in this group. And you don't have a reason as to why that is not, right?
I do not.
Okay, because a 357 can shoot a 38,
It can.
right? Now, but a 38 can't shoot a 357.
It should not.
Okay. Okay, that's what I thought. And this listing of firearms is not all inclusive.
Correct.
And to the best of your knowledge, does FIE, Arminus, and Titan, we'll just use those because they're on the report, do they make a 357?
I really can't recall that off the top of my head.
Okay. And with the, what is RG 38 Special Derringers? Can you explain what that is?
Yes. So RG is just another firearm manufacturer, and the 38 Special Derringer is the same caliber, 38 Special, except the firearm type is a little bit different. People tend to classify a Derringer as a type of revolver. Others tend to classify as a type of pistol. Really, the definition for it is just a very small gun designed to shoot 2 cartridges. It's like a pocket gun. It's very small, should fit in the palm of your hand, and typically it has 1 to 2 chambers. Sometimes it can have up to 4.
Okay, and that's a Derringer.
Yes.
But it's not a revolver.
It's not a revolver because it doesn't have a cylinder that rotates. A revolver has a cylinder that rotates, and a Derringer does not have a cylinder that rotates.
Okay. And no further questions. Thank you.
I'm just going to make it 12.1. Judge, I'm going to tender now by agreement GBI DOFS 12.1. It goes with the report 12. So I'm going to tender that into evidence.
All right.
Nope. Thank you. Ma'am, I probably caused this computer to crash, so let's see if I can. No objection. Publish it. No. We were talking about the bullet worksheet. Oh my goodness, I can't see that.
Ooh.
Let me just break it down a little bit. And this is Miss Kelly's. What is this? Do y'all have these when y'all you take notes and type some stuff up? Is that what you do?
Yes, this is a part of our bench notes. So anytime we have projectile evidence, we put it on our bullet worksheet.
And then when we were going through this, I think, so what we're looking at here is GBI item 2 and GBI item 5, is that right?
Yes, sir.
And 2 is the projectile from the basement floor and 5 is from the autopsy. So 2 is from the floor, and then it says right there, ME box labeled UID.
Yes, sir.
All right, tell us what this caliber and weights and grains, what are we talking about here?
I'm sorry, can you repeat that?
The caliber and weight, we have, what does this line mean?
That line is actually, it's pretty high up on the list because that's one of the first things you want your peer reviewer to see, but you don't fill that one in right from the get-go. You've done some analysis further down on the worksheet first, so that whole line that says caliber and weight in grains is what you have determined the caliber to be based on the available characteristics, and then the weight that it's most consistent with being within that caliber family.
And I think maybe early on there's a question whether or not this was a 380 bullet. Do you know anything about that?
I don't know anything about that.
But ultimately, the final opinion was this is a 38 special. There's two bullets, obviously, but one is they both come back to 38 Hornady type bullets. Is that right?
Yes, 38 class Hornady type bullets.
And did you know that the GBI item 5 that was involved in a burning or a fire?
I did not.
Okay, so you don't know the source of that or where it's from or anything?
As Miss Kelly's peer reviewer, all I saw was the documentation that said UID, so we didn't even have, at that time during her analysis, an identity for that individual.
But as you said earlier, sometimes you get bullets and they're deformed or messed up, and that could be from the conditions of where it was.
Yes.
All right, then what else do we have on here? Probable manufacturer. So you got item 2 and 5. What are we talking about here?
That would be who it's consistent with based on its design characteristics. So for the first column where it says Hornady with a red polymer tip and a knurled cannula is kind of what I described in the photographs that were shown. It's consistent with Hornady based on those features. And then the other column, it says it's consistent with Hornady, but she only remarked one knurled cannula. It had to be similar to the other items, knurled cannula and appearance, because it wasn't basically saying I'm different. It's saying I'm similar. I could be Hornady as well.
And I always want to say lanes, like a bowling lane and grooves, but it's lands and grooves and twists. What is that?
So when a barrel is manufactured by a fire manufacturer, what is cut into the barrel are actually grooves, and they are cut into a spiral pattern. So as the bullet passes down the barrel, it imparts spin on the bullet to help improve the bullet's accuracy upon leaving the barrel. When the grooves are cut into the barrel, they leave the grooves, but the spaces between the grooves are the lands. And when the bullet passes down the barrel, it picks up impressions from the grooves and impressions from the lands.
And then damage for item 2, which is from the basement, item 5, which is from the ND. It is noted some damage to item 5, is that right?
Yes.
Let's see. And then again, the match goes up to the 38 special Hornady bullet. And that's item 2, item 5, both of those are Hornady brand, is that right?
Well, item 2 she determined is Hornady brand, and then item 5 she said it's consistent with Hornady, not to exclude other manufacturers, but it's more consistent with Hornady, or else she would not have documented it that way.
Right, and Mr. Ray said that it was a guess, and I think I know what he's saying about that, but y'all don't guess at your job, do you?
No, we use what's available to make us, what we have available in data to provide us with conclusions. So instead of just saying Hornady, she put consistent with Hornady, meaning it's not inconsistent with other manufacturers, it's more consistent with Hornady, but I wouldn't quote unquote die on this hill that it is Hornady. She also included a note stating at the bottom of that worksheet, it's more consistent with Hornady than other calibers within the 38 class family.
That's because you're a scientist, right?
Yes, sir.
That's because us lawyers ask you questions and you just can say what the science holds. Is that true?
That's all I can say, yes, sir.
I mean, you're not in this business to say something for this side or something for this side, right?
No.
I mean, if I told you to say something, you're going to tell me to go jump in the lake, right? If it was not consistent with the science, probably kindly
say
you're going
it a little bit nicer, yes.
Right, but you're not going to just agree with me because I work for the state. Is that true?
No, sir. We can be called as witnesses for either side.
And you can and have disagreed with prosecutors before?
I'm sorry?
Have you ever disagreed with the prosecutor?
Perhaps just last week, yes, sir.
Now, these brands that we have here, FIE, Arminus, Titan, some of these brands, it's not a Springfield, is that right?
That's right.
It's not Smith & Wesson, is that right?
Not in this particular list. That's correct,
Yeah,
yes.
it's not a Glock.
No.
It's not some type of well-known or other type of brand. These are a particular brand. Are these less common known than others?
Yes, I would say out of that list, the ones that I've personally seen in casework the most are the Arminius brand revolvers.
And are those top shelf guns, middle shelf guns, low shelf? By low shelf, you know what a high point is, right?
Yes, sir.
Is high point a very cheap gun?
It is.
All right, then you've got, what's the most expensive type of gun you think is out there right now, pistol-wise?
Well, typically the most expensive guns that we receive in casework are going to be those that are owned by our officers.
So a nice Glock or something like that.
or
a
like
Kimber
a nice Delton rifle, for example.
So
Not an
these-
Arminius revolver.
Where do these brands fall in? Top shelf, middle shelf, or bottom shelf?
I can only speak for Arminius because I've seen that the most in my personal experience. It's a very cheaply made revolver.
Are you familiar with the other ones, where they all fall?
I've seen them, but those are mostly from our reference collection, which have been handled by a lot of trainees. So they're not in the best shape either, but I don't know if that's a result of their poor manufacturing or all of our handling of them.
Now, to be clear, this GBI item 35, this Smith & Wesson 357 Magnum, that is not consistent with the item GBI item 2 and 5. Is that what you're saying?
That's right.
Nothing further, Your Honor.
Just with the well, basically, here's what it really boils down to. You can tell me if you agree. Is y'all don't know what kind of gun was used to fire these bullets, right?
That's correct.
Okay, there we go. The easy way to solve that problem. So we don't know that, and going to the no, not the photograph. Where's the comparison at?
It's 12.1. If you go to the file.
No, I got it. All right, going into the comparison with the section of damage, some expansion of HP. What do you mean by HP?
HP is our acronym for hollow point.
You got to say that. You said it so fast.
I'm sorry. HP is our acronym for hollow point.
Okay, so some damage to a hollow point.
Some expansion to the hollow point, which is what we would expect when a hollow point is fired. However, we have seen hollow points that experienced no expansion, in which case, if there was no other damage to that projectile, we wouldn't have anything documented there.
In your opinion, looking at this photo, which is Thrasher 287, is that limited damage, limited expansion?
Yes.
Okay. And also, there's this part in your report. Let's see, the weight is 110 grains, 38 special Hornady bullet, even though we've already established that item 2 is believed to be a Hornady. Item 5, possibly a Hornady because of item 2. Fair?
It's possibly,
and other characteristics.
Yes, it's other manufacturing characteristics, and she did have two that she could put side by side, which helped her, along with our resources where we would see how much or what a 110 grain Hornady 38 special looked like. She would have been able to do that side by side comparison and see that it is more consistent with that than any others, but it's just consistent with that because she was not certain that that is what it was.
Okay. And then last thing is the report also, or the bench notes, also BS longer than 380. Is that trying to say that, trying to exclude 380?
Yes.
What's BS?
It's the bearing surface, and that length varies depending on the caliber. So 380 bearing surfaces are a lot shorter when compared to the bearing surface of a 38 class, like a 38 special bullet.
Okay. All right, that's all I have. Thank you.
I'm done, Judge.
All right, I got a couple. All right, that last report. So when the other experts have testified, we have heard a lot of consistent with X or consistent with Y. Okay, for example, this is consistent with blood, but hasn't been identified as blood yet. Okay, another testimony. All right. Now, the report comparing the two 38 bullets, the one that was indicated that was found in the ribs in the fire, and the bullet that was indicated that it was found in on the floor, the report says they are identical.
Yes, Your Honor.
They were fired from the same gun.
Yes, that's going to be based on their characteristics that they picked up from the firing process from the same firearm. So those two items, whether one is Hornady and the other is not Hornady, they were fired from the same firearm, but the ammunition itself might be two different manufacturers.
All right, so that's not a consistent with, that is it's from the same thing, that's a certainty.
Yes, that's an identification statement.
All right. Now, I was going to go back, so you kind of covered the Hornady thing. Was there additional analysis that could have been done to determine whether those were the same? The composition of the bullets was the same and therefore the same manufacturer?
In terms of firearms analysis at the lab, what we're going to do is document those design characteristics and their probable manufacturer, but that's where it stops for us.
So y'all don't, that would require additional testing from someone who would do it on a molecular level, or could you not compare it with the microscope?
Well, we do put ammunition side by side on the scope, or we can, to see if those ammunition manufacturing characteristics are the same, but with damage as well. It kind of makes just seeing those manufactured characteristics hard to compare as well.
So that was my next question. So the issue with the determination whether the bullets are the same manufacturer is based upon the condition of the second bullet?
It's possible, yes, sir.
Okay. Now, I think everyone knows, but I don't think you said specifically, but what's the point of a hollow? What's the purpose of a hollow point?
So the hollow point, as it's advertised by ammunition manufacturers that make hollow point ammunition, is for that facilitated expansion. It is advertised by the manufacturer that it's the greater stopping power for that type of projectile.
All right, so you don't necessarily, the GBI doesn't take a position on whether that's accurate or not?
That's correct.
All right. Now, my understanding is that the bullet then expands, right?
Yes, sir.
Upon impact,
Yes.
and then creates more damage. Is that fair? Or maybe not. Depends on what it hits, would depend on the amount of damage, but can cause a larger pathway through the object that it strikes.
Yes, I have seen, and we have had Hornady come to the lab to do some test fires in ballistic gelatin. So when you consider ballistic gelatin, that I have seen personally in my experience, a full metal jacketed bullet that doesn't have a center cavity in the nose travels a little bit farther, and the path is a little bit more narrow. And the hollow point bullet travels not nearly as far, stops a lot sooner because it's been expanded to stop, and then the area around that path is a bit larger.
All right, and along with those lines, have you done other comparisons with projectiles for the amount of damage or path or something similar to that, where you can see the difference between other rounds?
No, sir. The only reason I said what I just said was based on them coming and providing us with a lecture on their new lines of ammunition. So at the GBI, we don't worry about anything with ballistic gelatin. Just when they have the opportunity to see it, would I be able to make a statement on it.
If a projectile, if a hollow tip project, and then the purpose of the polymer tip is to keep it spiraling longer and then cause the spread more, or it's just a...
It's difficult to say. The ammunition...
It may have some purpose, but it also may be a marketing gimmick.
Right. So that's why I state that that's how the manufacturer advertises. What the purpose of that flex tip is more controlled expansion of that hollow point.
All right. If a hollow point bullet were to enter into a body and exit that body, what would the resulting exit wound probably look like?
I'm afraid I can't testify to that.
All right. That would be somebody else's department.
Yes, sir.
Now, your original premise, getting the big packet of stuff from either the investigators, detectives, DA's office, whoever. I anticipate you got sent a big bag of bullets and said, hey, do any of these match 38s?
That was the initial premise
All
for
right.
receiving that from the
And
sheriff's
you
office.
said, if y'all want me to do that, you, meaning the GBI,
Right.
y'all said, okay, then we have to pull out each bullet put it under the microscope, compare it with all the other the other two known bullets to see if they match. We can probably do that with an eyeball test, saying, "Hey, that's a 223 by sight," and then I don't have to go into the microscope and examine the bullet.
Well, so actually, I did put every item under the microscope. I just didn't do a side-by-side
Right,
comparison between
right,
any items.
right.
So
You
the
still did your
initial-
analysis on each bullet to say what it was, but
Correct.
you didn't then compare it to the other two bullets.
Right. So the question, like you asked earlier, was, are any of these 38 caliber? So at the time, the agreement with the assistant manager of the firearms section and the customer, Mr. Clifford Broughton at the district attorney's office.
Let's make sure they're
Was-
not 38s first before I do any under the microscope
Right.
side-by-side analysis.
Was that we agreed that we would determine the caliber and provide a DTW, which is a determined type weapon, for the bullets, but that we would not do a comparison at this time.
And then if any of those came back as 38s, then you would go to the next stage potentially of looking at them.
I'm uncertain because that didn't
Didn't happen.
Right.
All right. All right, based upon my questions, anyone else have any follow-ups?
No, you're not.
All right, you can step down. Thank you very much.
Thank you.
I always enjoy learning something here. All right. Let's take a break, and we'll start back at 11-ish. All right, take a break. We'll come back at 11.
This is the photo log for the 9th, when we return to get the comparison photos from the phone and the timestamp on the videos.
Now, how many cameras did you all collect footage from Azalea for, I don't know, the early morning hours of the 5th and the late night hours of the 4th? Do you remember how many cameras total?
I believe there was 3 cameras at Azalea.
Okay. And did each one of those 3 capture, at least seem to capture the Dodge Journey that you photographed?
Yes, sir.
Okay. I want to just talk to you about these next few pictures. Slide 5. Where are you as you take this picture?
So this one I'm inside the office, holding a cell phone here, and then had another officer hold their cell phone on the camera view from outside, and then you have the timestamp right above that.
Okay. What is this monitor here that you're looking at?
That's their computer monitor for inside the office.
And is that monitor showing you the current video feed from that camera that you were just standing under in the previous picture?
Yeah, it's the live view.
Okay. What is the time showing on your phone?
12:20.
Okay. And that's 20 minutes after noon, is that right?
Yes, sir.
On the 9th.
Yes, sir.
And it's the same for the officer standing outside holding a phone up to the camera?
Yes, sir.
Was your iPhone time working that day?
Yes, sir.
Has it ever not been working? That's a no?
No, sir. Sorry.
Okay. Now, this camera is showing, when we zoom in here, looks like it's showing 10:59.
Yes, sir.
All right. And so is that where you're getting that these cameras were about 81 minutes behind, 80 to 81 minutes behind?
Yes, sir.
And that's because the difference between 10:59 and 12:20 is about 80 to 81 minutes, right?
Yes, sir.
Now, this next image, slide 6, is this you looking at the monitor for a different camera pointing a different direction?
Yeah, same monitor, just different camera.
Oh, same monitor, different camera?
Yes, sir.
Okay. And does this camera that we're concerned with here in image 6, does this point out towards Ogeechee Road?
Yes, sir. That's Ogeechee Road, right past those U-Hauls.
Okay. And that's, you're indicating to like the top right corner of the picture?
Yes, sir.
Can we see any part of the chevron in this image?
Yeah, if you look at my vehicle, the chevron's right.
Which one's your vehicle?
The police truck on the left side,
All right, and then where's the chevron in relation to that?
just past it.
Okay. Are those U-Hauls in the chevron parking lot?
Yes, sir.
Okay. And did this camera have the exact same timestamp discrepancy
Yes, sir.
as the last one?
Yes, sir.
80 to 81 minutes?
Yes, sir.
Slide 7. Same monitor, different camera?
Yes, sir.
And does this one just point the other direction as the camera we were just talking about?
Yes, sir.
All right. And did that camera have the same timestamp discrepancy as the other two?
Yes, sir.
Whole system has the same time, right?
Yes, sir.
All right. Therefore, the time discrepancy is going to be the same on all three.
Yes, sir.
One moment, please, Your Honor. Let me just ask you this. Did the cameras themselves appear to be working when you were out there collecting the footage?
They did.
Did you have any issue collecting the footage?
No, sir.
As we were looking at this image, image 6, we see a police truck out there and U-Hauls in the Chevron parking lot.
Yes, sir.
At that time, was there in fact a police truck out there and U-Hauls in the Chevron parking lot?
Yes, sir. That's a live view of what was going on right then.
Okay, so were these cameras accurately capturing what was actually happening in the real world?
Yes, sir.
And does the timestamp discrepancy have anything to do with the accuracy or reliability of the footage itself?
No, sir.
No further questions, Your Honor.
All right, thank you. Mr. Hilliard?
Thank you.
Mr. Hilliard, before you start, I don't want to take a full break, but if you need to feel the need to stand up and just kind of stretch it out, you can feel free to do that. I know you've been sitting for a long time. Oh, just stand up and shake it out a little bit. I'll show you what I do. I recognize you're sitting for a long time. Kind of change the channel. Get your blood flowing again. Sorry. All right. Okay. Mr. Hilliard.
Officer Schinkler, I'm going to start where you left off because it just makes more sense to work back that way because that's where you were at. With regard to these, like State's Exhibit number 55 that we just discussed the 80-minute time discrepancy. Okay. Did you ever do any?
Just a moment. Mr. Shinker's,
Give me 1 second. I think it's me.
okay.
Is that better? Thank you. Sorry about that, Mr. President. Okay, so let's just start with the Azalea cams first. Okay, so on October 7th and October 9th, you noticed some sort of time discrepancy, correct?
Yes, sir.
And you documented it, and that's what we just dealt with, correct?
Yes, sir.
Did you ever inquiry or find out when the discrepancy began?
No, sir.
You were just sent out there to collect the footage then?
Yes, sir.
Okay, so you made no further inquiry other than just to note it?
I personally did not. I don't know if my sergeant or the other officer did.
And again, I'm not trying to put words in your mouth, just asking you what you did, okay? So you noted the discrepancy, but you didn't get to the bottom of it or find out when it started, correct? All right. So let's back up a little bit and go to State's Exhibit 11, which was the one you did prior to that one. So you, on October 6th, you got the Dodge Journey, correct?
Yes, sir.
And you photographed the Dodge Journey,
Yes,
correct?
sir.
Did you do anything else other than that, or just take photographs?
Photographed it. We did alternate light on the vehicle to see if there was any like fabrics or anything from the scene. We did do a couple swabs of a substance in the back, and we did blue star the vehicle.
Well, and that's why I'm asking is just based upon the testimony I heard, it seemed like it was just a bunch of pictures you were taking, but there was a lot more to it than that, wasn't there?
Yes, sir.
Okay, so how many people were out there that day on October 6th, I guess, examining the vehicle?
Myself and Corporal Shiro.
Okay, so two of you.
Yes, sir.
Okay. And so you went through the vehicle and you noted the alcohol containers, correct?
Yes, sir.
Did you seize those?
Did I see those?
Yes.
Yes, sir.
Okay, so they were taken into evidence, correct?
No.
They weren't taken into evidence?
No.
Just photographed them?
Just photograph.
All right. Just curious, why not?
Didn't feel that they were pertinent to the case.
So you don't think it's pertinent to the case, you don't log it into evidence?
Well, if it's not evidence,
And who determines whether or not something's evidence?
I guess that would be me.
So you determined it wasn't evidence, so you didn't log it, you didn't test it, you didn't swab it, you didn't keep it, correct? All right. Let's go on to the next picture. You had a picture of a natural light can in the back, correct?
Yes, sir.
And that was back in the passenger seat. And did you seize that and take that into evidence?
No, sir.
Okay. And again, I guess for the same reason, you didn't consider it to be evidence?
Yes, sir.
Let me ask you, whenever someone drinks from a can or touches a can or does something like that, is it possible to have some sort of DNA contact or transference between it?
Yes, sir.
Okay. And do you think that that might be relevant to testing to see who may have been or not been in the truck at that point in time?
It could be, but if they both had, or whoever had access to that vehicle, their DNA and prints would be all over the vehicle.
Okay. All right. But again, you didn't think it was evidence, didn't seize it, didn't test it, didn't do anything further with it, correct?
Yes, sir.
All right. Now, the substance in the back of the vehicle, which was kind of weird, okay, admittedly.
It was.
You did take that, though.
I took a sample of that.
And let me ask you this. You said it was some sort of kid cereal.
I believe. I'm not 100% sure.
Well, but it wasn't any biological material.
No.
Okay, it wasn't any sort of cleaning solvent or anything like that, was
No,
it?
sir.
Okay, but it was, from what you could tell, and I don't have any reason to think, you're wrong, it was some sort of kid cereal or breakfast cereal of some sort that was in the back.
Yes, sir.
Now, when you were taking pictures of the inside of the van, I'm going to assume you looked throughout the entire thing.
Yes, sir.
Did you ever find any feces or blood or anything like that in it?
We did find a spot that reacted on the driver's side seat, but that was it.
Okay, and what was that?
Appeared to be blood. We just blue starred it, and it fluoresced. And it was just a little spot on the front driver's seat.
Okay, did you seize that or send it for further testing?
No, sir.
You didn't?
No, sir.
And again, just curious, why not?
Didn't believe at the time it was pertinent.
Now, with regards to the rest of the vehicle, did you find anything else of any substance in there? Of any relevance?
There was a spot in the back that we took swabs of and logged in. And there's a couple fibers from the back seat, or the back of the vehicle that we collected and logged in.
Okay. And what did you do with them once you swabbed them and collected them and logged them in?
That was all I did with them.
Okay. And just out of curiosity, if you look at number 15 from State's Exhibit 11, what was this orange thing and this white thing in the back of the train?
Those are traffic vests, kind of like safety vests. And then the white paper was from the dentist, I believe it was.
Okay.
Paperwork.
And what's the little orange thing on the ground right there?
I believe that was another safety vest.
All right. That was the extent of everything that you found or found relevant from the call, correct?
Yes, sir.
All right, let's back up and go to State's Exhibit number 10. And actually, it might be easier to look at State's Exhibit number 9. Do you have that in front of you?
Yes, sir.
Okay. Let's do that, because it's a better overview, and the other ones are just a lot of pictures to thumb through. So you took a bunch of pictures of the house and the surrounding area, correct?
Yes, sir.
All right. So looking at State's Exhibit 9, and again, don't want to put words in your mouth, but from what my recollection was, there was a pool in the back, and there was a set of dining room doors and a set of living room doors that led out to the pool area, correct?
Yes, sir.
Okay. And it looked like, and again, not trying to put words in your mouth, just going from my recollection, that the living room doors opened into a play area,
Yes, sir.
and the dining room doors opened directly onto the patio area. Is that a fair and accurate assessment of what the pictures you took?
Yes, sir.
Okay. Now, when you got there, well, I guess it was on October 5th, correct?
Yes.
Okay. When you got there on October 5th, you were sent around to take all the pictures that you took in State's Exhibit 10, correct?
Yes.
All right. And Mr. Dean asked you to discuss and go through what it took to go from the front door to, I guess, the living room door, right?
Yes, sir.
Okay. But based upon that, it's a much shorter trip to go from the front door to the dining room door, isn't it?
Yes, sir.
Okay. And it's not nearly as circuitous, correct?
Yes, sir.
And I can't tell from the picture, so I'm going to have to ask you. The dining room door opens right out onto the patio, right?
Yes, sir.
Okay. The living room door opens into a play area, correct?
It's the same patio. It's just got a little gate. in
Right.
front of
And it
But
seems to me, again, not putting words in your mouth, but the play area seemed kind of cordoned off,
Yeah.
and the dining room doors didn't. It kind of opened straight into the pool area.
Yes, sir.
Is that a fair assessment?
Yes, sir.
Okay. So it's much easier to get out through the dining room door onto the patio than the living room door, correct?
Yes, sir.
And when you were there that day, were those doors open, closed? What were they?
All the doors were closed when I got there.
Okay. Were they unlocked?
I believe so, yes.
Okay. So you didn't have any problem opening and closing, or the dining room doors, were they relatively easy to open and get through?
Yes, sir.
Okay. The living room doors, same thing. Were they relatively easy to open and get through?
Yes, sir.
Okay. Did you have any difficulty getting through them?
No, sir.
Okay. Was there anything that indicated that the doors may have been kicked, smashed, broken in any way, shape, or form?
No, sir.
Okay. So they were operable.
Yes, sir.
Okay. Now, Mr. Dean asked about the route, I guess, through the downstairs. It's kind of a fairly odd layout in the downstairs area. I think that's safe to say, correct?
Yes, sir.
But was the kitchen in use?
Yes, sir.
And it was usable, correct? Was the living room in use and usable?
Yes, sir.
The dining room in use and usable?
Yes, sir.
And the front area that we're talking about, where you first enter into the front door area, that front door area enters, what's the street that is directly in front of the front door?
Pope altar.
So that's Buckhalter Road.
Yes, sir.
Okay. And the dining room and the living room, they open towards the pool, but I assume that's more around back to where the driveway and the garage and all of that was.
Yes, sir.
Okay. And again, if I'm misstating it or I'm just trying to understand it, but that seems to me that, and the area had a gate on it, if I'm not mistaken. I remember you taking a picture of a truck.
Yep.
So there's a gate, and the gate goes around to the back, correct?
Yep.
So wouldn't that indicate that the main entrance and egress to the house is through the back, not the front?
Sure.
Okay. Well, I mean, you know the layout better than I do, so.
I don't know what entrance they use, but yes.
Okay. So now, when you were taking all of these pictures, and you took a number of them, you took 475, right?
Something like that.
Somewhere there about a lot.
Yep.
Okay. I'm not saying these are all them, but you took a lot. When you came across the pictures, you said it was vomit that was in the pack and play, correct?
I believed it was.
You believe it was. Did you seize it?
Yes.
Okay. Did you send it off for testing?
I did not detect this.
So you basically did your job, seized it, handed it off to the detectives, correct?
Yes, sir.
Okay. But the one thing is you're sure it wasn't blood, correct?
I'm not sure.
Didn't look like it, did it?
It did not look like blood.
And not a trick question. You answered this question for Mr.
Thank you. State calls Angela Phillips. Ma'am, if you could please stand up and raise your right hand. Do you swear or affirm the testimony you're about to give in the matter now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, you can have a seat and scoot your chair on up to that microphone. You have a pretty soft voice. I need this man back here to be able to hear you, okay? If you could please introduce yourself to the jury.
I am Angela Phillips. I work at Burn Foreman. I was Mr. Farris's assistant for almost 28 years.
Thank you, ma'am. Can you tell the jury a little bit about where you started at Burn Foreman and your move to Georgia?
I started as a temp right after my husband got a job in Birmingham after we got out of the Navy. They hired me the first week. I started working for Mr. Farris and another attorney at that time. We were there for 5 years. I always wanted to live in Atlanta. My brother and sister-in-law were here, but my ex-husband took the job in Birmingham basically without even asking where I wanted to be. So when the job came open in Atlanta, we discussed moving. He wasn't interested. We were in marriage counseling at the time, and later we went through a divorce, and then I asked to be transferred to Atlanta when we were going through, not custody, but visitation. I was going to stay in the house. He was supposed to see our daughter, every other weekend on Wednesdays, and then he started, I can't get her tonight, maybe, so he wasn't going to keep any kind of schedule. So I then asked for the transfer to Atlanta where he would have to adhere to a schedule.
Okay, so what year was that when you asked for the transfer to Atlanta?
95.
Okay. And did you end up transferring to the Atlanta office?
I did.
And you were still with Burn Foreman?
Yes.
Okay, and who were your attorneys? Was it attorney or attorneys that you were assigned to?
I was so originally it was Gary and Ginger Busby. Then I transferred from Ginger to Darren Collier. And so I was working for Darren and Gary even once he transferred to Atlanta. And then I had a new associate also, whose name I don't recall.
And so you tend to work for multiple attorneys at one time?
Yes, I currently have 5.
Currently you have 5? So when you transferred here from Atlanta, how long had you known Gary?
5 years.
5 years. Did you work with him the whole 5 years prior to coming to Atlanta?
I did.
When you came to Georgia, apart from your brother-in-law, let me ask you this, where did you move to in Georgia when you came to Atlanta?
So Darren Collier, who I worked for in Atlanta, his mother lived in Marietta. She actually showed me around, helped me find an apartment. and eventually we found one in Alpharetta.
Tell me about your early professional relationship with Gary. How well did you know each other?
I mean, you know, we talked about the kids and what we did on the weekend. He'd tell me about his honey-do list, you know, ball, whatever the kids were doing, you know, family stuff.
And at that time, did you know much about Melody Farris, Gary's wife?
Not really, not a lot. I think I'd met her once or saw her in the office when she brought the baby and the toddler.
So that would have been Chris and Scott, or the girls?
The little girls.
The girls. And I want to get into a little bit about how your relationship with Gary evolved over time. Can you tell the jury, when you moved to Georgia, did your relationship with Gary ever cross from professional to personal?
Unfortunately, it did.
Okay, can you tell the jury briefly about when that was?
It was probably in '95. It wasn't ongoing. I wouldn't classify it as an affair. We just became very close, especially once I moved here. I didn't know anybody else other than my brother and his wife, and they lived in Hiram at the time, and I was in Alpharetta, so that was over an hour drive.
You lived in Alpharetta?
I lived in Alpharetta, and I did make one friend that was actually the assistant of one of our clients in the same building where we worked in Midtown, and then she lived in Alpharetta nearby. So, and she had two little girls, just a little older than my daughter.
And when you say that your relationship with Gary went from professional to personal, what does that mean?
Well, I mean, he became more of a confidant and a friend and an encourager on the weekends where I would have to take my daughter to meet her dad were very difficult for me. And so he was a shoulder that I leaned on. And then unfortunately there were a couple of instances where, you know, long hours, sometimes alcohol involved, things crossed a line.
And it became physical?
Yes.
How long would you say that the physical relationship lasted?
Well, it wasn't an ongoing thing. It wasn't like planned. A few occurrences maybe over the course of a year and a half, maybe.
Did it extend beyond the 90s?
Oh, definitely not.
How did it stop? And why did it stop?
Well, it stopped because I became friends with Melody and the girls. And I was such a mess back then, you know, and not having friends. But then I got involved in a church, and, you know, the person that I was up until that point, age 30, was so different than the person I was at 30, 31, 32, as I was going through that. And then I was just able to find my way back to the person that I was, to the, you know, with the morals and and my relationship with God. And just, you know, I would never want anybody to cheat on me, you know, with my ex-husband. So then when I realized, you know, it's like I was able to separate him from her when I didn't know her.
So at some point, did your relationship with Gary just go back to being professional?
Yes, I mean, we were still friends, but we were able to work through, and we had an excellent working relationship. We were a team, and I still miss that, you know.
How many years total did you work for Gary?
It would have been 28 in October if he had lived that year in 2018. I just celebrated my 34th anniversary with the firm last week.
Okay, so 28 years.
Yes.
Just short of 28 years with
Yes.
Gary. Okay. So over those 28 years, you saw Gary almost every single day in the office.
Yes.
Did Gary share with you information regarding his relationships with his family?
Yes.
And did you have access to Gary's financial situation?
Yes.
At
To some degree.
Okay, can you explain to
Well,
what degree?
I mean, I filed his taxes, made copies, and, we used to do TurboTax in the office. We would all share the same disk, and so I would photocopy, and then, he would share some things.
And in the beginning, would Melody come by the office and see Gary?
Sometimes. I spoke with her on the phone almost every day for several years after I moved.
What would you two have to speak about?
Just anything. She just talked. I mean, I would hear the same stories from her and from him. Sometimes you wouldn't know it was the same story if you didn't know it was the same story, She elaborated more, I guess.
Okay. So I want to move forward a little bit to, let's say, around 2009, 2010.
Okay.
At some point, did you see a change in Gary and Melody's relationship?
Yes, she became increasingly more critical of him in our phone conversations. And he became increasingly exasperated.
Okay. Can you speak up just a little bit
sorry,
for me?
yeah.
You still have a very soft voice.
Oh, sorry.
And I need all of these people to hear you.
Okay.
You said he became increasingly exacerbated.
Well, I mean, he just, I think that's around the time she started kind of disappearing. It's hard to remember the timeline exactly, but I do know that she was angry that he was receiving this Father of the Year award.
Okay. And I want to talk about, you mentioned her disappearing. What is it that you know about that?
I know that she would, go to her friend Sheila's, I think, or she would go to her mom's. Sometimes she would just, I can't remember the years, but I just remember he was only able to know where she was based on the credit card activity.
And at some point, did Gary start receiving his financial documents to the office?
Yes. He did after she ran all the cards up and was basically, breaking the bank. So, yeah.
Do you remember around what year that would have been when he began getting his financial information sent to the office?
Really can't remember exactly, but I'm going to say it was maybe 2016, 2017.
So in 2018, you were receiving information, his financial documents?
Yes. Mm-hmm.
Your Honor, may I approach the witness? Ms. Phillips, I'm showing you State's Exhibit Phillips 1. And I want you to just go right there. Is that the office address down in the middle of that page?
It was at the time.
At the time, in
Right.
2018?
Yes.
State moves into evidence, State's Exhibit Phillips 1.
Okay, thanks, Ben.
Okay, is this the exhibit I just showed you, ma'am?
Yes.
Okay. And this was the address at the time in 2018?
Correct.
Okay. And so this states that Mr. Farris had a credit card ending in 1727 mailed to the office.
Right.
Now, would you receive his mail?
Yes.
Can you tell me, well, the date on that is reversed. Is that 15/6/2018?
Yes.
So it'll be June 15th, 2018. Does that sound about right when you
Right.
would have received that credit card?
Right, I remember that new card coming.
You remember that new card coming
Yeah.
in? All right. I want to talk about, jury's heard a little bit about Mr. Farris's spells. Can you tell the jury if you've witnessed one of those spells?
Oh, many.
And what would happen to Mr. Farris when he was on spell?
Well, he would complain of dry mouth and kind of a burning in his throat, but you would know he would fall asleep at his desk. I mean, sometimes he would, be in his chair. Sometimes he would sit on the sofa, and a lot of times in the afternoon he would go in and close the door and just say, "I'm taking my 15." But a lot of times that extended beyond 5 o'clock, and I would have one of the associates or paralegals work on later to check on him before they left to make sure he could drive.
Did he, do you remember in 2018 when Mr. Farris was in the hospital?
I do.
And how did you know about that?
I believe Melody called me.
Okay, what was that conversation like?
Well, just kind of matter of fact, she was talking about how he didn't take care of himself and the smoking. So,
Were you concerned when Gary was in the hospital?
a little bit, yeah.
Did you know why he was in the hospital?
Not really,
Were you able to speak with him when he was in the hospital?
no.
Why
It was
that?
my understanding she didn't allow him to have a cell phone.
In the hospital.
Right.
To your, in your experience with Mr. Farris, had he ever been suicidal or had suicidal ideations or expressed thoughts
No,
like that?
absolutely not.
Tell me about Mr. Farris's work ethic and routine.
So typically he would work from home in the mornings, especially after they moved out to the farm, just to avoid the traffic. And then he would come in the office around 10 and often stay beyond 6. I never worked later than 6 unless there was a special project. So, but then I know sometimes he would continue work on after hours or on the weekends, because I had the habit of checking my work email on Sunday nights just to see what to expect the next day.
Would it be unusual for Mr. Farris to go, let's say, 24 hours without answering a work email?
Oh no, absolutely not.
And you said he worked on holidays sometimes? Well, you mentioned the farm and that he would come in a little bit later when they moved to the farm.
Right.
What did you know about them moving out to the farm?
Well, I know it was not his idea. If he had had his way after the kids moved out, he would have bought a condo closer to the office and then maybe gotten a farm or a lake house further out to enjoy on weekends. But I think because she had an affair with a man that had horses, I think he...
Objection, calls for speculation.
Okay.
Sustained.
When they moved out to the farm, did Gary change at all?
I don't know about change. I mean, I think he enjoyed having the horses and the farm. He liked to do manual labor. I mean, I remember, somebody that makes that much money would normally get a lawn service or have the boys do it, but, he preferred to do it himself. I know part of it was because he knew he could do it right. But I think he just enjoyed tinkering, I remember he always had projects as far back as I remember, and so I think he enjoyed having the horses and the farm and but he did not like the distance.
From the office.
Right, and he was unhappy that it still did not keep her at home.
I want to talk about the week of July 1st, 2018.
Okay.
All right. Now, that Monday, which was July 2nd, did Gary go into the office that day?
I do not recall.
Did he come into the office on July 3rd? That would be Tuesday.
He did not.
How do you know that?
Well, I just recall that we exchanged emails that day.
On the 3rd?
On the 3rd.
And at any point on the 3rd, did you notice he was no longer responding to emails?
Yes, he was no longer responding after sometime between 3 and 3:30, I think.
Is that typical or atypical for him?
It's atypical.
I want to talk about July 5th, when his remains were found, okay? How did you find out about Gary's remains being located?
So originally, Melody called looking for him. I didn't know anything, and I checked my email on the evening of the 4th, assuming he had replied to the emails from the 3rd, but he had not. And so when she was looking for him, I thought it was odd that she wouldn't know where he was, but I was concerned enough to call, because when you would call, if he was driving, you would get a message, a focus message that he was driving. If you sent a text message, it would come across his email in the office. So I just said, let me know when you find him, and then I don't remember how much later that was. Amanda called to tell me that he had been located.
Do you know what time Melody called you that morning?
It was after 11, but before noon.
After 11, before noon. Okay. And then Amanda called. And what information did you get from Amanda?
That they had found him in the burn pile.
When you received that information, what did you do next?
I mean, I just broke down. I couldn't believe it, I don't know. I just went to my friends and cried and talked about how I couldn't believe what had happened and how could it have happened.
When you spoke with Melody between 11 a.m. and 12 p.m., did she tell you when she had last seen Gary?
She called me a second time, so I don't remember if this was the first call or the second, but I think it was that call, the first call, that she said that the grandkids had said, we haven't seen Big Daddy in a while. And she said she recalled seeing him on the 3rd.
Okay, and you mentioned she called a second time. When was that second call?
That was, it was early afternoon, early to mid-afternoon.
And what was that call about?
She talked about his remains being found in the burn pile, and I inquired as to how he got there. I couldn't fathom any way that he got there. She suggested maybe he had a spell and fell in, and that didn't make any sense to me. His spells were never bad enough that he would fall into a fire and not be able to pull himself out. And I asked, would there be an autopsy? To which she said, oh, there's not enough remains for an autopsy, which just made my blood turn cold, and still does.
You could just give me 1 moment. Thank you, Ms. Phillips. That's all I have.
Okay.
All right, Ms. Weaver.
Good morning, Ms. Phillips. My name is John Luke Weaver, and I represent Melody. So I want to go back in time to the year you started with Gary. What year was that?
1990.
And that was over in the Birmingham office.
Correct.
Of Burn Foreman.
That's correct.
Right. And how long had you been working there?
I started working for him the first
Immediately.
week.
You were hired on to him.
I was hired as a temp the first week, but then when they hired me full time, the second week, I was assigned to him.
Right. And you guys, y'all weren't in litigation. Y'all were. Explain that a little better.
So, probably creditors' rights, bankruptcy, corporate, and then when the market shifts, we would go to lending. So, you know, if loans are being made, if the economy's good, then we represented the banks for loans, and then if the economy went bad, we would represent the banks against creditors who defaulted on loans.
Okay. Was that all the way through
Yes.
your career? It never shifted?
No.
Okay. And so it wasn't real estate closings, like large closings, correct? Or
That was here.
Okay.
The market has shifted by the time I moved to Atlanta, and it was almost exclusively closings.
Okay. Large real estate
Yes,
transactions.
multi-million-dollar.
Commercial transactions
Correct.
for the most part.
Mm-hmm.
And large housing developments too, I imagine.
Shopping centers, yeah, those sort of things.
And that's what you guys specialized in
Yes,
by the time you got here in '95.
yes.
So let's go back to in Birmingham. Were y'all close?
I mean, you know, we were friendly. We were close-ish, I guess.
Sure.
You know.
Well, so you know, you moved. You mentioned your divorce,
Right.
and you divorced in what year?
95.
And what came first? So you know, you mentioned that you and Gary had a relationship in the mid '90s.
Right.
But what came? Were y'all also having the relationship in Birmingham?
No.
All right. So it started when you came to Atlanta.
Yes.
But you were fond of him. Y'all were close.
Yes.
Talking about, I'm sure he consulted with you about your divorce.
Yes.
And you moved here in '95, correct?
Yes.
So let's go back. So, and I do want to remind you of this. You gave 2 statements in this case.
Right.
And the first statement, you didn't mention anything about the relationship that you had with Gary, correct?
Right.
And then you actually called them to tell them that you did.
Yes, because during the statement, I was not asked about it.
You weren't asked about it?
Nobody asked me about it. And then I was headed back to my desk, and I was pulled to the side by our managing partner,
Who was that?
Eric Durlacher,
Okay.
and the firm's attorney, and 2 investigators. I was pulled into a little room, you know, tiny little room, nothing like this, and kind of back against a wood door, you know, asked this question and put on the spot. You know, and I was so shocked by the question, first of all. And I said no, because I didn't want to, I don't know.
And this is the firm, people with the firm.
Right,
Okay.
Mr. Durlacher, and then people with the investigation. But I just didn't want Eric to hear it that way. I didn't want to be put on the spot like that. But then I did reach out because I didn't want it to ever be an issue of credibility. You know, I wanted them to know that I would not lie about it under oath should it come up for any reason.
Okay. And here we are, talking about it under oath.
Exactly.
So I do want to go back. You mentioned that you guys did have a romantic relationship.
I wouldn't call it romantic.
You know, you stated in one of your that you kissed. You kissed multiple times.
Right.
Right? And then you told, I believe, Detective Kuykendall that you can't remember whether you actually had sexual intercourse with him or not.
Right.
Was that correct? You can't remember?
I can't.
Right. And you guys would meet up and go to hotels, yes?
No, there was a hotel there was a hotel connected to the office.
At the Hyatt or Georgian Terrace?
No, I don't remember the name of it.
Okay. But you stated that you couldn't remember if you actually had sexual intercourse with him.
No, it was not. I don't recall ever having intercourse, no.
Okay. But you kissed him, and you
Yes.
stayed in hotel rooms with him.
No, he walked me to my hotel room when I stayed over here before I moved.
You described him as a friend, a confidant, and a shoulder to lean on.
Mm-hmm.
What does that mean?
Well, like I said, I didn't have a lot of friends over here at the time because I was new. I felt comfortable talking to him. I mean, he would encourage me to make friends. I remember one weekend I was set to go to like a women's retreat with the church that I just started to, and I was nervous about going there, and he just encouraged me to get out and, you know, make friends and learn to be, to make a life here in Georgia.
And he would talk to you frequently about your situation, your custody situation that you were having at the time. You mentioned that earlier.
Well, I mean, we didn't talk about it often, but yeah, he knew what it was. So on the weekends when I was going to be without her, you know, I would express how sad I was going to be home alone. I remember once he's like, I always have a house full of people, you know, but I wouldn't give for one weekend alone. You know,
That's what he said?
Well, yeah, you know, just kind of, you know, I should try to enjoy.
So when y'all were talking and y'all would have these close conversations, now y'all worked in the same office.
Yes.
And did y'all ever kiss in the office?
No.
So this was just out when y'all were drinking?
Right.
All right. And when did you guys ever discuss Gary leaving Melody for you?
Oh, no.
That never came up, not one time.
No.
So y'all would just talk, y'all would just kiss and have these close conversations, but never talk about actually being together?
No, there was no interest on either end. Mm-mm.
So how did these interactions supposedly stop?
Well, like I said, it's like, you know, I became friends with her, and she became a real person to me. You know, he was isolated to me in the office situation. You know, there's one thing to know, but there's another thing to see.
Okay. But, I mean, realistically, Melody knew about the two of you.
I don't know.
Okay. And did y'all ever talk about that? Do you remember that?
Melody and I?
Yeah.
No, I don't think so.
But y'all were close, you and Melody.
I mean, we would talk and we did things together sometimes with the girls.
But realistically, y'all's relationship tapered off. What year did you guys move to the Atlantic Station office?
I think we moved there in, well, we just moved to our new location last year. So we had been in Atlantic Station for 21 years at that point.
Okay, so that would have been, what, about 2002?
I guess we moved to Atlantic Station around 2000 or 2001.
Early 2000s.
Yes.
Okay. So, but that would be the more realistic time that you and Melody, I think you mentioned something about 2010, but your relationship really kind of stopped in the early 2000s with Melody, as far as being close, talking.
Yes. Well, yeah. I mean, she talked a lot. I couldn't get work done. Once caller ID became available, I just didn't answer.
You just didn't pick up the phone anymore.
No, and I mean, sometimes I would, but then she just became more increasingly critical of him. And, you know, I wasn't interested in hearing it.
So you were just kind of ready to get out of their marriage, essentially, at that point?
Well, yeah, I mean, after the inappropriate contact, I tried to back away from that. There was a time where they were having problems. I encouraged him to go for marriage counseling. And I said, you know, if she won't go with you, which he alluded to, I said, go for yourself. That's what I ended up doing. And, yeah.
You had access to, I mean, obviously his bank accounts and things like that, correct?
Well, I typically didn't open the personal things like that.
But you had access to his Gmail account, right? Gary4250@gmail.com?
Only to the extent that he would forward things to me.
Okay.
I didn't have a password.
But you saw, at his work email, you had total access to that.
Yes.
Right. And so could you ever see any of his work emails that he would, I mean, from what I understand, and tell me if I'm wrong, but Gary was one of those folks that communicated through email, yes?
Yes.
A lot of the time.
A lot.
Even his interpersonal communication with his kids, his wife, yes?
I don't know if he did with her, but
What about
yeah,
the kids,
with the
like
kids.
Emily?
Maybe. I don't recall specifically if there was a lot.
Sure. But did you ever run across any emails with a Joanne Ward Hill?
No.
You don't remember those?
No.
Did you ever meet Joanne Ward Hill since she works in your building?
I did.
Okay. Did you know that he was attempting to have a relationship with her?
I did.
You did know that? And that they would talk? I mean, did she come to the office a lot?
No, I think they went on smoke breaks together.
Okay. Would you have considered them dating?
No.
Okay. But you knew that he wanted to pursue something with Joanne, yes?
Yes.
Okay. How did you know that?
So Joanne worked at AGG. One of our employees' sister worked at AGG and knew that she knew me. So Joanne's coworker asked my coworker, who called and asked me if Gary was still married.
Okay.
And told me why.
And what do you mean why? What do you, go ahead.
Well, that he had asked Joanne out.
All right. And here's what I'm trying to get you to explain to me. He's out there essentially trying to date Joanne Ward Hill. Therefore, it's reasonable for you to have construed it as paralegal because you are very close to him, right? Going through his credit cards, you're getting these notices, opening these notices, his emails, his life. You're part of all of it.
Right.
It was fair to say that they were in an open marriage. He's dating, she's dating.
I don't know of him dating, per se. I knew that she was having an affair. He knew that she was having an affair because...
Would you not say that sending emails to another woman asking for dates and taking smoke breaks is an affair?
I didn't see him ask her in an email.
Okay. How did you know he asked her?
Joanne told Lynn, who told Billy, who asked me if he was still married.
That's a lot of levels of hearsay.
It was. So, and then Joe...
like a textbook definition of hearsay. There you go. Doesn't mean it's not true, but...
But it would be reasonable to believe that because he was pursuing dating, and as you said, she's having affairs for lives within a marriage. Yes?
Yes, it was my understanding. They lived on different levels of the house.
Different levels of the house. Seeing other people. Yes?
I don't know that he saw other people other than trying. Maybe it was something else. I know that he went to the doctor to be tested, but I also know I encouraged him to get tested for poisoning.
You encouraged him to get tested for poison.
Yes.
Okay. So that's where that idea came from, was from you?
Well, he said at one point that he thought she was poisoning him, and I encouraged him to go to the doctor. And he said that was embarrassing.
When did you ever, I'll ask you, have you remarried? Have you moved on since Gary? Okay.
Well, I mean, I never remarried. I didn't want to remarry.
Right. Did you still love Gary?
As a person, yes.
Okay. Well, I'm talking about as, wishing he'd be your romantic
No,
partner.
never.
And as far as being in the hospital and you allegedly not having cell phone communication, I mean, Gary always had his phone with him, yes?
I think so, yes.
Right, and he was always texting you and calling you,
Yeah,
emailing you,
right.
constantly.
Well, I mean, not constantly.
I mean, it's kind of absurd to think that, if I go to the hospital, the first two people I'm going to call is my wife and my paralegal.
Right.
Because they are the two most important people in my life. They
Right.
run my life. So you would have had communication with him, because he would have had to have talked to you about, hey, we've got this case coming up. We're going to have to move that closing. So that would be reasonable, yes?
Yes, but I was told he wasn't allowed to have his phone.
Who told you that?
I think Melody said she wanted him to rest, so she didn't give him his phone.
Well, then that'd be pretty reasonable, too. If he's trying to rest in a hospital, he's had a spell, maybe he doesn't need to work.
Right.
Well, but you insinuated that she somehow built this barrier between you and cut him off and hid him in the hospital away from you.
No, I'm not saying that. I'm just saying I didn't have any contact with him during that time.
So I may have one moment, Your Honor.
You ready?
Ms. Phillips, did you know how Gary felt about Melody having affairs?
Well, yes.
And how was that?
Well, I mean, he was obviously not happy about it. Especially since there were multiples. I remember the first time, and I don't know that this turned into an affair. I just remember him leaving the office sick one time. This is at least 25 years ago, because she'd gotten an email from some man talking about her legs and her red painted toenails.
And that was a long time ago.
A long time ago.
Did Gary ever express to you his state of mind when it came to if he were to pass away?
I know that he talked about changing his beneficiary information, that he did not want her to get another penny of his money because of the way she had wasted it and kept cheating.
Did he ever express to you his, and when I say state of mind, the way he felt and at the moment, at the time, as if something were to happen to him?
Well, we had a conversation about, I said, you need to go be tested for poisoning. If you don't want to go to our regular doctor, we have the same doctor, and obviously I couldn't tell the doctor to test him. I said, go to a different doctor. He went out on a smoke break, and he came back, and he said, well, you'll know what to tell Dateline if I die mysteriously.
And that was
That Melody had.
in jest in a way.
Yes.
That's all I have. Thank you.
All right, Mr. Weaver.
A moment, please, Judge. Gary would keep actually, and whether for medical purposes or for his own personal purposes, because he's a very organized person, right?
Yes.
That he would actually keep a log of his spells. Do you remember that?
Yes.
And would he turn that over to his doctors?
No.
Would he actually go to the doctor?
He did.
Okay. What was the theory on what was causing these spells from the actual doctor?
They couldn't find anything.
They check his blood sugar?
They checked everything.
All right. Did he mention to him, let me slow down. Did they ever mention that you know of that, of course, he's a rather large guy and he was in very bad shape?
Mm-hmm.
Was that ever a possibility?
Well, he was on blood pressure medicine or whatever.
Blood pressure medicine. How many packs a day would he smoke?
Hard to say. Too
Could
many.
you guess?
I think he would maybe smoke 2 or 3 every time he would go down, which was at least once an hour.
So 2 or 3 cigarettes per smoke break.
Right.
Every hour.
Probably.
Okay. And that's a fact. I mean, you were with him for so many years, you would know this.
Right.
And he would drink Mountain Dew constantly, yes?
Yes.
Right. So he was not in good shape.
No.
And he would just lay down at the office for hours, sometimes.
Well, he would fall asleep in his chair sometimes, and then other times he would go and just not be able to hold his head up and would sleep on a sofa.
And he'd been at the office for hours by that time, right?
Usually.
Right? So that afternoon he would have a spell.
Right.
Hadn't been home.
Sometimes he would have the spells at home and not make it in.
Right. But those days that he was at the office, he hadn't been home. Melody hadn't stopped by and given him a special drink or anything like that. He just had a spell.
Right.
Okay. That's all I have.
I have nothing further for this.
All right, let me step down. All right, y'all are doing outstanding at breaking right at lunchtime. All right. We'll take, let's try to get back up and running at 1:15.
1:15, Judge?
Yeah.
Oh,
A little bit later tomorrow, maybe till 6, to help make up for but we're planning on taking the entire afternoon off on Thursday. All right? All right, you want to step out?
But you believe it to be vomit, correct?
I do.
Okay. And you don't know how old it was or how long it had been there?
I don't.
Okay. Now, did you notice anything else of any significance in that front room? I noticed at least there was at least 2 other cribs or, I guess, beds in there. Did you notice any urine, feces, vomit, diapers, things like that in the area as well?
I don't recall.
If you had noticed anything like that, would you have taken pictures of it and recorded it?
Yes.
Okay. Did you take any pictures of it and record it?
I don't think so.
Okay. All right. And so this was pretty much the extent of what you did in the case, correct?
Yes, sir.
Okay. And did you review you said you went and seized the camera footage from Azalea, if I'm not mistaken. So that was you that went out and picked it up, seized it, and then I guess you forwarded it to the detectives, correct?
Yes. Well, we put it on a computer at work.
All right. So, and does that conclude your involvement in the case?
Pretty much, yes.
Okay. So there's nothing else you did of any evidentiary or investigatory importance at this point. It's pretty much everything that we discussed and talked about here today, correct?
Yes, sir.
Thank you, Officer Schink. I appreciate your time.
Thank you.
Just a moment. Turn to the state. Is there any redirect?
You were asked about blood in the car, and you mentioned something about a spot on the driver's seat fluorescing.
Yes, sir.
Can you tell us what you mean? Or blue star or something like that?
The blue star is a chemical we use to look for, it reacts to the hemoglobin in blood, and it will fluoresce blue. So we sprayed the whole vehicle with it. It's a liquid, and the only part that fluoresced was on the front driver's side seat.
Well, let's take it step by step. You spray the whole vehicle with this chemical, right?
Yes, sir.
Then what do you do? Do you next have to turn off the lights?
Yeah, it's got to be completely dark,
Okay.
or
Then,
as dark as you can get it.
again, step by step. Once you've turned off the lights, what do you do?
Then we spray the vehicle. We would spray each seat, the floorboard, and then see if there's a reaction. If there's no reaction, then we'll move on to another area, and then another area. And if we get a reaction, then we'll photograph it.
Okay. And then what does it mean for something to fluoresce or react on when you spray it with the blue star chemical?
It lights up blue.
Okay. Lights up blue?
Yeah.
Okay. In the dark?
Yes, sir.
It kind of glows a little bit?
Yes, sir.
First of all, this spot on the driver's seat that had this reaction, was it, before you turned the lights off and sprayed that chemical on it, did it appear to the naked eye to look like blood or not?
I don't believe so.
Okay, just like a little spot?
Yeah.
And where in the driver's seat was it?
It would be pretty much right where you would sit.
Right where you would sit?
Yeah.
Like dead center in the driver's seat?
Yeah, pretty much.
And how big was it?
It was just a small, line.
Very small, right?
Yes, sir.
Like almost like a pinpoint or something?
A little bigger than a pinpoint, but not a lot.
Okay. And does the blue star reaction necessarily mean it's blood?
No, it's just a presumptive test.
Now, did you take pictures of that spot before you had turned the lights off and sprayed it with the blue star?
Yeah.
And did you take pictures of that spot with the lights off, glowing blue with the blue star chemical on it?
I did.
And did you make those images available to detectives?
I did.
And is it detectives who ultimately make the decision about what particular things in the case need follow-up?
Yes.
Okay, thank you.
Just one more. And just not to belabor the point, but that was one of those things that didn't need follow-up, correct?
I didn't believe it did.
Follow question on that. Thank you, Judge.
All right. Is there any reason not to excuse this witness?
There you go. There you go.
All right. You are excused, sir. Thank you. Thank you. I think it's a good time for a short comfort break unless you want to. Okay, I'm getting head shakes, yes. So again, we're going to take a short comfort break. You're going to remain here in the jury deliberation room. Don't discuss the case. Don't do any research and meet in this short time. Don't expose yourself to any media or social media. All right? Let's take 15 minutes. We'll be back at 11.
some of the witnesses who the state has requested not be shown. I don't know who's objecting or what the objection is.
I objected initially to 3, but I narrowed that down to 2, Your Honor.
Okay. And who are those?
Let me look just one moment, Your Honor. An objection to Reed not being shown, Your Honor, and also to Brock.
Okay.
And I'm just asking if they not be shown that the state meet the requisite showing laid out in the court's order for the reason for them not being shown.
And what is the reason? Because all I got was the witness list. I didn't.
Yes, Your Honor. I was going to ask if the parties could approach.
Sure.
Thank you, Your Honor.
To give, according to the law, evidence given to the court. So if you had it under the penal penalty of perjury. Thank you. Can I have a seat, please?
Thanks, everyone. So we're going to start with instructions. And again, you don't need to take notes because you'll have these with you in deliberations. And then the parties are going to make their opening statements. And again, you can't take notes during those statements because those are not evidence. But we'll be providing note-taking materials to you shortly. Before the trial begins, there are certain instructions you should have to better understand your functions as a juror and how you should conduct yourself during the trial. Your duty is to decide the case based only on the evidence presented at the trial and the law given to you by the court. Anything you may see or hear outside the courtroom is not evidence. All people deserve fair treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. People make assumptions and form opinions from their own personal background and experiences. Generally, we are aware of these things, but you should consider the possibility that you have biases of which you may not be aware, which can affect how you evaluate information and make decisions. You must carefully evaluate the evidence and resist any urge to reach a verdict that is influenced by any bias for or against any party, witness, or attorney. Personal opinions, preferences, or biases have no place in a courtroom where our goal is to treat all parties equally and to arrive at a just and proper verdict based on the evidence. Do not begin your deliberations and discussion of the case until all the evidence is presented and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices, such as a mobile phone or computer, text or instant messaging, or social networking sites, to send or receive any information about this case or your experience as a juror. We will stop or recess from time to time during the trial. You may be excused from the courtroom when it is necessary for me to hear legal arguments from the lawyers. If you come in contact with the parties' lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or any other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities, to share any information about this case. For example, do not communicate with anyone by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter either in person, electronically, or by any other means. If anyone does so, despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. Evidence is first the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. And third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. You are not required to, but you may take notes during this trial, except during the opening statements and closing arguments. The court will provide you with materials. In taking notes, you must be careful that it does not distract you from carefully listening to and observing the witnesses. You may rely on your notes to refresh your memory during your deliberations. Otherwise, keep them confidential. After the trial, the notes will be collected and destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. You should pay careful attention to all the testimony because you must rely primarily on your memory of the evidence and testimony introduced during the trial. The defendant It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the result of this trial, the witness' conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness' recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness' testimony, the apparent intelligence of the witness, bias or prejudice if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. In this case, the state has charged the defendant with 2 counts. The first count of the information in this case charges that between August 23rd, 1991 and August 25th, 1991, at or near 9070 West Waterford Square in the city of Greenfield, Milwaukee, County, Wisconsin, the defendant did cause the death of Catherine Schrader, another human being, with intent to kill that person, contrary to section 940.01 sub 1 of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. First-degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. First, that the defendant caused the death of Catherine Schrader. Cause means that the defendant's act was a substantial factor in producing the death. And second, that the defendant acted with the intent to kill Catherine Schrader. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you are satisfied beyond a reasonable doubt the defendant caused the death of Catherine Schrader with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. Count 2 provides as follows. The second count of the information in this case charges that between August 1st, 1991 and August 25th, 1991, at or near 9070 West Waterford Square in the city of Greenfield, Milwaukee County, Wisconsin, the defendant did intentionally cause great bodily harm to a child, Catherine Schrader, date of birth July 3rd, 1991, contrary to section 948.03 sub 2 sub a of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Physical abuse of a child, as defined in Section 948.03, Sub 2, Sub A of the Criminal Code of Wisconsin, is committed by one who intentionally causes great bodily harm to a child. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused great bodily harm to Catherine Schrader. Great bodily harm means injury, which creates a substantial risk of death, or which causes serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. Second, that the defendant intentionally caused great bodily harm. This requires that the defendant had the mental purpose to cause great bodily harm to Catherine Schrader, or was aware that his conduct was practically certain to cause that result. And third, that Catherine Schrader had not attained the age of 18 years at the time of the alleged offense. Knowledge of Catherine Schrader's age by the defendant is not required, and mistake regarding Catherine Schrader's age is not a defense. Before you can look into a person's mind to find intent, intent must be found. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that all three elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. The lawyers will now make opening statements. The purpose of an opening statement is to give the lawyers an opportunity to tell you what they expect the evidence will show so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. So, we begin with the state, which has the burden. Mr. Torbenson.
This trial begins with the number 2. There are only 2 people in this entire world that could cause the death of Catherine Schrader. The defendant and Catherine's mother, Christine. Only 2 people in the entire world had the opportunity to abuse Catherine to the point that she ended up in a hospital on August 25th. 1991. Only 2 people in the entire world had the opportunity and ability to silence this child's life at the age of 7 weeks. The last person with Catherine Schrader, before she became unresponsive, on August 25th of 1991, defendant that she's having problems getting Catherine to eat. Catherine wasn't eating all day. In fact, earlier that day, Christine told this defendant that she wanted to take Catherine to the hospital, that something was gravely amiss with her daughter, and it was this defendant who talked her out of it. So, just after 11 p.m. on August 24th, Christine hands her 7-week-old daughter to this defendant. And this defendant says he feeds Catherine. And during that feeding and after that feeding, he says he gives 3 ounces. He gives his daughter back to Christine. And Christine immediately notices her daughter's likeness. That something is gravely amiss. She instructs the defendant to call 911. Catherine was rushed to Children's Hospital by the first responders that came out to the residence. What they found was a pulseless, non-breathing, 7-week-old infant. They worked their hardest to regain a pulse on that ambulance ride to Children's Hospital, Wisconsin. They gave her medication, they gave her CPR. None of it was working. She remained for the entirety of that ambulance ride, pulseless, non-breathing, unresponsive. And you're going to see from the ambulance report that their notes indicate that when they got on scene, 5 minutes after that 911 call, they found what they put in their report as a child that was probably dead. When Catherine was admitted to Children's Hospital, Wisconsin, the emergency room doctor started working on her immediately. She was intubated. She was given medication to try and regain a pulse. And for some time, they were able to regain a pulse. You're going to hear that a CT examination was done of her head. That CT examination revealed that her brain was swelling to the point that the sutures on her skull were separating. That the ridges in the brain were going away because they were pressing against the skull. That she had bilateral subdural bleeding on both sides of her brain, which is caused from rupturing of bridging veins. You're going to learn what bridging veins are through the course of this trial and what causes ruptures of bridging veins. And it's motion inside the head, where the brain is going one way and the skull is going the other way, that causes those veins to rupture and bleed. You're going to hear that there's actual damage inside her brain. You're going to hear that there was subarachnoid bleeding on her brain. Subarachnoid bleeding is highly, highly concerning in this case because it makes the child immediately symptomatic when that bleeding occurs. You're going to hear and you're going to see that Catherine had too numerous to count retinal hemorrhages in her eyes. So many retinal hemorrhages in her eyes that when they opened her eyes on autopsy, you can see it with the naked eye. All the little pinpoint specks of blood everywhere throughout her retinas. You're going to hear that despite the best efforts of the emergency room physicians at Children's Hospital, Wisconsin, she was declared deceased on August 25th of 1991, the very day that she was admitted, just hours earlier. Dr. Carl Leilani is going to be one of the emergency room physicians who's going to come, take the stand, and testify. He's the emergency room physician that declared that Catherine was deceased. He's the first doctor of many that wrote in a report that the cause of her death, the cause of her medical condition, was shaken baby syndrome. You're going to hear from the first responding police officer in 1991 to the hospital. He was called out at 4 o'clock in the morning because the doctors were so concerned about what they saw. got law enforcement involved. His name's David Novi. He talked to the doctors, he talked to a social worker that was involved in this case, and then he met with both the parents independently. And what you're going to hear is that both parents, Christine and the defendant, parroted the same story. That the defendant came home at approximately 11 p.m. that evening, that Christine was having problems getting Catherine to eat until she asked the defendant to feed Catherine. And then they sat on the couch and they did it together. And what Christine told law enforcement that morning was that this defendant was never alone with Catherine that evening. That statement was a statement made to protect the man that had been abusing her. That statement can be looked at in a vacuum or it can be looked at in the context of her relationship with this defendant. And it's a relationship that starts when Christine is at college with her sister. She shares a dorm room with her sister Elizabeth a year before. She's starting to see this defendant. And during the context of that relationship, anytime this defendant is around, Christine, who's otherwise social, enjoys going out with her sister Elizabeth, enjoys going out with friends, her entire life becomes this defendant. Every time he visits college, she only spends time with him. Shortly thereafter, she drops out of college her first year, and they get what's referred to as an economy apartment on First and Lake. That's where the domestic violence begins. Christine, not even weighing 100 pounds, is told that she's fat. She's told that she's ugly. She's told that her family doesn't love her. All by this defendant. He controls who she goes around. He controls who she spends time with. And you're going to hear from the family who had a close, loving relationship with a sister, with a niece, about how that suddenly was removed when she became involved with this defendant. That when they did see her, she had bruises on the inside of her arms, sometimes very large bruises on the inside of her arms, and on other areas of her body. And the family was concerned, based on the appearance of those bruises, about this relationship and what was happening in this relationship. But she was being isolated. She was being kept from her family. She's being removed from her family and controlled by this defendant. You're going to hear that in that economy apartment, this defendant slammed Christine down to the point that she injured her back. That she couldn't turn her head for a period of time. That he was violent with her, that he was abusive with her. That he would punch her in her hair and punch her in her body in areas that would be hidden by her clothes. That she would change her wardrobe, change what she wore to conceal these injuries. And then Christine became pregnant. They moved into the apartment on Waterford. You're going to hear from neighbors, a neighbor that lived in that same apartment building, about the domestic violence that they heard this defendant exert on Christine. So loud it could be heard in a different apartment in the building. You're going to hear that the defendant's own mother was staying with him for a period of time while Christine was pregnant. And in one of these acts of anger, this defendant threw Christine down and sat on her pregnant stomach.
his own mother there to witness it. To the point that Christine calls out for her family and asks for help that evening, only later to retract it. Why? Because of this defendant. Catherine was born on July 3rd, 1991. It's a memorable day, one day before July 4th. It was a happy occasion for most of the family. It was a happy occasion for Christine. I suspect it was a happy occasion for the defendant. Slightly premature, Catherine would remain in the hospital for a few days before demonstrating that she was a feeder and a grower, which means she was a healthy, premature baby. Ladies and gentlemen, August 25th of 1991 would not be the first time that Catherine would be hospitalized. On July 22nd of 1991, this defendant was feeding Catherine. A feeding after which Catherine's entire abdomen was bruised and patterned. A feeding after which Christine said the child needs to go and see the pediatrician. And they take their child, Catherine, to the pediatrician's office. Dr. David Noki, you're going to hear from this, Dr. David Love, you're going to hear from in this trial as well. Dr. David Lowes is so concerned about the bruising that he sees on Catherine's abdomen that he makes a referral and says Catherine should go to the hospital and notifies Child Protective Services, who starts investigating this. It's pattern bruising. You're going to see the photographs of that bruising on her abdomen. This defendant was interviewed by a social worker at the hospital regarding that bruising. And the explanation that this defendant gives is that, A, Catherine had no bruising prior to this defendant feeding Catherine on the morning of July 22nd of 1991. That Catherine started having difficulty breathing when this defendant was administering a feeding, so he flipped her over on his arm and was patting her on the back, and she must have rubbed her stomach somehow on his belt buckle. That is the explanation, that is the excuse that this defendant gives. You're going to hear that Children's Hospital Wisconsin ran a number of tests. You're going to hear ultimately that Catherine was sent back home with the defendant and Christine, only to be back in the hospital a few weeks later. After Catherine's death, an autopsy was performed on her body. The doctor who performed that autopsy, the medical examiner, has passed away. That doctor cannot come into this courtroom and testify. That doctor wrote a report. That doctor had photos taken. There were a number of different experts that looked at the pathology, that child's brain, the eyes. And you're going to hear from the medical examiner of Milwaukee County, Dr. Westwell Swolman, who reviewed all of the work done by that forensic pathologist, independently reviewed the photographs, independently reviewed all of the reports, police reports, the medical history, the medical records for this child, and concluded that Catherine Schrader died as a result of blunt force trauma, and her manner of death ruling is homicide. Dr. Cholmack is not only going to talk about that, she's going to talk about when she sees these types of severe injuries to the brain. She's going to tell you about accidental situations where you can see these same injuries. And ladies and gentlemen, it's not a fall down. It's not a short fall. Where you see the types of severe injuries that Catherine Schrader had in the inside of her head are from significant, massive forces, such as a car accident. A significant car accident. Dr. Tomac is going to talk to you about when and how she sees injuries like she saw in Catherine. This case doesn't end there. For almost 3 years thereafter, this defendant would continue to exert his control over Christine Schrader. Christine. He would move in for a period of time into their parents' house, Christine's parents' house, where he would leave books out with certain titles. How to Get Away with Crime. How to Incriminate Somebody Else. Christine's parents worried about her, knowing that this case was being investigated for a homicide, talked to her about getting a lawyer. And this defendant was so concerned about her getting a lawyer that he wanted to talk with Christine about what she would say to the lawyer about him. In 1994, Christine would finally have the strength to leave this defendant, to get rid of his control. She forced him. So he moved on. In January of 1996, this defendant started courting a woman by the name of Brenda Kowalczyk. She was a model. She was pretty. For a while, she refused the defendant's advances. By March of 1996, they were involved in a relationship. Shortly thereafter, he gave her a pager. The expectation with that pager is every time it rang with his call, she was to answer. Every time he called, she better say where she was. Soon, she couldn't go anywhere without him. He told Christine she was fat. He told Christine she was ugly. He told Christine family didn't love her. In 1996, he's telling Brenda the exact same things. You are fat. You are ugly. Your family doesn't love you. Brenda has a child with this friend. His name is Hunter. You're going to hear about a situation where this defendant was the only person with Hunter in November of 1997. Hunter was in a car carrier. Hunter was hungry. Hunter was fussy. And Brenda went to go make a bottle of Hunter. When Brenda heard a cry that she's never heard before, her son. A cry that tells a mother that something is wrong. She went from the kitchen into the living room to see a bloody rag covering her child's face, and this defendant saying, I don't know what happened. Brenda took Hunter to the doctor, but she didn't report the circumstances of how this defendant left that child. Like Christine, she didn't report that this defendant was alone with Catherine moments before Catherine went unresponsive. Brenda, too, didn't report the circumstances. She didn't report those circumstances because she was being physically abused. She she was being controlled. She was being isolated. You're going to hear that at some point through the course of her relationship, she questioned the defendant about the death of Catherine. In fact, you're going to hear when Hunter was being born at the hospital that this defendant said, "Please don't mention that I have any other children." Why? Well, you're going to hear that when she questioned this defendant about the death of Catherine, that this defendant first said it was a SIDS death. Wrong. Not a single person who has reviewed this case has ever come to that conclusion. Nobody. It's a self-serving conclusion for him. But Brenda keeps pushing. She wants to know the circumstances around the death of Catherine because she's heard conflicting information. A social worker has visited her, warned her. And this defendant becomes violent with her again. You're going to hear about the pattern of domestic violence that existed between this defendant and Brenda. For a period of time, she moved out from him, only for him to beg for her to come back home. She too was left with bruises on her body. She too was isolated and controlled. That wouldn't be the last, though. This man would have a third relationship with a woman named Nicole. Together they had a child named Hannah. Beautiful name that I'm fond of for a number of reasons, including my oldest has the same name. You're going to hear that Hannah, too, was hospitalized after being with this defendant. You're going to hear that Nicole and this defendant, the only caretakers for Hannah, put Hannah down for a nap. This defendant reported that he checked on Hannah and found her having difficulty breathing, vomiting, blood. You're going to hear as a result of this, this defendant being the last person with Hannah, Hannah was taken to the hospital. Hannah was examined by doctors. Let me tell you what the doctors found on Hannah. Petechial bruising on her cheeks. Petechia on her scalp. Petechial bruising on her lower back. A short, narrow, linear collection of bruising on her sternum. 2 parallel lines of petechial bruising on her abdomen. A cluster of petechial bruising over the upper right quadrant of her stomach as well. Petechial bruising under her chin. Multiple small subconjunctival hemorrhages in her eyes, bruising to her eyelids. That's what was observed on the outside of her body. Here's what was happening on the inside of her body. She had a displaced fracture of her first rib. She had fractures of her right ribs, number 4, number 7, and number 8. Her 6th and 7th ribs on the left side were fractured. She had posterior fractures that were healing of the 6th, 5th, 7th, and 8th ribs. She had a CML, or classic metaphyseal lesion fracture of her femur bone, largest bone in the human body. metaphyseal fracture of her proximal tibia. 12 whole fractured bones in a non-mobile infant child. You're going to hear that a child abuse pediatrician examined Hannah and concluded that her injuries were the result of physical abuse. The final witness that you're going to hear from in the state's case is Dr. Lynn Sheets. She's a board-certified child abuse pediatrician. She's a board-certified pediatrician. Her job is to look at cases of child abuse and either say this is child abuse, I can't determine this is child abuse, or rule out child abuse. She was hired by the Milwaukee County District Attorney's Office in this case to review the case of Catherine and to review the case of Hannah. And she's going to talk about the significance of bruising on non-mobile children. She's going to talk about the significance of abdominal bruising and how it's highly associated, if not diagnostic, in a non-mobile child for child physical abuse. She's going to talk about the fractures in both of these children. Because remember, Catherine also had rib fractures that were found in autopsy. She's going to talk about the mechanisms for causing those fractures. Squeezing, compression on the rib cage. She's going to talk about nature and types of forces that are needed to cause effusive head trauma or shaken baby syndrome. But most importantly, she's going to talk about the striking similarities in the injuries to Catherine Schrader and to Hannah Schrader. Those striking similarities in the bruising pattern and the rib fractures are this defendant's signature of abuse on these children. It's him leaving his mark. (33, 3, and 12). If Catherine Schrader were alive today, she'd be 33 years old, 3 months, and 12 days. That's what this defendant took from this earth. During voir dire, a lot was made about Mr. Torbenson. This case isn't about Mr. Torbenson. It's not about facts. This case is about the evidence and who is responsible for the death of Catherine Schrader. Ladies and gentlemen of the jury, I'm asking that you listen closely to all the evidence. And at the end of this trial, I'll ask that you find this defendant guilty based on the evidence you've heard in this court. I thank you for your time, and I thank you for your attention.
Thank you. We'll turn to the defense. Ms. Pakes.
Good morning, ladies and gentlemen. You've just heard an emotional accusation. Accusation is not evidence, and emotion is not evidence. But emotion and accusation are very powerful. And the reason they're so powerful and the reason they're being used so much is because the facts don't fit the crime. And I'm going to go through the facts, and you will hear several discrepancies between Mr. Torbenson's version and the version you will hear that we think you will hear from the witnesses. This case is old. Evidence is no longer available. Key investigators have died. Witnesses have died. Witnesses that remain, their memories are faded. And key pieces of physical evidence have been destroyed. We no longer have the x-rays that were taken. We no longer have the CT scans. There was an autopsy in 1991, and material that could shed light on Katie's position or her condition were not preserved. And that missing evidence does not affect the state's ability to prosecute, but it does affect our ability to defend. There can be no thorough, reliable, independent evaluation in this case. And the ability for independent evaluation is extremely important because this is essentially a medical prosecution. Katie died unexpectedly, and she had medical findings that could not be easily explained. And some of those findings were suspicious for trauma. And because it's an infant, there's a presumption of abuse. There's a lot of room for speculation in this case. So how will the state get from suspicious for abuse to an accusation of first-degree intentional homicide? Because what Mr. Torbenson has to prove beyond a reasonable doubt is that there was a crime. That's his first burden. He has to prove that there was an intent to kill, meaning a mental purpose to take the life of another human being, or an awareness that their conduct was practically certain to cause the death of another human being. It's our position he will not meet that burden. There are no medical findings unique for abuse. There's no magic test for abuse. It's not like pregnancy or cancer or other conditions where you have a test, you look under a microscope. There's a lot of speculation in this case. And whether Mr. Torbenson can prove beyond a reasonable doubt that A, there was the crime that he's charged, and B, that a person did it, it's your decision, and your decision alone, and it's your decision based on everything you will hear in this courtroom. And you have the benefit, unlike the doctors, of listening to all the evidence. So to the extent that we have facts and evidence that have not been destroyed or compromised, here's what the evidence will show. Christine and Ron met in the late 1980s. They married in 1991. It was not a great marriage. Ron was a terrible partner to Christine. They had an abusive relationship. And she got rid of him, as Mr. Torbenson said. In 1994, she moved out. She filed for divorce. She was done with him 6 months later. She entered a new relationship, and she's still in that relationship today. During that marriage, the marriage of Christine and Ron, they had 2 children. We've heard about Katie, the firstborn, who died tragically in August of 1991. And as terrible as Ron was in his relationship with Christine and adult women, you will hear that he was happy to have a child, and he was involved with Katie. He went to birth classes, prenatal visits. He decorated the hospital room with balloons, and he would give Katie rolling kisses. He would grab her and give her kisses. And over the years, the police have interviewed Christine several times, including after the divorce in 1996 or 95, in 1998, in 1999, and yes, she confided to investigators that Ron was abusive to her, but she had nothing bad to say about his relationship with Katie. What do we know about Katie? She was born July 3rd, 1991. She was born slightly premature, 35 weeks. From the records we do have, we know it was not an easy delivery. It was a traumatic birth. They had to use the forceps to pull her out. Her head was swollen from the pressure on it. She moved through the birth canal and they pulled her out. And we don't know whether from that birth there was a pre-existing condition that existed on August 25th of 1991. We know that after her premature traumatic birth, she had trouble breathing and eating. Babies are premature. They apneic or trouble breathing is expected. They had to insert a feeding tube in the hospital. You'll hear mom had a lot of trouble breastfeeding in the hospital, and again at her July 30th visit, the baby was refusing to breastfeed. In August, when Christine's sister visited her, Katie was fine. The only problem mom really had was the breastfeeding. Ron and Christine followed up with all of Katie's appointments. July 12th, everything was fine. Pediatrician. July 17th, everything was fine, again with the pediatrician. Then we come to July 21st. I'll call this the carnival ride. Ron and Christine and Katie get in the car and they pick up Ron's mother, Delphine, and her dogs, her two dogs. I don't know if you can see that. They pick up Delphine and her two dogs. They go for a drive. It's the only picture we have of that time of Ron's mother, the baby, and the dogs. They stop at a festival. They leave Katie in the car, in her car seat with Delphine. Christine and Ron go on a ride. At some point they return. When they return, nothing seems amiss. Katie's strapped in her car seat. After the festival, all of them head to Ron and Christine's apartment. It's a small one-bedroom. It's a small one-bedroom. The baby sleeps in the large room in the corner. There's a bassinet and a crib there. Ron and Christine have their bedroom. There's a couch. When Delphine sleeps over, she sleeps on the couch in the large room. It's a 600 or 700 square foot apartment. It's very small. Christine reported that night getting up several times to feed the baby during the night. Ron said that around 8 o'clock in the morning or so, he changed the baby. He changed Christine. Now, Mr. Torbenson says that Ron's version was he did not see bruising. And what Ron actually said was he didn't notice any bruising, right? We don't know what the baby was wearing. Was it a onesie, right? May have not have noticed when he changed the diaper. We don't know where he was when he changed her. We don't know if the room was dark. Sometimes when you're not looking for something, you don't see it. So he didn't say, I did not notice. He just said, I did not notice, not that it wasn't there. We know after the diaper change, Katie was fed around 8:30, and sometime around that time, she was spitting up milk through her nose, and she was holding her breath, and she wasn't breathing. And because she was premature, you'll hear they were sent home with a suction bulb. Babies that are premature are nose breathers, and sometimes they use it to suction the nose, and they took this suction bulb, and they started suctioning out of her mouth and her throat, what she was vomiting. The mother reported, Christine reported, for perhaps 45 minutes they had suctioned. There was sporadic suctioning and breathing problems. And Katie continued to be irritable. So they take her to Dr. Lautz. And when Katie and Ron are at Dr. Lautz's and the mother removes the diaper, that's when the mother first noticed the weird bruises and abrasions. And here's what they look like. Okay. And it was concerning, so they photographed it. The bruising is superficial. It's not, the internal organs are fine. It's not life-threatening. And she's an infant, and no one has an explanation. And so certainly it's concerning. Dr. Lautz is concerned, rightfully so, and so he sends Ron and Christine to Children's Hospital. So they get in the car, and they drive Katie to Children's Hospital. And they tell Children's Hospital that she started to become irritable the night before, the night of the carnival ride. Children's is concerned. They immediately assign a social worker, and they immediately notify CPS. And the social worker from Child Protection and Advocacy interviews the parents and asks in the past 24 hours who's been around the baby. It's grandma, her poodles, mom, and dad. That's it. Social worker asks Christine and Ron, what do you think happened? They don't really know. Ron's theory is it was his mother's dogs, his mother, or he did it when he was trying to suction Katie and get the vomit out of her throat and her mouth, when he was panicked and handling her roughly. Meanwhile, Milwaukee County Child Protection Services assigns a social worker, an experienced investigator, Erica Doman, to investigate abuse, and she comes to the hospital. At the same time, the hospital is looking to see if Katie has a bleeding disorder. Mom reports perhaps a history of easy bleeding in the family. They run some tests. She has one abnormal result. She's got a low level of what you need to clot, one ingredient that you need to clot, and perhaps she bleeds more than an infant who is normal. At this point, the hospital does not know whether this abnormal result is due to genetics or her age, but she has it, and they recommend that in 6 months she be retested to see if her levels are normal, and she recommends the parents get tested. And that is never done. The reason she has it isn't important. The fact is she knows we know she has this condition, and a question is how does this contribute to her condition on August 25th? At the hospital, while they're investigating this bruising, the blood specialist asks Mom, have you noticed any bleeding with Katie? And Mom says, no. The only incident she can conjure up is maybe a lip bruise from her struggles with breastfeeding. And we don't really have any information about this. There's no photograph. It's not really referenced in the medical records, so we're left to speculate as to what that means. Ultimately, Children's chalks the bruising up to rough handling and the suctioning of the baby, and they send her home with the parents. But now Ron and Christine are under the child protection microscope, as they should be, and they're under the critical eye of suspicious family members. And you'll hear that on August 4th, Ron and Christine leave Katie with Christine's parents to babysit. The next morning, they pick her up on the 4th. The next morning, Christine's mother calls Erica Doman, the CPS worker, and Christine's mother says, I saw a bruise. I saw a bruise on the baby. We don't have a photograph, and we're really left to speculate about what that means. We do know that Erica Doman does her job. She's diligent, she's thorough. The next day, she shows up unannounced at Christine and Ron's work, their place of employment. You'll hear Ron was an outside salesman and Christine worked in the office. When Christine went back to work, she took the baby with her. They didn't have childcare. She was with the baby at work. CPS worker Doman shows up unannounced, has Christine strip the baby, strips Katie naked. No marks, nothing. Christine's sister visits Christine in the middle of August. Katie seems fine, no concerns other than an ongoing difficulty with breastfeeding. August 22nd, 2 days before the 911 call, you'll hear Christine is in a car accident with Katie. We don't have much information about it. It really wasn't investigated. Christine said it was her fault. Her car was hit in the rear. There didn't seem to be much damage. Neither party wanted to call the police. She said Katie was in a car seat. She claimed it was buckled and fastened. We know the investigators got a receipt for the car seat, where she bought it, but that was all we know. August 23rd, the next day, Ron, Catherine, Katie, they pick up Delphine, Ron's mother. They head to Mexican Fest at the Summerfest rounds. They take turns holding Katie. They don't have a stroller. As the evening progresses, Katie becomes fussy, a little upset, wouldn't take a bottle or a pacifier. After they're done at the festival, they drop Delphine at her house around 10 p.m. The next morning, August 24th, Saturday, is a busy day. You'll hear that Ron had a second job at the ground round. He was scheduled to work that day from the noon shift, and he had to get there about 11, and he would work till 2:33 in the afternoon. You'll hear that after later that evening, his plan was to meet a buddy out to watch a baseball game. And so during the day, they go to the video store to rent movies for Christine to watch with her sister while Ron would be out that evening. That morning, Christine drops Ron at work. Later, she picks him up. She talks to her sister on the phone and tells her sister, you know, Katie's not feeling well. I don't think you should come over tonight. They go to the video store and they rent movies for Christine to watch. Katie, Ron, Christine at the video store, they know the people there. They go there often. It's a promotional day. It's a fun atmosphere. There are a lot of people in the store. There's a video game contest. There's a Super Mario Brothers contest. They're playing Pink Floyd in the background. Everyone is smiling and joking. And the videographer captures the moment.
There's the winner. What's that? There's the winner.
What are you doing later? What, you and Chris gonna go out or something like that?
No, he's planning to go watch.
You're so morbid. How do I get it if I stepped all over you? Shoes with me. That's just what I'll do.
So this is the video that was taken Saturday. That was Ron and Christine at the counter, and that was Katie in the carrier beneath them. They rent movies. Later that evening, Ron goes out with his buddy to watch the baseball game. He returns home later that night. Mr. Torbenson says it's at 11 o'clock. It's not 11 o'clock. No one could give a precise time other than between 11 and 12. We know that when he gets home, Christine tells him she was having problems feeding the baby, and she gives him the baby. And you will hear that Ron had a technique where he would squeeze a few drops of milk out of the bottle, he would put it on Katie's mouth, and if she was having difficulty feeding, he could get her to take a few ounces. And he got her to take a few ounces, and they sat on the couch in that apartment while he did that. And after he fed Katie, he handed the baby to Christine. The baby was perfectly fine. In fact, you'll hear later, we'll get to it, but it's a big issue of dispute with Mr. Torbenson's version of events. Christine has never said that the baby was not breathing when she was handed over. We do know from the medical records that 15 or 20 minutes after that feeding, she noticed the baby wasn't breathing. We know that Ron took the baby and performed CPR. He was panicked. He called 911 twice. And when EMS arrives, she's still not breathing. And you're going to hear that was about 5 minutes. And you're going to hear that 5 minutes is a long time to be without oxygen. And they rush her to Children's, and she's still not breathing. And Children's does a lot of CPR on her. And Mr. Torbensen's correct, for several hours. They were able to get her heart started. It would stop. They had to restart her heart several times during those first few hours. You will hear that the brain is very sensitive to oxygen, that the lack of oxygen triggers a cascade of changes. It's called hypoxic ischemic injury, HIE. It just means the brain is sick because it didn't have oxygen. And when the brain doesn't have oxygen and it becomes sick, it will start to swell. And people develop uncontrolled bleeding, which Katie did, and they develop raised intracranial pressure and other complications. Katie is kept alive on a ventilator. You'll hear that her brain continues to decompensate. There's not a normal perfusion or flow of blood. The blood she has gets sludgy, it's congested. She lingers and dies 17 hours later. And as expected, CPS and the police are immediately in the hospital interviewing Christine and Ron about what happened. And Christine brings up the car accident several times to Officer Novy. And she's concerned that this somehow may have had an effect on the baby, on Katie, and may have been in the causal chain of events. The problem is no one gathered any information or specifics. They just wrote it off. We don't know the speeds of the cars. We don't know the distances. We don't know how hard she braked, whether she braked, whether she braked before impact, after impact. Christine reported that Katie was in a car seat, but we don't really know if it was strapped in properly, if she was strapped in properly. And we suspect it was a forward-facing car seat from the description in the records. And in 1991, we don't use forward-facing car seats anymore because they're dangerous. Let's the head move. And what do we know with what was going on with Katie on August 25th? Because Mr. Torbensen's version is she was perfectly fine and then she wasn't. And it happened, and Mr. Schrader must have done something. Well, Christine has described an infant that became progressively more symptomatic throughout the day. She described her as weak and tired. Katie wasn't eating as much as normal. Instead of regular naps, she didn't really sleep. She was kind of listless, not herself. She recalled an incident that when Ron was out with his buddy watching the game, she was changing a diaper and Katie cried out in pain. And as the evening progressed, Katie ate less and less. And by the time Ron returned home sometime before midnight, she said Katie's not eating at all, gave the baby to Ron. So here's the question. What set the process in motion? When was it set in motion? As we sit here today in 2024, we don't know any more than we did back then. If anything, we have less information and more speculation. Mr. Torbensen is charged a crime, first-degree intentional homicide, acting with the intent to kill. And to prove that, he's going to call a child protection and advocacy doctor, Dr. Sheets, and you'll hear that she combed all of the old medical records, and she pulls out every little incident that could possibly be due to abuse. And she's going to come in and say there are 6 incidents, and as a child protection advocate, these events are extremely highly concerning for physical abuse. Incident number 1, what mom described as a lip bruise from breastfeeding. We don't know what that means. We don't have a picture of it. We don't have a description of it. No one else reported it. We don't have a time frame for it. We don't even know if it was a bruise. It wasn't worth photographing, And it could very well be due to what Christine described, a struggle with breastfeeding. To Dr. Sheets, Child Protection and Advocacy, this is a marker of abuse. Dr. Sheets describes 2 incidents. From the 7/22 incident where she had the bruising at Dr. Lautz's, Dr. Sheets says, the bruising, which is pure speculation, she said there must have been a backhanded grab and squeeze which caused those marks. It's unclear how she ruled out the dogs. She doesn't even mention them in her report, and they are mentioned in the medical records. Dr. Sheets talks about this irritation in Katie's throat or in her mouth. She calls it an intraoral ulcer. Again, from the visit with the bruising when they had been suctioning out her mouth vigorously for 45 minutes. Whatever this was, whatever this irritation was, it was not significant enough to photograph. So we don't have any idea what it actually means. We're left to speculate. What we do know is that Children's Hospital found these irritations consistent with vigorous suctioning from the bulb. To Dr. Sheets, it's sign of abuse. Dr. Sheets' 4th sign of abuse is that Christine's mother called social services and reported seeing a bruise. Again, we don't have the photo. And we know that when Child Protective Services ran out to Christine's place of employment and stripped the child down, there was no mark anywhere. But any report of a bruise is a sign of abuse to Dr. Sheets, to Child Protection and Advocacy. You'll hear that on August 19th, Christine was so paranoid about CPS, Child Protective Services, that she called and reported a small bruise on Katie's leg from bumping her on the changing table. Again, we don't have any other description than that. We have no photograph. And Dr. Sheets agrees that could be normal handling, but she considers it a marker of abuse in her report. And on 8/24, when Katie is rushed to the hospital for not breathing, there's a red mark in Katie's eye, a burst blood vessel. We don't have a photograph of it. The records simply note that Mom saw it around 11 p.m. She noticed it around.
Oh, yes. There's a church, went to church with and saw
swapping around the seats on us. Uh-oh. All right, real quick, there was a short issue that came up. Nothing wrong, just I want to make sure y'all, know what the rules are, and if something happens, you let us know, which is what happened this afternoon during lunch break. One of the jurors bumped into, it's probably no secret which one of you it was because he got called out of the room, but bumped into someone that he knew that worked at the district attorney's office, and they chatted, and she saw his juror badge and said, "Oh, you're on the jury," and yeah, I'm going to go get coffee. You want a coffee? No, you can't have I can't talk to you because I work at the DA's office, kind of thing. So that's, again, why we have you wear your badges during lunch. There's many reasons for it, but that's one of the best examples of it. And if anything like that happens, immediately remove yourself from the situation. Let us know about it. We'll take it up. Odds are it's not that big a deal, but we'll address it appropriately and go from there. All right? With that, Ms. Frankis, you can go ahead.
Judge, the state calls Patrick Clark.
All right.
Mr. Clark, if you could stand and raise your right hand, please. Do you swear or affirm the testimony you're about to give in the matter now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat and introduce yourself to the jury.
My name is Patrick Joseph Clark.
Where is it that you work, Mr. Clark?
I work at Boone Foreman.
What, I guess, branch? Which practice of Boone Foreman?
I work in our Mobile, Alabama office, but I was in our Atlanta office for about 22 years.
22 years?
Yeah.
And do you know Gary Farris?
I do.
How do you know Gary Farris?
Gary and I mean, we first met, back before I became a Boone Foreman attorney. We were actually on the opposite side of real estate transactions and just got to know each other over the years. And at a certain point in time, Gary had talked to me about coming to work with Boone Foreman, and at a certain point in time, I did that. So we practiced together, up until his death.
Can you describe your relationship with Mr. Farris?
Yeah, Gary was a good friend of mine, and while we didn't spend a lot of time together outside the office, and there's various reasons for that, we each had our own lives, and people who live in the Atlanta area and everything, you know how it is, commute-wise, and we worked so much that whatever free time that we had, weekends, et cetera, we generally were spending with our families, et cetera. But, we would get together, play golf sometimes, go out and shoot ski, and go, I think we went on a couple of dove hunts together. But, most of our time was spent as friends in the office, going to lunch when it was appropriate. We'd go out to dinner with clients sometimes, and et cetera. But, I considered Gary to be a very good friend of mine.
Did you ever hang out with Gary's family?
Some, yes.
How well did you know the rest of the family?
I knew who all they were. I mean, I knew all their names. I knew Melody. I knew, Chris and Scott and Amanda and Emily. Went to Chris's wedding. Went to Emily's wedding. Gary would tell me what was going on with his kids sometimes, and so on and so forth. So, yeah, I knew the family.
Can you explain to the jury Gary's work ethic, or how often you guys have to work in your line of work?
Yeah, we work a lot. We are commercial real estate transactional lawyers, and we don't do any residential real estate work. It's all commercial real estate. And our practice primarily was representing institutional type lenders in commercial real estate transactions, construction loans, permanent loans, various different kinds of properties, multifamily apartment complexes, industrial buildings, office towers. We oftentimes did what we call syndicated transactions, which involve multiple banks, high dollar, high volume transactions involving what you would consider to be very sophisticated real estate developers, very sophisticated lenders, and it required a lot of time and effort to get those deals done. A lot of time and effort to get those deals done.
Would you work holidays frequently?
Yes, definitely. You know, our clients were very demanding, justifiably so, and you know, our work ethic and the was always, you know, we did and took the time that was needed to accomplish what it was that they were engaging us to do. And our practice, so a little bit better understand that, is our practice was nationwide in scope. We closed deals all across the United States. And again, you know, we were dealing with financial institutions in New York and Boston and California and other places. So oftentimes there would be time frames where you'd be doing a transaction out in California, and they'd be 2 or 3 hours behind us, depending on what time of the year it was. So it wasn't unusual for us to get on the phone with a client 10 o'clock our time, 6, 7 o'clock their time.
To your knowledge, did Gary Farris have any professional enemies?
No. And that's one of the reasons I wanted to try to explain that, because we're not criminal defense lawyers, we're not plaintiffs' attorneys, we don't go into the courtroom. I've been in the courtroom one time in my entire career. And I think Gary probably was in the courtroom a little bit more, but he used to practice some bankruptcy law, so he was probably in there in that regard. But no, our work, our transactions always involved people on every aspect of the transaction who were trying to accomplish the same goal, which was to get a deal done.
Would Gary share with you information about his family and what was going on during certain times in his life?
Not really.
Was he kind of a private person?
Very.
Was he proud of his kids?
Yeah, to the extent that we talked about them.
What about Scott?
Yeah, I remember kind of the first time I ever met Scott. I guess he was younger, you know, maybe in his teens, and I think the first time I ever met him, I had lunch with him and Gary, and he struck me as a young kid, and then I guess he kind of had different jobs. I think I remember that he was selling cars at one time. I think he worked as an auto mechanic, if I'm not mistaken. And then at a certain point in time, he decided to go into the military. And I remember how proud Gary was of that. Very much so.
Were you someone that the family reached out to when his remains were found on July 5th?
Yes.
Did you have an opportunity to speak with Melody that day?
No.
When did you speak with Melody about what happened on July 5th?
My recollection is I talked to Melody not too long after that, and I couldn't tell you exactly what I mean in terms of time by not too long after that. For obvious reason being it's 6 years ago.
Sure.
But I do remember that I did talk to Melody. I can remember I was sitting in my office in Mobile, and my phone rang, and I looked down, and it said Melody Farris, and I was a little bit surprised, but she called me in my office.
And what was it that she was calling you about?
She called me and asked me if I could provide any assistance or information about helping her, I guess, obtain or get access to Gary's capital contribution in our law firm.
What is a capital contribution?
Well, a capital contribution, so in law firms, you have different levels of people who work in a law firm. And our firm is a pretty large firm. We've got 19 different offices, but there's different organizational structures, organizational funds. But the way that our firm works is you have two levels of partners. You have what's referred to as equity partners, and then you have what's referred to as income partners, and then you have associates, right? So the hierarchy is, in terms of the firm structure itself, the equity partners are the owners of the law firm. So it's as if you owned a construction company and you're the owner. Income partners and associates are basically employees of the law firm. So they're W-2 employees. So our law firm, if there's profits at the end of the year, the equity partners share in the profits. So a capital contribution is the amount of money that, as the owner or equity partner in the law firm, that you're required to put in on an annual basis, et cetera, to maintain a certain level of capital for expansion, for needs to meet, upgrades in computer systems and so on and so forth. So it's basically a slug of money that's put in by the owners that's there and available for certain things.
And at any time, do you receive that contribution back throughout the year?
The only time that you receive it back is when you're no longer an equity partner.
Okay. Was Gary?
But you do have to put it in. The opposite's not true. You got to put it in every year.
Right.
So.
Was Gary a partner?
Yeah, Gary was an equity partner.
And did you continue to chat with Melody on the phone after she asked about that?
I did for a short period of time, yes.
What was it that you and her spoke about?
After I had talked with Melody, or as she asked me about the capital contributions and assisting and trying to get it, and I indicated to her that I would do what I could. I really didn't have any knowledge about that because I'd never been involved in having to get a capital contribution back. But I took the opportunity to ask Melody, what do they think happened? And she answered me.
What did she say?
She didn't really respond, in my opinion, to my question. She basically relayed to me, I guess if I think back on it now, what was going on the morning of the 4th of July. And what she told me was that she got up early in the morning or sometime in the morning, and she was blowing off, I guess, the leaves on either the driveway or somewhere around the house with a blower. And she finished that up. And then I remember her distinctly saying, and I know that Gary was there because I could smell cigarette smoke, right? And then she got prepared because she was going up to, I guess, Lake Lanier to spend the day with one of her children, and my recollection is it was her daughter Amanda. And she headed up to the lake.
And did she mention anything about if she went anywhere else before the lake?
Yeah, and I remember this conversation pretty vividly because it just struck me as unusual. She said, and on the way to the lake, I stopped at, my recollection was Target, and I bought a chair. And then she said something that really and she said, and I've got the receipt for that. And I went up to the lake, stayed up at the lake, came back home. She had two girls with her. I think one of them was her granddaughter, and one of them was a friend of her granddaughter's. got back home, went straight to the bedroom and stayed in there the rest of the night because they were tired and they were watching movies. And that was basically the extent of the conversation.
Did you ask her what she did that day, or was this unprompted?
It was unprompted. I didn't ask her what she did that day.
Mr. Clerk, that's all I have for you. Thank you.
Hi, Mr. Clark. My name is John Luke Weaver, and I represent Melanie. Few quick questions. Based on what you just said, did you not call law enforcement in this case? Do you remember that?
I spoke to law enforcement.
Like, you called them. You had something. Yes, sir.
I spoke to law enforcement. I think it was the week after the 5th. I called and spoke with a detective who was the lead detective on the case. And I told him who I was. I told him what I did. And I told him that he and Gary and I did the same kind of work.
Sure.
And the reason I did that is because when most people think about lawyers, they think about people who spend time in the courtroom and people who spend time involved in litigation, etc. And I called them because I had become aware that the incident after finding Gary had become a homicide investigation. And I wanted to tell the detective, look, what you have to do, and I told him, I said, I'm not trying to tell you how to do your job, but you need to know what it is we do. And we spend all of our time on the telephone, and we spend all of our time sending emails. So what you need to do is you need to look at our firm's email system and find out when the last time that Gary sent an email was, and if there's nothing after that, that's where you need to start. And that's what I told him. So that's when I contacted law enforcement. I never said anything to law enforcement about the conversation that I subsequently had with Melody until I was interviewed a month or so ago.
Do you remember when you called Detective Hayes also that there was something, you had a conversation with Chris, that there were some things that concerned you and you brought that up to Hayes? Do you remember that?
I don't know what.
You were discussing something to the effect of you had a conversation with Chris and some of the knowledge and things that he knew, you just thought, well, I think that's kind of concerning and I think you need to know about that, Detective Hayes. Do you remember that at all?
Possibly I did. I don't know that I'm sitting here trying to think about that. I talked to Detective Hayes. Can't remember how extensively I talked with him about the conversations I'd had with Chris. I had gotten a lot of my information
from Chris,
right? Because Chris contacted me to basically let me know what happened to his dad. I wasn't in Atlanta at that time. I had already moved out of Atlanta to Mobile, and he was kind of telling me what happened, and to a certain extent asking me, what do you think we should do here? And so I relayed to Detective Hayes everything that people had told me.
Sure. But you didn't bring up any of this conversation with Ms. Farris?
I did not. I did not bring that conversation up with anyone until, like I said,
about a month ago.
The first time I talked to Detective Hayes, to my recollection, was the last time I talked to Detective Hayes. And nobody in between that period of time until a month or so ago ever got in touch with me. So I guess to a certain degree it was kind of out of sight, out of mind. Maybe I should have called them, but I didn't.
Okay. But you can't remember, would it help to listen to the recording of your phone call?
Sure.
To refresh your memory?
Yeah. I mean, again, it was 6 years ago, and, you know, I don't doubt what you're saying. I don't remember. But I do remember what I was striving to do when I talked to Detective Hayes was to relay information to him that I thought would be helpful in the investigation.
We might need just a minute to get that together.
Well, we'll need to get outside the presence first and then go from there. So, y'all, anything else you want to ask them before we go down that road?
No.
All right, y'all step out. To get information from over there to over here.
From the council table to...
In the future.
In the year 2000, we'll be able to do that. In the year 2000. I'm going to make you all come to the technology conference with me in December.
Just issue an order to it.
I'm exempt.
You might want to know where it is, and then you might change your mind.
Is the
Mr. Fogus had something to do with it, so you know the sound. Well, it's not on the displays, so that's the problem. Yeah, well, it's got to be up. There we go. Now try it.
This is my Mr. Farris, Detective Hayes at the Sheriff's Office.
All right. Let's pause it and tell them what you're doing.
At this time, I'm playing a recording that you made of the phone call that you made to Detective Hayes to help refresh your memory. And Judge, I mean, if you want, I don't have this timestamp and there's no transcript of this, so I'm going to move it kind of forward. It was towards the end of the interview, I believe. Play the whole thing. 17 minutes. What's that? I don't have it admitted, but we'll call this Clark 1.
But I felt like I thought about this over the weekend, and I felt like I should at least relay this information. Gary was my law partner and my friend, and he and I'm assuming, I know that the remains have not been identified, but I'm assuming that that's who we're talking about. Gary's oldest son, Chris, called me on July 5th in the afternoon. And, after I had heard the news from two of our partners in our Atlanta office, and by the way, I practiced in Atlanta for the last 25 years. I just recently moved out of town to one of our other offices. so forth. And then during the course of that conversation, we're talking about his father's death. He made at least one comment that kind of made me think, well, why did he say that? And which was, my parents have been having problems, which I knew. Gary was a fairly personal person when it came to his personal life, so he didn't share a lot. But, when you spend so much time with somebody, you pick up on things and so on and so forth. So I thought that was an odd statement during the course of the conversation. When we were talking about his dad passing away, what he should do and how he should take care of things, that's how his dad would want him to do, so on and so forth. And that was kind of the gist of that conversation. So I hung up and then came into the office the next day. Chris called me back on Friday morning, and we started talking again. And it was at that point in time, see, we didn't know what had actually happened. And when I say we, I'm talking about people at our law firm and myself and so on and so forth. We all assumed that Gary had passed away from a heart attack. We know that he had been having some medical issues, so on and so forth. So during the course of that conversation, Chris started telling me about what happened. And one of the things that struck me as unusual, and I'm going to tell you basically what he told me, he said that no one had seen Gary on July 4th, and that they all went to the lake and came back and still no one had seen him. And then the next day, which would have been the 5th, one of the grandchildren asked where Gary was, and that's when they started looking for him. And his car was there the whole time, his car keys were there the whole time, and Chris said that he and his brother Scott and Gary's wife Melody started looking around and eventually made their way to a point on the property where, and I don't know if it was a permanent burn pit or something else, but a place where they burned things. And Chris then said a couple of things that really made me, and this is why I'm calling you. First of all, he said, my mother went directly to the pit. I felt like she took us directly there. My brother Scott started stirring around in the pit and said, we need to call 911. Don't look in there. So that's what they did. And then, and this is what I found to be really unusual, because, and look, I'm not a police officer, I'm not an investigator, et cetera, but, I watch enough shows on TV to at least think, I have some kind of idea what you guys go through in these investigations. Chris told me, he said, and they told me, he didn't say who they was, they told me that they found a rib bone that had a bullet in it or had been struck by a bullet, that it was a .38 caliber bullet, and that there's a .38 caliber weapon that was on the property that I guess belonged to them that was missing. And I thought about that, and I was thinking to myself, well, during the course of an investigation, I wouldn't think that the people doing the investigation are going to share that kind of information with someone. Maybe I'm wrong. Maybe I'm just, playing, television detective or whatever. But I would think that especially if you were one of the people who was on the property, that that's not something that they're going to share with you. So I found that to be odd that he told me that. Maybe I'm just dreaming things up. Maybe I'm conjuring things up. I don't know. But the more I thought about it, the more I was thinking, well, maybe I better tell somebody about that.
Yeah, and there were probably 15, 20 investigators there at any one time, and Scott was actually the one that pointed out to us, when I say us, detectives, that the gun was missing. Scott had discovered the gun a couple weeks ago. During the course of this, he went back to find it and couldn't. So that's how Chris would have known the gun was missing. And we have not identified the caliber of the bullet, so Chris might be assuming it's a .38 because the .38 is missing. So.
And again, detective, I don't know whether he relayed that to you guys or not, but that's what he told me. So those were the kind of conversations, and I had one more conversation with him after that, which was more along the lines of, he indicated to me, I guess, that they had all hired attorneys and so on and so forth, and I have not heard from him since. I'm assuming his attorney probably told him he doesn't need to be talking to anybody. The other thing that I was thinking about, and I wanted to relay to you guys, and hopefully this will be helpful. Again, not trying to do your job or not trying to play, detective. What Gary and I do, we're commercial transactional lawyers. We don't go in the courtroom. We're not people we deal with primarily with banks, Wells Fargo, Bank of America, BBVA Compass. We represent.
Does that refresh your memory?
Yes, it does.
Okay.
All right. All right, bring them back in.
Yes, Your Honor.
Warm water over there? It is barely comfortable in here.
It is freezing.
I am burning up. I'm about to turn my fan on. No, you touched. I turned it down in the office already. Feel the warm air blowing from All right, ladies and gentlemen, as we get started back, I'm going to take this opportunity just to remind y'all the things I've been telling y'all, and it's just the reason I'm doing it is just because it refreshed my memory as we were doing it, and I figure it's a good time just to have a little chat with y'all again. Normally, when we send y'all in the back, it's very unlikely that you're going to interact with anyone who knows what happened while y'all were in the back, in the jury room. Unfortunately, with the coverage of this case, there are many sites in which you can view the proceedings that are going on right now. And so it is critically important, and that's why you cannot talk to anyone about the case, because they may be watching the case and they see you're a juror. They're going to want to say something, and especially going to want to talk to you about something that happened outside your presence. And there's a reason it's happening outside your presence, because the rules of evidence, although they may seem strange and arcane, and to some extent they are, there are a reason for the rules, and that's why we follow the rules. And so when we're sending you out on the what's about to happen right here, and I'm just going to tell you what kind of happened right here without going into the specifics, but as y'all left, there was a phone conversation with the witness and a detective, and so that was played to the witness so the witness could refresh his recollection. But that's the process. Instead of playing you the message, that's the proper process in doing it. And because it's a recording, we can't show it to him and have him review it, etc. So there may be things that are not otherwise admissible, and that's why we do it outside your presence. And that may come up from time to time and will continue to happen throughout the course of the trial. So that's the whole reason for that, and that's why it's critically important that you not talk to anyone about the case whatsoever. All right, with all that, Mr. Weaver, go ahead.
Thank you, Judge. So after listening to the recording, your memory has been refreshed, yes?
Yes.
All right, and you previously told the jury that you called because your primary purpose of the call, or the only purpose of the call, was to discuss, the nature of being a transactional lawyer. But there was a first part to that phone call, and could you tell the jury what that is?
Well,
let's try to contain what he's talking about.
Let's contain that too, and I asked you, what did you want to call and relay about Chris that you found to be concerning?
I don't know that I was just necessarily calling about Chris, but what I was calling about was things that had been relayed to me from Chris that I found to be concerning under the circumstances based on where the matter was at the time.
Which would have been the 6th, I believe, Friday?
So my recollection is that, and actually thank you for playing that, because it reminded me that the 5th was a Thursday.
Correct. And yes, sir, we have a calendar right here to look at to refresh
Right,
your memory.
not Friday. I think I said Friday earlier, but it was actually, so Tuesday was the 3rd, Wednesday was the 4th, the 5th was the day that they found Gary's body.
Correct.
And so, and I'm sorry, what was your question again?
My question is what did you relay to Detective Hayes about the conversation you'd had with Chris?
All right, so I relayed
to
Detective Hayes that I found concerning some of the things that had been relayed to me by Chris in that conversation. And my concern was based on not the fact that it was coming from Chris per se, but I was kind of concerned about, okay, this is early in the investigation, so where is this information coming from? It seems to me that, again, and you heard in the conversation, based on just common sense and somewhat limited knowledge about police investigations, I always thought that the investigators would hold things very close to the vest and not relay any information to anybody whatsoever, especially somebody like the deceased son who's on the property.
And that information was that he had relayed to you that a .38 was missing in the house, yes?
Yes.
And that a .38 special bullet was pulled from his father's.
I don't know if you said special. It was 38, yeah.
38 was pulled from his father.
Yes.
And Detective Hayes said back to you, we don't even know the type of bullet involved in this case.
In that conversation he did. But he also said that, that the information was...
Said to you.
Well, but I got you. I understand.
Unless prompted.
That's all, Your Honor.
All right. Anything else?
Just briefly, Judge. After speaking with Detective Hayes, you spoke with Chris, and then you relayed what Chris had communicated to you to Detective Hayes. Is that accurate?
Say that again?
You spoke with Chris had called you, and then you relayed what you heard from Chris to Detective Hayes.
Correct.
And the information that Chris was telling you, you weren't sure anyone should know or would know.
Right.
Okay.
I was simply relaying to Detective Hayes what had been communicated to me. That's all I was doing.
And then after speaking with Detective Hayes further, did you have any other concerns regarding that conversation?
No. I was trying to be very factually based in what I communicated to Detective Hayes. I knew that it was early on in the investigation. I myself had just found out that this was a homicide investigation, and I was completely shocked by that because, again, we all believed that Gary had suffered some type of heart attack or a stroke or something like that, and had fallen over and burned up in a fire. And then we find out a day later that no, Gary was killed. He was shot. And so once I found that out, and after information had been relayed to me, I just thought it was important to tell the detective what people had told me. Especially because it was just right there, the 5th.
All right, thank you. That's all I have.
Anything else? All right, you can sit down. Thank you, sir. All right, call your next witness.
State calls Eric Durlacher. Mr. Durlacher, if you could please raise your right hand. Do you swear or affirm the testimony you're about to give in the matter now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may have a seat. And if you could please introduce yourself to the jury.
Yes. Good afternoon. My name is Eric Durlacher.
Mr. Durlacher, what is it that you do for a living?
I'm a lawyer.
Where are you a lawyer?
I'm a lawyer with Boone and Foreman.
What kind of law is that?
We're a full-service commercial law firm with offices throughout the Southeast.
How long have you been with Boone Foreman?
25 years.
Did you have the opportunity to know Gary Farris?
I did. I worked with Gary. Gary Farris hired me at Boone Foreman.
When was that?
I started March 1st, 1999.
And do you work here in the Atlanta office or somewhere else?
I work in the Atlanta office.
Mr. Durlacher, could you please tell the jury when you first heard about Mr. Farris's remains being discovered?
Sure. It was July 5th. I was at work, and I heard the news from Angela Phillips, who works in my office. She was upset, and myself and another attorney in my office took her into a conference room to talk to her, and that's when we heard that Gary's body was found on the burn pile.
Can you tell the jury about your relationship with Gary?
Sure. We were friends. We were co-workers. Like I said, he hired me. He trained me. So we worked closely together for a number of years, and I owe a lot to who I am as a lawyer to Gary.
Would you all share personal information about your families to each other?
Small talk. We would talk about our families, what's going on with kids. My kids were younger than his, so he could be a source of wisdom, having gone through it before. But that was about it.
Can you tell the jury, please, about when you found out that Gary was in fact murdered?
It was sometime after July 5th. I can't remember the exact date, but I can remember it was in the context of that a bullet had been found in his rib.
Who was it that told you that information? That relayed that to you?
I can't remember who exactly told me that.
Like law enforcement?
Just going back, I can't remember if it was someone from the family or law enforcement. I talked to both a good bit during those early days.
Who did you communicate with from the family?
Around that, what I'll call early to mid-July period, I had a number of conversations with Melody Farris, and then I had one conversation with Amanda Farris.
Tell the jury about your conversations with Melody Farris during that time in July.
Sure. We had an early conversation. Melody, in fact, might have reached out to me as returning a phone call that I had placed just to see how everything was going. I'm just trying to think of exactly what we discussed, but it was whether they had heard anything about Gary, what was going on, and like I said, it was, I think that day, later that day that she and I spoke, and confirmation that Gary was found on the burn pile. And she also offered that there was no foul play involved.
When was that phone? Do you recall what date that phone call was?
Yes, that was later in the day, on July 5th. I had spoken with Angela around midday, around noon. She had gotten the news from, I believe, from Amanda, and then later in the day is when I spoke with Melody.
Did you know anything about Gary's spells?
Yes, I knew some about those.
Did most of the people in the office generally know that he would have those moments?
A number of us did, yes.
Did you ever see him have one of those?
Not personally where I saw the spell as if you were to have one right now, but I was around when he was in his office. I knew he was laying down because he was having one.
And did you have a subsequent conversation with Miss Farris after that call on the 5th?
We had a few conversations. We had that first one on the 5th and a few after that. Police were at the house looking through things, had taken the phones. Once she had called me from a neighbor's house. I believe I even supplied her with the name of a criminal lawyer as well.
What was your relationship like with Melody Farris during this time?
Fine, I would say cordial. We didn't spend a lot of time with each other, but we would see one another at firm events from time to time.
Did she ask you any questions about Gary's finances or documents in the office or anything of that nature?
It came up in one of the calls in the context of she did not want anyone to come in to take papers or to go through any affairs, that she was reluctant to have Emily Farris or her husband come in and to do anything, so that her preference was that we wouldn't let anyone into the office.
That's something she expressed to you over one of the phone calls?
Correct.
Did she volunteer information about her whereabouts from the 4th or the 5th?
Yes. She had told me that they were at the lake, I believe all day on the 4th, that they hadn't gotten back until late, didn't think about seeing where Gary was until the next morning when the grandkids were asking where Big Daddy was, which she told me that's what the grandkids called Gary. And it was at that point that they realized he wasn't in the house, and that Chris and Scott went looking to try to find him. His phone and his keys were in the house, so they weren't sure where he was.
After the days following finding Mr. Farris's remains, did you speak with law enforcement as well?
I did.
And did law enforcement ever come to the office and gather documents from the office? Did your firm provide documents as well?
Yes, they came to the office. We met with them. We showed them where the office was. They requested certain documents from us, which we had our IT group help to download from the computer that could be sent to them.
At this time, Judge State would move to tender State's Exhibits, July 1, 2, and 3.
No objection. All right, they're met.
impartial witness, Your Honor. Mr. Derlocker, if you could please review these. I'm going to pull them up on the computer. Okay, I'm pulling up Derlocker 1. What is it that we are looking at here in State's Exhibit Derlocker 1?
It's a stack of papers that's entitled Current Elections and Beneficiary Designations. And when I turn the page, looks like the type of information that we have to fill out on an annual basis for enrollment in our benefit plans.
Benefit plans?
Yes, ma'am.
And are these Mr. Farris's benefit plans?
It says so. It says Benefit Plan Enrollment, Gary W. Farris.
Okay, and these came from your office. Is that accurate?
Yes, I had requested these from HR.
And so these are benefits that Mr. Farris elected himself into.
That's correct. We have a pretty robust benefit plan at our law firm, and so you can buy additional or you get a certain baseline, and then you have to fill out some information such as beneficiary designations.
And do the partners get additional options for benefits?
There's some additional life insurance that you can purchase. That's correct, both in terms of life, accidental death and disability, and long-term disability.
And does it appear that Mr. Farris elected into basic term life, accidental death and policy?
It does appear he paid the premium to opt into the optional accidental death and disability, and as well as the buy-up for the life insurance policy.
Okay. And then he also, it appears that he signed up for an optional accidental death at
Correct.
the bottom. Okay, we're going to move on. Let's see here. Okay, it's a little slow moving. Okay. This next page appears to be the beneficiaries of Mr. Farris's policies.
Yes, that's what it looks like.
Okay, and who is that beneficiary?
It appears there's one current beneficiary, and it's Melody Farris for 100% of the primary percentage.
This appears to be a summary of some sort for the previous year, maybe. And then
It appears so. It looked like the prior page was the 2017 coverage. Looks like this page that you're scrolling through is the 2018 benefits coverage.
okay. So you have to re-enroll into these benefits every year.
That is correct. I think it's in January, but once a year you have to re-up, even if you just want to keep the same coverage or to change it.
And that's typically what people call open enrollment period.
That's exactly right.
And everybody does it at the last minute.
Correct.
Okay. Go to. All right. It It appears that did your firm do the highlighting for the current information?
That I don't know.
Okay. This appears to be when Melody Farris was added as beneficiary in 2012. And then he edited his profile. All right. We will go on to the, so primary beneficiaries here under the profit sharing. Now, what is the profit sharing?
Sure. As a partner in the firm, we're all enrolled in the profit sharing plan where a percentage of the profits are put into the plan, and you can also go up to a statutory maximum each year with your own dollars, but regardless of whether you make contributions, so much of the profit of the firm will be put in on a quarterly basis for the benefit of all the partners.
And this states that the beneficiary effective date was April 10th, 2018, and it was Melody Farris. Is that accurate?
That is correct.
Now I'm going to open Durlocker 3, which is sort of a nice little summary of what we were just looking at. This was provided by your firm as well.
That is correct.
And this breaks it down through your carrier of Lincoln Financial, and it appears to be Gary Farris's enrollment for each term life, accidental death, equity partner, the buy-up, and the optional. Is that true? Is that accurate?
Correct.
Okay. So that just says how much each coverage is, and then this is a separate one down here. Is that accurate?
That's the profit sharing plan, and our custodian of record is Empower.
Okay. And so Melody appears to be the beneficiary of all of those as well.
That is correct.
Can you describe Mr. Farris's work ethic with the firm?
Yes, I'd be happy to. Gary had a sterling reputation in the legal community. I don't know if you've heard this already, but he practiced in an area that's called commercial real estate and worked with a lot of banks and financial institutions. He was incredibly intelligent, responsive, and very practical minded at the same time, which is always a unique combination of skills in a lawyer.
Would the individuals in your firm often work on holidays?
Yes.
Was he fairly prompt with responding to emails?
Absolutely. To be a good lawyer, you have to be prompt in responding to clients.
Give me 1 moment. To these numbers here and the amount of coverage. So for the term life, it appears to be $500,000. Then the accidental death, the group accidental death is another $500,000. The life equity partners, $400,000. So we're at $1.4 million, 1.4. And then the buy up is another $300,000. So that's 1.7. And then the optional accidental death is another 500. So that would be 2.2.
That's right. It looks about it to be $1 million of accidental death and disability. And then in terms of life insurance, it's, what would that be? 1.2.
That's all I have for you, Mr. Durlocker. Thank you so much.
Good afternoon, Mr. Durlocker. My name's John Luke Weaver. and I represent Melody. I want to go back and talk to you briefly how do I turn Megan, how did you turn this? Why it wouldn't be turned on the document. One thing we have definitely established in this jury is technology does not work. Thank you, Michael. Nothing works. Okay, right here, this highlighted portion, we're talking about something in 2012, and it looks like we've moved Ms. Farris from a contingent to a primary. Is that what that means?
That's what it says, yes.
Okay, so that means prior to that, she was not the primary beneficiary of any of his life insurance.
She would be a contingent beneficiary, which means if something were to happen, if one of the primary beneficiaries were pre-deceased, then the residual would go to the contingent beneficiary.
Did you have records, or did you know who was the primary prior to Melody becoming the primary in 2012?
I would assume our HR people have that, but
Okay.
I don't know that.
You don't know. But we do know that as of 2012, she was moved from the contingent to the primary.
That's what this appears to show, yes, sir.
Okay. And I know the jury's loving hearing about all these numbers, but I've got one more question and I will sit down. Can you explain to me how the profit sharing system at Burr & Foreman worked? And what was Gary's percentage? We've never known.
Well, let's see if I can explain it. Yes, each year you can contribute so much of your own money. I don't know in this time period, but maybe it was up to, let's say, $15,000, and then if you were 50, you can do a catch-up every year of maybe an additional $5,000. And Congress sets that amount, and it goes up each year. But then separate and apart from that, the firm will put so much money into the profit-sharing plan. Pretty much an equal amount for all partners. So, for example, my firm just made the third quarter profit-sharing plan contribution. Today I got an email, and it would have everyone's name, and it would show the amount put in on a quarterly basis, and it's the same for each equity partner in the firm.
Okay. So they get every equity partner gets the same amount?
That is correct. And then on top of that, an equity partner can make an individual decision whether they want to contribute some of their own money on a pre-tax basis.
Okay, that's all I have.
I have no more questions.
All right, you sit down. Thank you, sir.
Should I leave the exhibits here or hand them
Yes.
back?
You can give them to Ms. Frankie.
I'll take them. Thank you.
All right, call your next witness.
Judge, next witness is a little lengthy. You want to go with that?
It's just 2:30.
All right.
Let's go a little bit.
Dr. Gooding.
All right.
Sir. Yes, sir.
Ready to break? All right. All good. I just had one of you break. All good.
at 9 p.m., at 8 p.m.? We don't know. All we can do is speculate. But again, to Dr. Sheets, child protection, this is a marker of abuse. And looking through the lens of child protection, you have to take the worst case scenario, right? To protect children. Erring on the side of safety makes sense to doctors and in hospitals, right? They treat it as abuse to protect the child, but it doesn't translate well to a court of law, where you have to listen to all the evidence, and there's a presumption of innocence, and you don't presume abuse. Mr. Torbenson has to prove abuse. Dr. Sheets will talk about the rib fractures. When Katie is taken to the hospital on August 25th, the day of the 911 call, you'll hear that they x-rayed her and she had old rib fractures, and in the same area she had acute or new rib fractures. Dr. Sheets will tell you she takes the position that those rib fractures happened after Katie was sent to the hospital for the bruising on the side. And Dr. Sheets says she knows that because they x-rayed her on 7/22 and there were no fractures. And there's a few problems with this position. And again, she's looking at it in the worst possible case, right? That this fracture is happening after 7/22. The problem is the state did not preserve the x-rays from 7/22, July 22nd. The films were destroyed. Someone looked at those films and determined or interpreted the films as no fracture. They could be wrong. There might be a subtle fracture. Radiology is a lot of subjectivity. There can be disagreement. Two people can look at the same films and have a different opinion. We can't get an independent opinion, so we're left to speculate about someone else's interpretation that they didn't see fractures. But it's easy. They could have verified it. They could have validated. They could have easily found out whether there were fractures on the 22nd, and they do this all the time. There's a standard procedure for it. Dr. Sheets does it all the time. They have a follow-up survey done, a follow-up x-ray. Because if you don't, there can be subtle changes or subtle fractures that can't be observed if they're fresh. If you wait a week and the body starts to heal, you can see them. They're much easier to see. That follow-up survey was not done. What this means is that at the autopsy, when they find old fractures, and they do with a lot of healing, and they do, we cannot rule out that those broken ribs are from the 7/22 event where she had the bruising, the picture you saw up there. But child protection defaults to the worst case scenario. It must be a new injury. And with the new rib fractures, there are some broken ribs, but she had so much CPR that the medical providers are consistent that these are consistent with CPR. Dr. Sheets then looks at Katie's, her history meaning what was going on with her on the 25th, and Dr. Sheets takes the position she was fine, and suddenly she wasn't. And that the event causing her death must have been severe and resulted in immediately and persistent symptoms. This is speculation. And Dr. Sheets says, well, she was not an unrestrained passenger in a motor vehicle. This case is consistent with abuse. But what she doesn't talk about is the fact that Katie was exhibiting symptoms all day long. Something was going on, and we don't know what that was. But in Dr. Sheets' world, child physical abuse explains everything. And it's true, in the hospital setting, they can come up with a theory of abuse to explain everything, but it's an artificial setting. It's not a jury trial, and they don't have the benefit of all of the information you will be provided. And you'll hear from Dr. Twomack, the medical examiner. She'll talk about that based on the information she has provided and the limited information she has, it looks consistent with trauma. That opinion can't be confirmed. And she can't be specific on when, what, where, who, why, how. What we do know is the case was investigated several times over the years. And today we are in essentially the same place we were in 1991. The only difference is it's harder to defend because people, information, and evidence are unavailable. So what new evidence did Mr. Torbenson have when he charged this in 1991? Because he told you yesterday this could finally be proven. Nothing. He talked about yesterday about 3 children being abused. And we talked about this in voir dire. And I'm sure some of you were wondering why we would talk about it in voir dire, but it's because some jurors, child abuse is a very traumatic and emotional topic, and it's not right for some people. And the danger in talking about it in voir dire is that people, when they hear the word abuse, they go to the worst place. They have the worst images or imagination. Well, when you hear about Hunter and Hannah, our position is there's no evidence they were abused, and there's never been a finding they were abused. You'll hear Hunter was born April of 1997, and there was one incident. And it was not in November. Brenda was very clear. It was in August of that year, and it was a few days before she took Hunter to the hospital. You will hear that Hunter, the first 4 or 5 months of his life, was sick. He had reflux, that his stomach contents would flow back up into the esophagus. You will hear that when he was brought in on May 15th for this complaint, the doctors actually observed the reflux in the hospital as it was happening. You will hear that he had fevers and vomiting. He had a hoarse, dry cough, croup. It was chronic. Couldn't seem to get rid of it. That on chest x-rays, he had inflammation, and they called it bronchiospasms, where he would have coughing and wheezing. He would be treated with inhalers and fluids and medication and improve. And according to the medical records of September 12th of 1997, his doctors also noted that he had an occasional cough that would produce sputum, sometimes with blood in it. And he grew out of it. There is nothing concerning for abuse. Hannah. Mr. Torbenson talked about Hannah. Hannah, when she was born in November of 2004, had an older sister, Haley. And Hannah was born 31 weeks. She was very premature. She was in the hospital for several weeks. She had breathing disorders. She had weak bones, brittle bones. They could see this. And she was fussy when she was in the NICU, when they would manipulate her or move her around, when they changed her diaper or her clothing. When they released her to Ron and Nicole in December of 2004, approximately a month later, they released her home with an apnea monitor because she would stop breathing when she was in the hospital. The apnea monitor is a strap that you put around the baby and you tighten it, and it senses whether they stop breathing, and it sets off an alarm if they do after so many seconds. Ron and Christine noted that as in the hospital, when she was fussy, when she was moved, it continued when she was at home. To them, it was normal. They didn't think anything of it. They take her to the pediatrician on the December 31st. Everything's fine. They take her to the pediatrician on January 5th. Everything's fine. And then on January 7th is when she's not normal. She's vomiting up milk. There's some blood in it. She's got secretions in her nose, and they start suctioning out her nose. And they're panicking. They're flipping her over. They're hitting her in the back. As they're suctioning her nose, blood is coming out. You'll hear this area is very sensitive, and she's bleeding. And they rush her again. They call 911. By the time the police get there, Hannah's fine. She's not non-responsive, but the officer is concerned, so he takes her and he pats her on the back. They take her to the hospital, and they do x-rays, and they find broken bones. The problem is we don't know when they occurred. And they recognize that because of her condition, because of her prematurity, she does have weaker bones. And we know that there are some older ones and some newer ones. And we don't know if some of them were from the hospital, and she's got them on the ribs. And in the hospital, they did look at her rib area. And she didn't have rib fractures in the hospital, but they didn't look at her legs. And so the area on her legs where they're claiming there are fractures, because again, we don't have the x-rays, we don't have any of the scans, we don't have the person who interpreted them. So they're describing what appears to be these fractures. We don't have the actual evidence to look at, but they think there's something there, and that's all we know. We can't really say anything more about it. We know in the hospital she had significant nasal congestion, and they continued to suction her. And she was eventually released. So that's what Mr. Torbenson has, emotional fodder with the child abuse. Our position is there is no child abuse. So what else? What else does he have?
The answer is absolutely nothing. Justice delayed is justice denied. That's an old legal maxim attributed to Prime Minister William Gladstone from England. It came into our lexicon, it came into our usage in the 1960s when the great Reverend Martin Luther King uttered the words, "Justice too delayed is justice denied." And the maxim just means if something can be done at a time when everything is fresh and new and in people's minds and all the evidence is in, then do it. That's not what happened here. That's not what happened here at all. Everything that Mr. Torbenson talked about in 1991 about poor Catherine, and just, I want you to know that our entire team over here takes this case very seriously, and I don't want you to interpret anything we ever say or do to belittle or deny the tragedy that took place on August 25th, 1991. Katie died. There's two parents of Katie, Ron and Christine. They're both in this courtroom right now. That's the number two that Mr. Torbenson was talking about. There's grandparents, there's aunts, there's uncles, there's cousins, there's friends, there's family. And our thoughts and prayers go out to all of those people, because this was a tragedy. But everything, the good thing is, your county, Milwaukee County, has wonderful municipalities with excellent law enforcement personnel. And the Milwaukee County District Attorney's Office is supremely blessed with hundreds and hundreds of assistant district attorneys since 1991. Tens and tens of deputy district attorneys since 1991. And two phenomenal district attorneys. E. Michael McCann was the district attorney when this happened in August 25th, 1991. He was the district attorney in Milwaukee County from 1969 to 2007. And some would argue he was the finest prosecutor in this nation. And no one would dispute the statement that E. Michael McCann was one of the great protectors of life that ever served public office in Wisconsin. And the phenomenal law enforcement in Milwaukee County, and all of those district attorneys in Milwaukee County, assistant district attorneys and deputy district attorneys, and E. Michael McCann himself, who was succeeded in office in 2007 by John Chisholm, another phenomenal district attorney. None of those people made the decision to charge this case.
Judge, objection, can we have a sidebar?
Yep. Objection sustained. Let's continue, please, Mr. Glenn.
The case was brought in 2021. Nothing is new. I am going to reserve a piece of my paper over here for Mr. Torbenson. And the challenge is for him to come over here and write down any new physical evidence that has occurred regarding the intentional homicide or the child abuse of July of 1991 and write it down right here. Because I submit to you that the answer to the question is there is no evidence. All the testimony that you will hear from today and tomorrow and the rest of this trial is that nothing has changed since 1991. There's no new evidence. But what Mr. Torbenson has done is, in his opening statement, he talked for 50% of the time, almost 15 minutes, about the other acts. Deplorable accusations. That's what they are. They're not charged here. They're not charged here. And there's a jury instruction that you'll hear about that goes to this. It's called Other Acts Evidence. You're going to hear a lot of evidence about physical abuse, domestic violence. You're going to hear about bad relationships. You're going to hear about all of that. That is brought here for emotional appeal.
Judge, I object. That's argumentative. I filed a motion and a court found it admissible under the law.
Sustained. Let's move on, Mr. Glenn.
Another judge allowed that. But what I'm going to tell you about is I want you to listen to this case, listening to the other acts evidence and the emotional appeal that comes with it. And the judge will instruct you that you may not consider this evidence to conclude that the defendant has a certain character or a certain character trait, and that the defendant acted in conformity with that trait or character with respect to the offense charged. You can't just say, when you hear something about Mr. Schrader, that therefore he's guilty of these two charges. And I submit to you that there is no new evidence in 1991. There's not any new DNA. You won't hear about any DNA analysis of information. There aren't any new fingerprints. There's no new evidence that was discovered. All we're going to find out is that in 1997 there was a bad relationship, 2004 there was a bad relationship, and try to get that. I've been around long enough, and it's not my first rodeo, to know that that's a really tough ask. This is emotionally strong information. But that's the law. I trust that you guys answer our questions honestly while here. We'll be able to utilize that. You've taken two oaths, and you'll be able to utilize that. So the evidence will come in. Make sure you distinguish between 1991, 12,090 days ago, 33 years ago, and what happened since then. The only allegations are 1991, and it's specifically first-degree intentional homicide and physical abuse of July 22nd. Thank you very much.
Thank you. Right, everyone, that concludes opening statements. This time I'm going to order the sequestration of all witnesses, and we're going to distribute note-taking materials. Jurors, how are you doing? Does anyone, we're going to be breaking for lunch in about 45 minutes. Does anyone need a break before then, or are you, okay. All right, we're going to take about a 10-minute break. All right, everyone, thank you.
we'll wait for you, or I'll send everybody back out. All right, go ahead.
Please, the court counsel, this time the state calls Dr. Alice F. Gooding. Dr. Gooding, raise your right hand. Do you solemnly swear affirm the evidence you're about to present in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead and have a seat. Thank you for being here today. Dr. Gooding, state your full name for the record, if you would.
It's Alice F. Gooding, Gooding.
Dr. Gooding, what is your title and what do you do every day when you're not in court?
I'm an associate professor of anthropology at Kennesaw State University and the forensic anthropologist for the state of Georgia at large.
And how long do you teach classes every day? Is that something you carry a full caseload, or how do you do?
Being a professor is my full-time job, except for classes canceled today.
Now, sometimes you do forensic skeletal recovery and analysis. Is that right?
That's correct.
How did you get into that? What got you to do that? Was it an interest you had in a young age, or did you pick it up later in life, or what got you into this type of work?
I wanted to be a medical doctor, but I didn't want my patients to talk back to me.
Fair enough. If you don't mind, just tell the jury your educational background through whatever degrees you have now.
I got my bachelor's in anthropology at Occidental College in Los Angeles, my master's in archaeological resource management from the University of Georgia, and my PhD in biological anthropology from the University of Tennessee, and I'm a board-certified forensic anthropologist, number 160.
And what is your doctorate degree in?
Biological anthropology.
And how many years total were you actually in a classroom or school setting?
After high school?
Yeah, so 4 years undergraduate, and how many years after that?
Some quick math would be probably close to 10.
And how many people actually do what you do for a living? What you're testifying to today?
For reference, I am the only forensic anthropologist in the state of Georgia, so very few.
And how long have you been doing that here in the state of Georgia?
This is my 10th year.
Do you travel anywhere else for your job when you're an expert?
I have traveled, but only when the jurisdiction is in Georgia and the case is tried somewhere else.
Typically, just in a nutshell, what kind of things do you do in your line of work?
On the forensic anthropology side?
Yes. Mm-hmm.
My responsibilities are to sometimes recover remains at a scene. In a lab setting, they are to analyze the remains, inventory them, and analyze the presentation in front of me.
To do your work outside just having the formal education, is there anything else that you do to have the skills and knowledge in order to be a forensic anthropologist?
I attend continuing education courses, yearly scientific conferences, do scientific work that's published in journals, and present at scientific conferences.
And what is a forensic anthropologist?
A forensic anthropologist uses skeletal biology to learn who someone was based on their skeleton and what happened to them.
And how do you go about gaining the knowledge and what you do trying to identify the skeletal remains? Is that a lot of, did you have not just book knowledge, but hands-on practical experience and training with that?
That's correct.
So tell the jury about that, how you learn to do your job.
A lot of my classes and training are hands-on in nature with case analyses, peer-reviewed reports, things where you get feedback on the physical work that you're doing.
I know you said there's not many people that do your job, but is there a branch of the science that you do that's related to what you do, but not necessarily your expertise, but is kind of in the same area?
Biological anthropology is the larger subfield under which forensic anthropology falls.
And do you know how many people total in the United States do something similar to what you do?
Probably a couple of thousand.
Do y'all have conferences or any professional organizations that you're a member of?
Yes, that's correct.
All right. What type of things would those be?
I'm a member of the American Academy of Forensic Sciences, the American Board of Forensic Anthropology, the American Association of Biological Anthropologists, the Georgia Academy of Science. I think that's it.
Have you ever been called upon, whether it's in some type of legal case or criminal setting or a trial setting, to give opinions, expert opinions in forensic anthropology?
Yes.
How many times have you been deemed an expert in our course, do you know?
5.
Just this time I tender in Dr. Goon is an expert in forensic anthropology.
No objection as to that.
All right. She's deemed to be an expert. As I've told y'all, she can testify to things that are, give her opinion as to things in her area of expertise. All right, go ahead.
Okay, we've got the foundation now, so let's talk about really, when it comes to forensics anthropology, when I say forensics, what does that mean to you?
Forensics is a large field of different scientific subdisciplines like blood analysis, fingerprint analysis. My specialty is just the bones.
And when you combine that with anthropology, how does that in a practical sense come out in your everyday life? Do you work with law enforcement? Do you work with other agencies when trying to figure out when the remains are found, what they are?
I work on a contract basis, which means when the Georgia Bureau of Investigation has a case that is primarily bones, the medical examiner will review it and then reach out to me to do an anthropological analysis.
Now, as a PhD doctor, you don't have a badge, you carry around a gun or anything like that, do you?
I do not.
Are you separate and independent of law enforcement?
That's correct.
If you go to a scene and you're working with law enforcement, do you have your own protocols and procedures that you follow to be objective regardless of what they do?
That's correct.
Would you have any problem whatsoever with telling law enforcement, stay out of my lane, or disagree with them when it comes to your science and what you do?
I do not.
Okay. But do you work well with law enforcement?
Absolutely.
Are you involved at all with training law enforcement or giving continuing legal education classes with law enforcement agencies and state workers in this area?
I do.
Do you work with crime scene investigators at times or teach them?
I do.
What type of teaching or things do you do with people like that? Is there anything that you do every year, or is it kind of just on when they need something, they ask you to teach it?
Every year at Kennesaw State University, we offer a training series for law enforcement, coroners, medical examiners, crime scene technicians, anybody in the medical legal field. We teach them to recover bodies from clandestine scenes, which is anywhere that you would not expect a body to be. And we cover the training from classroom all the way out into the field. So we have a field-based learning experience for them.
I would imagine, is it not at times that your objective when you're brought in as a scientist may be different from what law enforcement is trying to achieve at a scene? In the sense that scientifically, when you're not interested in per se catching a suspect or someone that did this. When you're called to this scene, is it kind of a very particular task they're asking you to do, or a very small part of their case?
That's correct. I have no, it's outside the scope of my science to be interested in perpetrators.
So you're not involved in the interviews with people or trying to identify suspects or chase people down or apprehend anybody. You're just really based on the location of the loci, what is there in the remains usually in a case?
That's correct.
Now, did you know the officers in this case that they took, I believe, a class of yours, and that's how they remember to call you?
Yes.
And I want to talk about case specifics in this case. Do you remember when you were called and what date that was?
It was July 5th, 2018.
Do you remember who called you or how you were called into the case?
Sergeant Shaw of, I believe it's Cherokee County Sheriff's Office, probably placed a call or a text to me to request my assistance on a case.
How often during the year are you being called out on things?
Less so than I used to be. It used to be a couple of times a year, but I've out-trained myself a little bit. They don't need my help as much.
Do you, when you do this type of work, if you can just tell the jury, if you were called out, let's say you were just called out to any scene, what things do you take with you? First of all, how do you get there? Do you have your own vehicle? Do you have tools and things that you take to the scene? What's that like?
I have a personal vehicle, and I have a large trunk full of equipment and supplies that I bring myself.
Do you ever take anybody with you when you're doing scenes?
Sometimes I do.
I think in this case you had some interns or some people that were working with you. if you remember.
I don't remember I don't recall that I did, but I may have.
I want to look at a couple of dates in this case. I've got, and do you have a copy of your report?
I do.
Which one? Just this time I'm going to tune your evidence, Gooding 1 through Gooding 120, 120 exhibits.
All right. Any objections?
No.
All right, they're admitted.
I think you've got yours. I'm going to have these two. So they'll come up on the screen. All right, let's look to go through the case. I think July 5th of 2018, I believe you arrived at the scene at 2155 Purcell Lane in Cherokee County, Georgia, about 6:30 p.m. Is that right?
That's correct.
And then the other 2 days I want to go through when I think you did the inventory and analyzed Gary Farris's remains, and we've stipulated that it is Gary Farris's remains, so just want you to know that.
Thank you.
July 17th and July 23rd, 2018. Is that right?
That's correct.
So July 5th and then July 17th and July 23rd of 2018. When you go to a scene, I think you have certain methods that you follow in what you do. Is that right?
That's correct.
I want to ask you about, is it typical when you go to a scene, I think your report talks about there's a rake, screen, surface survey, and then a grid, and then you map and record, and then you do a recovery. Is that kind of the procedure that you do?
That's correct.
Well, what is raking? Is that the first step, or is there a step before that?
There is usually a just gross observation, meaning looking around. I would count that maybe as the first step. But then secondary to that, yes, would be raking up material in the surrounding area.
What is raking? What does that entail?
Can be using tools, including actual rakes like you would use for leaves, or hand raking, in which you use your hands to kind of scrape material together.
And that's just trying to find any remains or any evidence or items of interest?
Usually around the perimeter of what you have observed as the main site.
And here in this case, at the location, you're looking at a fire pit, is that right?
That's correct.
And then after raking, you do a screening. What does that consist of?
Screening is when you use your eyes to visually screen the material that you've collected to see if there's anything of interest.
And after screening, I think you can do something called a surface survey?
That's correct.
And what is that?
That, again, using visual methods to look over the area and indicate, in this instance, using pin flags, which are small flags you may have seen near electrical lines or sewer lines, using those to flag or indicate areas of interest.
Once you figure out the location and the interested location, once you get it kind of surveyed, then you at some point do a grid, is that right?
That's correct.
Tell the jury what a grid is, and in this case, I know it's going to be A, B, C, D, but what do you do there?
A grid is a cordoned off area that you've identified as of interest. So you put up stakes in some sort of rectangle or square shape, whatever is fitting for that situation. String up some twine to indicate that that area should be kept away from in terms of walking through or anything like that. And then I use a quadrant system where I divide the grid into 4 quadrants so I can keep track of what material comes from what area of the larger grid.
And then after you form that grid, I think there's procedures and there's a mapping and recording that takes place?
That's correct.
What does that consist of?
When remains are identified or other things of interest, items of interest, they are mapped, so they're measured from an X and Y. If you remember from maybe elementary school, an X and a Y on a graph, we can actually measure from each of those lines and come up with a coordinate or a point of the location of that material.
And Doctor, are you very systematic in this process? Is it a slow and deliberate process at times?
It is.
And does it take quite some time?
It does.
Do you remember how long you were at the scene?
Approximately 6 hours.
And then finally, I think you get to the recovery of remains. Is that right?
That's correct.
And what does that process look like?
The recovery of the remains is usually done by only a select few people to limit the amount of traffic through that cordoned off area. The human remains in this case would have been removed and set aside, and then the debris from underneath them removed and screened until no more human remains were recovered.
Is it kind of like peeling an onion? You just go down and down and down and down, or scraping different surfaces until you find no more remains?
Yes, that's correct.
And after you go through the physical ground and layering, if you would, then you do an inventory and a session or analysis, is that right?
In the laboratory setting, yes.
So July 5th, you do all the steps up to the recovery, and then after that, from July 17th and July 23rd, that's when you do the inventory and analysis. Is that
That's
fair
correct.
to say? All right, let's walk through the photographs. And I probably will move pretty fast because I think a lot of these are going to be in already. This is Gooding 1. Tell the jury what this is and what significant it is in your case.
This is a map of the grid and the 4 quadrants, the A, B, C, and D, over the fire pit with the human remains indicated by those boxes that have the names of the bones in them.
So we have quadrant A, right top, quadrant B, bottom right, quadrant C, bottom left, and quadrant D, top left. Is that right?
That's correct.
Is it called the datum or datum?
Either's fine.
Just tell me how you call it.
I call it a datum, but that's because
Let's go with datum then.
From around here.
My accent may call it something different. What is the datum?
A datum is the highest point of elevation. So in this map, it's listed as 0 inches. And then anything measured below that will be a negative number. So it gives you a sense of the depth, where the X and Y measurements gives you a sense of the location.
And directionally, north, south, east, west, would it be north be top? Is that what we're...
The north arrow on the left side of the screen is pointing top.
So
a little
this
bit of an
direction a
angle.
little bit.
That's correct.
All right. For the most part, though, north is up here, and then kind of as you look at it. Is that right?
That's correct.
All right. Gooding 2, what is this here?
This is the fire pit scene, specifically quadrants A and B. A is on the top portion, and B is the portion of the picture that's closest to you.
And Dr. Good, I'm going to go kind of fast through the photographs, but if you see anything that you want to talk about, just stop me and point it out, and we'll do that, okay?
Okay.
3, just another angle of this. 4, close up. 5. And 6, as we go through, these are just some of the things that you collected from the quadrants, is that right?
That's correct.
And at some point, I think it was described as an eraser, but the bullet in the ribs, tell us about that.
Yes, you can see it on the prior photo, number 6, and then the other side of that mass, the kind of orange colored, does look a bit like the end of a number 2 pencil eraser, but that is a projectile.
When you first arrived at the scene, did law enforcement, did you know what you were dealing with at that time? I don't know if the bullet was found at the time you arrived or anything talking about that, or was it while y'all were actually processing the remains?
That's my hand and my photograph.
This is 9, 10. And I took this from your report, Gooding 11. What is this?
This is a diagram, a schematic of the front and the back of a human, and it shows the area from which the bullet was found in the remains in this case.
And it was, looking at this diagram, I think you talk about anterior to posterior. What does that mean?
Anterior is the front of your body, and the posterior is the back side of your body.
And you found the bullet to be going from anterior to posterior, is that correct?
That's correct.
Gooding 12, just some of this will be at the GBI, so not on the 5th, but on the days that you analyze it, is that right?
That's correct.
Do you remember about approximately how much in weight the remains there were?
I don't remember if they were weighed. And if they were, that would have been the medical examiner.
Were there degrees, different varying degrees of damage or heat and fire damage upon the bones?
There were.
Tell us about that if you could.
When a fire burns unevenly, which is common to most outdoor fires as opposed to a commercial crematory oven, the fire will burn the body in an uneven manner. Human bodies are also uneven in the way that they're built in terms of where the fat and the muscle and the bones are. So in some areas that have very little fat and muscle and tissue, the high heat may burn right through to the bone. In other areas where there is a lot of muscle tissue, you may see that it's black and charred, but there might be some soft tissue remaining underneath.
When it came to this fire, did you find that the fire itself was I guess a significant fire in the sense that it has not just one that just went up for an hour or so and then went out? Was it more significant of a...
I'll object to that. That's outside our expertise. About the fire in particular itself.
Judge, I think she's a forensic anthropologist. She can give her opinion about fire and the remains.
They also got another expert who's coming in to testify about the fire, so I think it's that expert.
Ask her to what extent she knows, and then we'll go from there.
To what extent do you know about the size of the fire, the magnitude of the fire?
The only, within the scope of my knowledge, the only thing I can say about the fire is the temperature, which was taken at the site, and the consistency and presentation of these remains are consistent with a fire of about 1,000 degrees Fahrenheit, which is listed in the report.
All right, in your report, there was an actual measuring temperature of the center of the pit, is that right?
Yes.
And what was the degree in Fahrenheit that you found this to be?
230 degrees.
And
That was by fire personnel, not myself.
Right, but that was the measurement, 230 degrees Fahrenheit?
That's correct.
And would that have been taken prior to your arrival or sometime when you arrived?
It was noted that it was there, taken when I was there.
Okay. And then dealing with, I'm going to come back to this, but based on the objection, when it comes to thermal damage, you opined about the charring and black discoloration was observed throughout the present skeletal remains. Is that right?
That's correct.
And based on that, what was your conclusion?
That the remains had been burned.
And he said that these characteristics are consistent with the fire reaching what level in Fahrenheit again?
About 1,000 degrees Fahrenheit.
As you pulled the physical remains from the fire, did you notice that it appeared to be burning more so in one location of the grid as opposed to other locations?
The majority of the remains and the burning was taking place in quadrants A and B.
So top right, then bottom right. Is that correct?
On one of those prior pictures, correct.
When you're piecing together the remains, and I'm sure as an expert you quickly can realize certain pieces of bones or certain things, but how long does it, in the condition that you found these remains, how difficult was it to analyze and figure out what exactly the bones that you could determine to be?
Would have taken a couple of hours.
And how do you do that? Is it visually or do you do microscopes or how do you?
It's a visual observation.
Is there any reason that there will be some bones that are more intact than others that you found in this case?
Again, that has to do with the amount of muscle and fat and skin that's over the remains. It's harder for the heat to get to them. For some areas that have less tissue or the fire isn't as hot in that area, you may see some more fragmentation.
And we see here that when you go through and take pictures, you're putting like bones to like parts. Is that how you organize them?
That's correct.
And here we're looking at Gooding 53. What is this a picture of?
This is a picture of the block of burned tissue and a portion of the ribs and the projectile found within them.
And then 64, is that just the projectile from the ribs?
That's correct.
And when you were able to gather remains of head bones and things like that, did you try to piece it back together to see if there was any injuries or anything you could locate?
Yes, I try to reconstruct the bones of the cranium or the head as much as possible.
And here, Gooding 96, is that what we're seeing?
That's correct. This is the left side of the top portion of the cranium.
And why do you try to reconstruct the cranium?
The objective is to see if there's any other sort of trauma to the cranium that the fire may have obscured.
Typically, do you find in cases like this that there are certain bones that remain, assuming there wasn't a destruction to the bones, like something had broke the bones or something like that, but in a fire like this, is there a reason that you would find more of the bigger bones as opposed to other bones?
A lot of the bigger bones are encased in more muscle and fat and tissue.
And you did find some soft tissue remains?
That's correct.
And you wrote a report, in this case, is that right, that we provide to the defense?
That's correct.
And did you share your findings that you had in this case with the GBI and Dr. Atkinson, the medical examiner?
I did.
What I'd like to do is some questions about your report. When you were looking at the, when you're looking at the remains, did you find that there were other material in the burn pile besides just human remains? For example, burned trash, household debris, things like that?
That's correct.
Was there evidence that there was also wood or other material there in the pile?
Yes.
And were you able to sift those out and separate them?
They were separated from the human remains.
And the state of preservation for the materials that you found in this, what did they range from? In the sense of the charring or the powder substance, what level did you find that they consisted of in the burn pit itself?
In the pit, you saw different colors, white, ash, blues, grays, black charring, so all different types of burning.
Out of all the remains that you were able to recover on scene, how did y'all transport those to the GBI to be analyzed?
That's a question for the coroner.
Did you get those, were they packaged in a certain manner, a certain number of body bags or a certain number of containers?
I believe they were packaged in brown bags.
I'm looking on page 2, your last paragraph before skeletal analysis.
3 body bags containing brown evidence bags and cardboard boxes.
And then when you did your analysis and you did the skeletal inventory, I want to talk about the trauma analysis that you did. You have a section called perimortem trauma. Tell us what your finding was for this.
The perimortem trauma in this case was a minimum of 1 gunshot wound to the left chest from a front to back direction.
And you have I guess it's the Latin, the bullet was lodged in situ. And what is that?
In situ means in place or found as it was.
And what findings did you find for thermal damage in this case?
That the remains had been burned on a bonfire, excuse me.
Did you find any traumatic fractures of any?
Fractures were all indicative of the burning.
Any traumatic fractures observed on the cranium?
All indicative of the burning.
And I think you noted when it came to the traumatic fractures for the cranium, I'm looking at your last sentence in thermal damage. What was that finding there?
No traumatic fractures were observed on the cranium aside from heat-induced damage.
So outside of the heat, nothing else?
Not that was observed.
You have a section for antemortem skeletal change and identifying characteristics. When you tell us you didn't have any findings of that, what does that mean?
Antemortem skeletal characteristics are those that you have on you in life that make you unique. For example, if you have a disease or you have anything that sets your skeleton apart from someone else's, that's where I would note that in the report, given the fragmentary nature of the remains and how burned they were. None of those characteristics were able to be noted.
And then looking on page 6 of 24 of your report, as you see on the screen there, you went through and I guess analyzed and then cataloged what you found, the remains that you found in each coordinate or unit. Is that right?
That's correct.
And is this just a listing of the things that you found?
That's correct.
And again, most things, so this first column here is Unit A, and it's evidence bag 1, and then you list the things that you found there on the right side. Is that correct?
That's correct.
And then the next section is E2, which continues to page 7 of your report. and then E3, E4, and E5 in Unit B. So again, the most that you said were in coordinates A and B.
Of human remains.
When you were processing this, how long did it take you before you realized that you were dealing with human remains at the scene?
Instantly.
I'm on page 16 of your report here. This is figure 11, I think. And tell us again, what are we looking at here?
We're looking at a top-down view of the section of burned soft tissue and ribs. I think I refer to it as a block of tissue in which the projectile is situated deep to the ribs, which means closer to the gut side as opposed to the skin side.
As we see in figure 11 here on page 16 of your report, Exhibit 120, is that how, when you were processing the burn pit, is that exactly how it looked in the way it was sitting in the pile when it was actually taken from there?
That's correct.
And then at some point you then took that and it was, you were able to analyze that and then submit it to the GBI as evidence in this case?
That's correct.
Just have one moment. Did you only find the remains of one person?
That's correct.
Did you find any other bullets or things like that in the burn pile?
I did not.
Did you find any parts to a gun or anything like that?
I did not.
Did you find any metal outside of that, though? Just other things in the pile that did not burn that was metal?
I believe so.
Did you find any ropes or tow straps or anything else in the fire?
Not to my knowledge.
I have nothing else, Your Honor.
Good afternoon, Dr. Gooding. My name is Michael Ray. We met outside previously, right?
That's correct.
And I have a good bit of questions for you, but not too terribly many. First off, I want to know, how do you become the state forensic anthropologist? Like, who gives you that job?
The chief medical examiner at the Georgia Bureau of Investigation.
Okay. So are you actually, because being a college professor, I think you said you're an associate professor?
That's correct.
That's where I graduated from. So that makes you're a state employee, correct?
Yes, that's correct.
All right. Now, are you serving, do you have basically just two state functions? One associate professor, two the state forensic anthropologist?
Correct.
All right. In this case, because I know you're testifying as an expert, a lot of times experts are paid. Are you compensated by the state additionally above your state salary for testifying today?
That's correct.
Okay. Were you compensated by the sheriff's office for coming out, ruining, your after the 4th and coming out and dealing with this case? Did they have to compensate you as well?
No, they did not.
They did not?
Not to my knowledge.
Just your testimony here today?
No, the analysis of the remains.
Okay, so let's back up. Let me ask better questions. How about that? So, I'm assuming as the forensic anthropologist for the state, you get some type of small salary, or some type of salary.
It's not a salary, it's a contract basis, so it's just an invoice per case.
Okay, invoice per case. All right, so basically, is it like an hourly rate?
It's based on a type of request. In this case, it was a trauma analysis, so there would have been a fee for trauma analysis.
Okay, so what would you classify what you did here? Because you did a lot more here, you know, getting the bones out of the burn pile, doing the trauma analysis, and all that. So what would you classify what you did here?
A recovery and an analysis.
Okay, what were you paid for the recovery and the analysis, if you recall?
I believe at that time, I think $100 for the analysis and maybe $250 or $280 for the recovery.
Okay, that's in total.
Well, that would be maybe $380 in total.
Okay, that's what I meant. That's
Yes.
not like your hourly rate. That's the total what you
Yes,
received.
yes.
Okay. On top of that, your state salary with being a associate professor.
Correct.
I'm gonna slide over. There's a sticker here that says "Don't stand here." So just move over here. Okay. All right. So first off, just so there's no confusion, because we had Dr. Atkinson testifying yesterday. You're not a forensic pathologist, correct?
That is correct.
All right. And the difference, partly in that, is a forensic pathologist is a medical doctor.
That's correct.
You are not a medical doctor.
Correct.
You are not able to certify cause or manner of death.
That is correct.
Okay. Now, I'm trying to figure out a good place. Well, we'll just start with your report. In your report that Mr. Fogus was going over with you, you had stated perimortem trauma.
That's correct.
All right, perimortem trauma being before or just after death.
Perimortem trauma is at or around the time of death.
Okay, at or around. Are you familiar with hemorrhaging?
Yes.
Okay, because I asked Dr. Atkinson yesterday if he could prove to a medical certainty whether or not Gary was alive or dead when he was shot, and he said he could not. So my question to you is, how can you use the term perimortem trauma just before or just after death when you can't prove to a medical certainty he was even alive?
That's why it's at or around the time of death, so that could be a pretty wide scale.
No, I mean, I wouldn't say around the time of death. Somebody's been laying there 2 or 3 days, right? You couldn't tell the difference from your examination, right? In a situation like this where their body's been burned.
In this situation, I would still classify that as perimortem trauma.
Okay.
Because the projectile was on the gut side of the bones.
Okay. So if it was on the gut side of the bones, what internal organs did the bullet impact?
That I cannot testify to.
Okay. So you can actually say that it went into the body cavity.
That's incorrect.
That's incorrect?
I can say that it went into the body cavity.
Okay. Then, yet again, what did it hit?
That I cannot testify to.
Okay. But your testimony here is that your opinion that it's inside the body cavity.
That's correct.
Okay. And the bullet went in front to back.
That's correct.
Okay. So if I got shot right here, and actually let me show you number 11 and ask you this way. You actually don't know where that bullet is in 11, correct?
It's in that range of brackets.
Yeah, but I'm asking, I want to know specifically, where's that bullet? You don't know.
That's correct.
Okay. So, but it's your testimony, even though you don't know where it is, it's your opinion that it is on the gut side of the rib.
That's correct.
Okay. But yet again, you can't tell me anything that it hit.
That's correct.
Objection, asked and answered.
I'll move on, Judge. Now, generally, as an anthropologist, you would deal typically with bones, correct? And not soft tissue?
That's correct.
I hate not having it printed out. I'm sorry. You also stated in your report that you thought it was anterior to posterior. That would mean front to back, right?
That's correct.
I mean, so it's your opinion that if Gary was shot, that whoever shot him was standing in front of him? Or a bullet had to come from his front, right?
I would agree with the second version of your statement.
Okay. Now, I want to talk about what you know about. Did you say my name? No. Now, as an anthropologist, do you typically see gunshot wounds in your cases?
Can you repeat the last word you said?
I said gunshot wound. As an anthropologist, like how often have you encountered gunshot wounds in your cases?
Oh, maybe 40 to 50% of the cases.
Okay. Well, how many cases have you worked? Because there's so few of y'all. So how many did you work this year?
I don't know. I know the total is over 160.
Since when?
2014.
Okay, so in 10 years you've done 160, so that's 6 a year?
That sounds, I think our math is adding up.
Okay, so, and then you said about half of those have gunshots? So
Yes.
Seeing 3 a year?
Sure.
Okay, and are those bullets, are they in bone or you're finding them around skeletal remains?
Both. I've seen both.
Okay. Now, you would agree, based on your job, because you talk to the medical examiner a lot, right?
I do not.
Okay. Well, I'll just go ahead and jump in. Do you know that Dr. Atkinson copy and pasted your version of gathering the remains into his autopsy report?
Yes.
Verbatim?
Yes.
Okay. You would also agree with me that Dr. Atkinson never went to Purcell Lane?
I don't know that.
Okay. Did you see him there?
No, not while I was
Okay.
there.
Did you see him taking any of the photographs?
Not while I was there.
Okay. Well, we'll come back to that in just a minute. All right. So, what type, as an anthropologist, expertise do you have in gunshot wounds?
To bone, quite a high level of expertise.
Okay. So, but you didn't see any of that here in this case. At least I can't find it in your report. Like any damage to bone from a bullet.
That's correct.
Okay. So we got no damage to bone from a bullet. You put the skull back together. There's no damage to that. Right.
That's
Except
correct.
for thermal damage.
That's correct.
And when I say there's no damage, universally there is thermal damage. Okay.
That's correct.
All right. So how about mapping trajectory of wounds? You got any skill and expertise in that?
When it relates to bone, yes.
Okay. And we already talked about that. Now, you don't have any entrance wound to examine, correct?
Not in bone.
Okay. Well, I mean, in this case, you didn't find any type of entrance wound. You just found a bullet lodged in soft tissue.
That's correct.
Okay. Now, let me ask you too before I forget. Who, because I've asked everybody, who found the bullet?
To my recollection, it was me, but there were a good number of people peering over my work.
Okay. While you were working around this time that you find the bullet, who's there with you?
I can't give you a full inventory.
I'll name you some people, and you tell me if you remember they were there. That'd be easy. Was Sally Sims there?
She was on scene.
Okay. But you don't remember she was actually in the burn pile with you?
I can't recall who would have been in the pile. At times, it would have been only me.
Okay. Do you recall handing the rib and the bullet to Sally Sims?
Couldn't recall who I would have handed it directly off to.
How about Officer Shaw? Do you recall him helping you at the burn pile?
He was present at the scene.
But you don't recall him helping?
I don't recall in
Okay.
what.
That's fine. That's fine. What about Detective Westbrook?
I don't recall.
Okay. And because I know Mr. Focus had asked you, but yeah, you had an intern with you there too.
Okay.
I don't remember their name either.
Apologies
It's not
to the
important.
intern.
I'm assuming they were a good intern. It's just been 6 years. Okay. I want to do a little comparison between your report and Dr. Atkinson's report, not verbatim comparison. So you had stated that, in your opinion, that the trajectory was front to back, and so are you aware that in the autopsy, Dr. Atkinson has said that he was unable to assess any type of bullet path?
I wasn't.
Did you know that?
After reading his report.
Okay, so you found that out. You did read his report. You read Atkinson's autopsy?
I have since this.
Prior to testifying here today, you went and read it?
That's correct.
Okay, yeah.
I was provided with it.
And before he actually wrote his autopsy, you sent him a copy of your report?
I would assume so.
Okay.
Given that it's copied and pasted.
Pasted into it, yeah. Do you always do that? Send a copy of your findings to the medical examiner?
I actually send them to the director of medical operations, and she distributes them to the medical examiner that requested.
Okay. What's the logic in that? Because shouldn't a medical, and I know you're not a medical examiner, but I'll ask anyway. Shouldn't their opinion and analysis be separate and apart from what your findings are?
Objection relevant.
Oh, well.
No. I think we're a collaborative medical team employed with the same office.
Okay, that's fair.
I think it's reasonable to, if the medical examiner requests anthropological analysis, I think it's reasonable that they rely on those findings.
Okay. Now, let me. You know, when you try to organize everything so good, there it is. So in your report, I get ahead of myself when I just start talking, and then I got to scroll through and figure out where I am. So you stated like front to back, but the autopsy actually found here on, let me get to it, past it. You stated that it was front to back, right? That's what your report found.
That's correct.
Okay. Now, but in the autopsy, they found that couldn't assess for an entrance wound. So if you can't assess for an entrance wound, how can you say it's front to back?
Based on the location of the projectile in the remains.
Okay. But you are aware that also bullets do have the ability that if they hit some type of object, they do have the ability to tumble.
That's correct.
Okay. All right. So got some contradiction there. The autopsy also says that they're unable to assess a direction of a wound path, correct?
Is that D?
Yeah, section D.
I'm reading that, yes.
Okay. Okay. And yet again, you found no other evidence of any other, well, actually, you didn't find any other evidence or any damage to any other bone, correct? You found technically no evidence of any damage to bone, other than thermal damage.
That's correct.
Okay. So no other bone evidence of injury from a bullet.
That's correct.
Okay. Or any other blunt force object.
That's correct.
Okay. All right. You also you didn't offer any opinion in your report appropriately as to manner or cause of death.
That's correct.
Okay. Now, moving on to the more fun stuff. I want to talk. I really like your grid, by the way. And so this is Gooding 1. And I also want to pull up Gooding 3, just so I can get an idea here. Okay, can you see both those, Gooding 1 and Gooding 3? Oh, no, you didn't. Can you see both those, ma'am?
I can.
Okay. Okay, that looks fine. All right, so here's just a couple questions based on this, okay? You've got up here on number 1, this is quadrant A, correct?
That's correct.
So, and then you've got the cranium where the skull was found. It's kind of on the line between A and, well, the line between A and B.
That's correct.
Because it's right here. So, going over to Gooding 3, that puts it somewhere around, based on this, somewhere in this area here.
I would drop your cursor down and to the left a little bit.
You tell me when to stop.
Maybe over to the left just a little bit, right about there.
Okay.
Yeah.
All right. See? All right, so that's the skull. Also, what are the flags?
As I stated previously, the flags are part of the visual search when we identify areas of interest.
Okay, so it's like this flag may be like, hey, there may be something here, check it out.
That's correct.
Then I'm assuming when you checked it out and removed whatever was there, if it was evidentiary, then you remove the flag? Like showing that that area had been searched?
Yes, but that wouldn't have been the order of operations.
Okay. All right, so we get so we got the skull around here, and then the next thing, if we go down a little bit, the pelvis is, let's say in here. Is that a fair assessment based on your diagram?
Yes.
Okay, but then we've got, I'm assuming rib here, the very bottom. That's the rib with the bullet and the soft tissue.
I don't know that to be true.
Okay. Well, where was
I'd have to go back and look at the inventory. Looks like the rib with the bullet was found in Unit A, evidence bag 1.
Okay. But from your diagram you did here, we don't know where the bullet in that rib was found. We just know it's quadrant A.
We do know where it was found in the rib.
In the what?
In the rib.
No. Okay, no, where at in the pile, in quadrant A? We don't have any documentation of that, right?
That's correct.
Okay, so we know it's quadrant A here, or I'm assuming here, because this is the burned area. But we don't know exactly where.
Correct.
Okay, so we've got a rib down here. Let's see, femur and tibia. That's the front part of the leg and back part of the leg?
It's the top and the bottom part of the leg.
Oh, okay. Which one's which?
The femur is the thigh bone, and the tibia is the shin bone.
Gotcha. Okay. So those are the two leg bones. And then we also have another femur and the pelvis, right?
That's correct.
Okay. All right. So any kind of issues as to why is there a lone rib bone down here at the very, very bottom? Any explanation on that?
My responsibility is mapping.
Oh, I'm not saying this is your fault. I'm just wondering if you know how it got there.
I wasn't concerned about that.
Okay, so I mean, because it would seem anatomically out of place, right? A rib below the pelvis.
Sure.
Okay.
Sure.
That's my whole point, right there. So nothing really to do with you. Okay. Already did that. That number. I'm just going to pull up your report because Mr. Fogus showed you something. I don't remember what it was. Okay, that's the part of the rib where you're saying it's on the gut side, correct?
That's correct.
Okay. But yet again, going back to your anatomical drawing, you can't say where that bullet is in those ribs.
That's correct.
Okay. No further questions, Judge.
There you go.
All right. You can sit down. Thank you, ma'am. You'll have a short witness or?